ಕೊಡ್ಬೇಕು. ನೀವು ವಕಾಲತ್ ಹಾಕಿ ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್ ತಗೊಳ್ಳಿ. ಆಗ್ಮತ್ ಮೆಮೊ ಮೇಲೆ ಏನ್ ಆರ್ಡರ್ ಬೇಕಾದ್ರೆ ಮೆಮೊ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ ಆನ್ R11 is taken on record ಅಷ್ಟೇ. ನಾನ್ ಫೈಲಿಂಗ್ a print list of acknowledgement for having paid the amount towards preparation of paper book.
ಪೇಪರ್ ಬುಕ್ ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಿ
ಪ್ರಿಂಟ್ ಲಿಸ್ಟ್ ಏನೋ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಏನೋ ಹೇಳ್ತಾರೆ ನೋಡ್ರಿ.
ಪೇಪರ್ ಬುಕ್ ಫೈಲ್
ಆಯ್ತು ಹಾಕಿದಿರಾ?
ನಾವೇ ಹಾಕಿದ್ವಿ.
ಅದ್ರಲ್ಲೇನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರಬೇಕು.
ಅಲ್ಲ ಅದ್ರಲ್ಲ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ is directed to comply with the office objection regarding paper book. Issue notice against ಯಾರ್ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು?
Respondent number 4 to 6, 4, 6 to 10 and 12 to 13.
4, 6 to 10 and
12, 13.
12 and 13. ಹೌದಾ? The appellant counsel is directed to pay process forthwith. Returnable by 21/7.
Also 11 also ಮೇಲ 11 ಗೂ ಕೊಟ್ಬಿಟ್ಟು process.
ಇಲ್ಲ
11 ಗೆ ಬಂದವರಲ್ರಿ ಕೌನ್ಸಿಲ್.
11 ಬಂದವರು. 11 ಆಲ್ರೆಡಿ ಅಂದ್ರೆ.
ಸಚಿನ್ BS
42.
ರಿಕಾಲಿಂಗ್ ಹೇಳ್ರಿ ಏನದು?
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು? 21, 23 ನಲ್ಲಿ ಡಿಸ್ಮಿಸಲ್ ಆಗಿದೆ.
ಡಿಸ್ಮಿಸಲ್ ಆಗಿದೆ. ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೇವೆ.
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ರಾ?
ಕಟ್ಟಿದ್ದೇವೆ.
ಯಾವಾಗ? ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಕೊಡಿ. ಯಾವತ್ತದು ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ನೋಡಿ. This appeal was dismissed and this court having considered the application with order dated 9/6/25 and also the illalla madam ಇಲ್ಲಿ paid the deficit court fee ಅಂತಿದೆ ಅಷ್ಟೇ. verify and report ಅಂತಿದೆ ಅಲ್ಲ. ಅದಕ್ಕೆ ಕೊಡಿ. ಯಾವ್ದು ಕೊಡ್ತೀರಿ ಬೇರೆ? with order dated change ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. 2/6/25 pending consideration of IAS week's time was granted and subsequently on 9/6/25 made the submission that court fee of rupees 79,300 is paid and directed to verify and report. And in view of this same and registry is verified and submitted that office objections is complied and hence IAS are allowed by condoning the delay and order dated 29/8/23 is recalled. List this matter for admission on 3/7.
43.
59/23 Jayaprakash Reddy. Yes madam ಹೇಳಿ.
We have paid all the
recalling the order 59/23 ಎಷ್ಟು ಟೈಮ್ ಬಂತು ಕೋರ್ಟ್ ಮುಂದೆ? ಫಸ್ಟ್ ಟೈಮ್ ರಿಕಾಲ್. ಡಿಲೇ ಇಲ್ವಾ?
ಡಿಲೇ ಏನಿಲ್ಲ ಸರ್.
ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದೀವಿ.
Complied with office.
This court wide order dated 2/6/25 pending consideration of IA number 1/23 weeks time was granted to comply with office objection and thereafter matter listed on 9/6/25 and office has raised other objections and hence another 1 week time granted and now all the other office objections are also complied and in view of the same dismissal order dated 15/9/23 is recalled. List the matter for admission on 3/7.
44.
ರಿಪೇರಿ ಕೆಲಸ. ಬಿ ಶರತ್ ಕುಮಾರ್ early hearing filed by the advocate for respondent. ಅಲೋ ಮಾಡಬಹುದಾ?
ಅಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಸ್ವಲ್ಪ ಡಿಫೆಕ್ಟ್ಸ್ ಇದೆ. 2 weeks ಟೈಮ್ ಇದೆ.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಅದನ್ನ
ಪ್ಲೀಸ್
ತಗೊಳ್ಳಿ. Appellant counsel is given 2 weeks time to comply with office objections on paper book. IA 2/24 will be considered along with main appeal.
ಪ್ಲೀಸ್.
IA 3/24 filed by the counsel for respondent ಏನಂತ್ರಿ ಅದು?
ಅದೇ ಅಡಿಷನಲ್
IA 3 ಏನು ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Heard on IA number 1/25 for early hearing and for the reasons stated in the accompanying application of Probate IA number 1/25 is allowed. IA 3 ಏನು? counsel for respondent PB ರಾಜು ನೀವೇ ಹೇಳ್ಬೇಕ್ರಿ. ನಿಮ್ದೇ ಅಪ್ಲಿಕೇಶನ್ ಅದು.
ಫೈಲ್ ಕೊಲಿಗ್ ಹತ್ರ ಇದೆ ಬರ್. ಕೊಲಿಗ್ ಬಂದಿದೆ.
ಸ್ಟೇನಾ?
Vacating interim order.
ಅದು ಒಟ್ಟಿಗೆ ಹಾಕಿಬಿಟ್ಟಿದ್ರು. ಎರಡು ಒಟ್ಟಿಗೆ ಹಾಕಿದ್ರು. ಈಗ ಸೆಪರೇಟ್ ಬೇರೆ ಬೇರೆ
ಹಾಕಿದ್ರು. ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್ ಯಾವಾಗ ಮಾಡ್ತೀರಿ? 3/7 ಆಗುತ್ತೆ ಇಬ್ರಿಗೂ?
ಆಯ್ತು.
ಸ್ವಲ್ಪ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ವೀಕ್
ಆಯ್ತು ಕೊಡಿ. ಸೆಕೆಂಡ್ ವೀಕ್ 8/7
ಪ್ಲೀಸ್.
ಅಷ್ಟೊಳಗೆ ನೀವೇನ್ ಪೇಪರ್ ಬುಕ್ ಎಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡ್ಕೊಳ್ಳಿ.
ಪ್ಲೀಸ್
ನೆಕ್ಸ್ಟ್
45.
Somarjuna VM. Rakshit KS. Wakalat not filed ante. Recalling the order dated 10/16/10. Memo for undertaking filed by counsel Rakshit KS. Ilva? Somarjuna ilva kodi en undertaking en nodi. Registry is directed to show the name of the counsel Sri Rakshit since the said counsel has filed application for recalling the order and in the cause list earlier advocate name is shown. So in spite of this court directed to file wakalat. But ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ? ಮತ್ತೆ ಹೆಸರು ತೋರಿಸಿದ್ರು ಬರೋದಿಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಅದು ಬರಲ್ಲ ಅವರಿಗೆ. ಸೋಮಾರ್ಜುನ ಅನ್ನೋದು ಬರುತ್ತೇನೆ. ಸೋಮಾರ್ಜನ ಅಂತ ಬ್ಲಾಕ್ ಕಲ್ ಮಾಡಿದಾರಲ್ಲ ಅದು ಬರುತ್ತೆ. ತೊಗೊಳ್ಳಿ ಏನಾಯ್ತು ಹೇಳಿ. In spite of this court directed to show the name of the counsel Sri Rakshit, the name of Somarjuna is also shown in block letters and hence registry is directed to delete the name of Somarjuna VM. And if counsel who filed an application IA number 1 of 24 fails to file wakalat, IA will be dismissed in the next date of hearing. List this matter on
27/6. 46. Sachin BS.
Sachin BS. 47 days in filing appeal. ಹೇಳ್ರಿ ಏನು ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್
Divergent madam.
ಡೈವರ್ಜೆಂಟ್ ಕೊಡಿ ಮೇಡಮ್ ನೋಡೋಣ.
Suit for partition.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಏನಾಯ್ತು?
Partition suit ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಮ್ ಫೇವರ್
ಟೈಟಲ್ ಫಾರ್ ಹಾಫ್ ಶೇರ್ ಅಂತ ಆಯ್ತು.
ಹಾಫ್ ಶೇರ್ ಆಯ್ತು. ನಂಬರ್ 2 ಗೆ ಅಪರೆಂಟ್ ಅಲ್ಲಿ
ರಿವರ್ಸ್ ಮಾಡಿದಾರಾ?
ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು. ಅದರ್ ಸೈಡ್ ಆರ್ ಅಪಿಯರ್ ಆಗಿಲ್ಲಲ್ಲ? Issue notice on IA number 1 of 24 and also on main against the respondents. In the meanwhile, registry is directed to get the records of trial court and appellate court. List this matter on 21/7.
47. MB Chandrachud.
Appointment of court commissioner along with statement of objections filed by
I am for
R1.
the respondent concurrent findings. Appeal is not admitted. Similar application filed by them that was allowed, commissioner was appointed, he has inspected. He filed report, he was examined. Again, same application was filed in the same court that was dismissed. Again, in the appeal also same application was filed. Now this is third application.
ಏನ್ರಿ ಇದು?
At their stage only commissioner was appointed.
Appellate court
He filed
ಇಲ್ಲಿ
report,
appoint ಆಗಿದ್ದು ಒರಿಜಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲ?
original court ಅಲ್ಲಿ.
ಒರಿಜಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು, ಕಮಿಷನರ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು, ಅವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ದೇರ್ ಆಫ್ಟರ್ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅದು ಸರಿ ಇಲ್ಲ ಅಂತ. ಸೊ ಆ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಅಪೀಲ್ ಅಲ್ಲೂ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಹೇಗೇನ್ ಥರ್ಡ್ ಟೈಮ್.
ಏನ್ರಿ ಇದು?
ಒರಿಜಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ
ಆಯ್ತು ಅಯ್ಯ ಹಾಕಿದ್ರಿ.
ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಹಾಕಿದ್ರ ಇಲ್ಲ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೆ,
ಅದು ರಿಜೆಕ್ಟೆಡ್.
ರಿಪೋರ್ಟ್
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ರಿಜೆಕ್ಟೆಡ್.
ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರು, ರಿಪೋರ್ಟ್ ಸರಿ ಇಲ್ಲ ಅಂತೇಳಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅರ್ಜಿ ಹಾಕಿದೆ. ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು, ಐ ಡಿಡ್ ನಾಟ್ ಪರ್ಸ್ಯೂಡ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಹೇಳಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. ದಟ್ ಈಸ್ ರಾಂಗ್.
ಬಟ್ ಅವ್ರ ಪ್ರಕಾರ ನೀವು ಫಸ್ಟ್ ಒಂದು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆಯ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಅವ್ರ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು. ಆಮೇಲೆ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಮಾಡಿದ್ರೆ
ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ ಅಲ್ಲಿ ಅಂತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ.
ಹಾಕ್ಲಿಲ್ಲ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇಲ್ಲಿದೆ.
ಕೊಡ್ರಿ ಅದೇನು ನೋಡಿ.
IA 22 and 22 ಅದನ್ನು ಪರ್ಸ್ಯೂ ಮಾಡಿಲ್ಲ, ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಆರ್ಡರ್ ಕಾಪಿ IA 2 ಅಲ್ಲೇ ಇದೆ.
ಮತ್ತೆ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಇಟ್ ಅಸೈನ್ಡ್
they have not challenged.
ಎಲ್ಲಿ ಹಾಕಿದ್ರು? ಒಂದ್ ನಿಮಿಷ.
IA 22 ಹಾಕಿದ್ರಿ
66 ಅಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ ಇದೆ ಅಲ್ಲ, ಕಾಪಿ ಕೊಡ್ತಾ ಇದಾರೆ.
ಎಲ್ಲಿ ಹಾಕಿದ್ರು ಅದನ್ನ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಅಲ್ಲೇ
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಅದರ್ ರೀಕಾಲಿಂಗ್ IA 23 ಹಾಕಿದ್ರು, ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಅಂಡ್ ಅಪಾಯಿಂಟ್ ಎ ನ್ಯೂ ಕಮಿಷನರ್ ಅಂತ ಅಲ್ಲಿ ಹಾಕಿದಿರಿ. ಅರ್ಲಿಯರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಏನಿದೆ ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಫ್ರೆಶ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹಾಕಿದಿರಿ ನೀವು.
IA ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
IA ನಂಬರ್ 22
ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. IA 23 ರೀಕಾಲಿಂಗ್ ಹಾಕಿದ್ರು, ಎರಡು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಆರ್ಡರ್ ಕಾಪಿ ಅಲ್ಲೇ ಇದೆ, ಫಸ್ಟ್ ಅಲ್ಲೇ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅವರು. 22 and
ಇಲ್ಲ,
23.
ಈ ಐಎ ಮೆರಿಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಆಯ್ತಾ ಇಲ್ಲ?
ಯಾವ್ದು?
ಅವ್ರೊಂದು ಐಎ ಹಾಕಿದ್ರಲ್ಲ, ಐಎ ನಂಬರ್ 22.
ಅದನ್ನ ಅವ್ರು ಪರ್ಸ್ಯೂನೇ ಮಾಡ್ಲಿಲ್ಲ.
ಹಾ.
ಸೊ ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ
ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲೇ ಇದೆ. ಐಎ 22 and 20 ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರು ಆ ರೀಕಾಲ್ ಮಾಡೋಕೆ.
You are not answering to my question. This IA number 22 was dismissed ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ ದಾಖಲೆ ಅಂತ ಕೇಳಿದೆ.
IA number 22 they have not pressed and as such it was dismissed.
ಅದರ ಆರ್ಡರ್ ಇದೆಯಾ ಅಂತ
ಅದೇ ಫಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಎಲ್ಲಿದೆ? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ, ಫುಲ್ ಆರ್ಡರ್ ಇದೆ ಅದು. IA 22 and 23 ಅಂತ ಥರ್ಡ್ ಪೇಜ್ ಫೋರ್ತ್ ಪೇಜ್ ಇಂದನು. ಸೊ IA 22 ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದಕ್ಕೆ ಇನ್ನೊಂದು IA 23 ಹಾಕೊಂಡ್ರು ಟು ರೀಕಾಲ್ ದಟ್ ಆರ್ಡರ್. ಎರಡು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಇಲ್ಲ ಇದೆ IA 22 23 ಮೇಲೆ.
ಒಂದ್ ನಿಮಿಷ, ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾನು ಇರ್ಲಿಲ್ಲ. ಐ ವಿಲ್ ಜಸ್ಟ್ ಲುಕ್ ಇನ್ ಟು ಇಟ್.
Counsel for the respondent submits that this is a third application for appointment of commissioner, and counsel would submit that similar application was filed before the trial court and the same was rejected, and also counsel submits that in appeal also filed and the same was also rejected, and third time the present application is filed, and hence appellant counsel is directed to verify and submit. List this matter on ಯಾವಾಗ
ನೋಡಿ ಹೇಳ್ತೀನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ.
37 ಹಾ,
ಹಂಗೇನಾರ ಇದ್ರೆ ಐ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸ್ ದಿ ಅಪ್ಲಿಕೇಶನ್.
37 ಆಯ್ತು.
Admission matter 48.
ಒಂದು ಅಡ್ಮಿಷನ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಲಿ, ಇಫ್ ದಟ್ ವುಡ್ ಬಿ ದಿ ಕೇಸ್.
ಅಡ್ಮಿಷನ್ ಗೆ
press
ಪೋಸ್ಟ್
the
ಆಗಲಿ,
application
ಕನ್ಕರೆಂಟ್
ಅಂತ.
ಫೈಂಡಿಂಗ್ಸ್ ಅಡ್ಮಿಷನ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಲಿ.
ಆಯ್ತು.
ಅಡ್ಮಿಷನ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಲಿ, ಐ ವಿಲ್ ನಾಟ್
List
ಪ್ರೆಸ್
this
ದಿ
matter for
ಅಪ್ಲಿಕೇಶನ್.
admission on 37 ಅಂತ ಹಾಕ್ಬೇಕು.
I will say,
along with IA ಅಂತ ಇಟ್ಟಿದೆ.
I will not say that something more. ಅಡ್ಮಿಷನ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಲಿ irrespect of the application.
Yes.
48 current
48
property.
MSA.
P. Raghavan.
Appearing for this respond 2 to 9 million in MSA.
2 to 9.
In MSA.
Ah.
And 7 to 15 RSA.
2 to 9 are treated as LRs of deceased now.
R1 million.
R1 LRs.
Yes, ma'am.
ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Lord, this is miscellaneous second appeal.
You are the only contesting advocate. ಮತ್ತೆ R10 to 13 ಇದಾರಲ್ಲ ಅವರು.
R10 to 13.
ಹಾ.
I appear. Lord, it is a connected matter.
ಹಾ.
RSA, I have filed an appeal.
ಹಾ.
RSA 836 of 2015. It is one of the brothers. He appears for one of the brothers. The other person.
ಬಟ್ ನೀವು ಇದೀರಿ ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ. ಇನ್ನೊಬ್ರು ಯಾರ ಕೌನ್ಸಿಲ್ ಇದಾರಲ್ಲ. PR and PR associates for R.
I am R2 to 9 million.
3 to 9 also you appears.
Yes, madam. In MSA.
ಬೋತ್ ಸೈಡ್ಸ್ ಇದಿರಲ್ಲ ಎರಡರಲ್ಲೂ. ಆಯ್ತು ಹೇಳಿ, ಏನು ಮ್ಯಾಟ್ರ್ ಏನು ಹೇಳಿ.
Lord, the first appeal is by the defendants 2 to 5.
D 2 to 5.
2 to 5.
ಹಾ.
The connected appeal, regular second appeal is by the LRs of the first plaintiff. LRs of the plaintiff. LRs of the plaintiff.
Plaintiff LRs, RSA.
Suit is for partition and separate possession of 1/3 share in all the suit scheduled properties. The defendants 1 to 5 had filed written statement, a counterclaim, seeking a separate decree in their favor for partition and separate possession of 1/3 share in all the suit scheduled properties.
ಅಂದ್ರೆ ಅಲ್ಲಿಗೆ ಇಶ್ಯೂ ಇಸ್ ಕ್ಲೈಮಿಂಗ್ ಆಲ್ ಆಫ್ ದೆಮ್ 1/3 ಶೇರ್.
Yes, ma'am.
ಹೌದಾ?
Yes, ma'am.
ಆಯ್ತು.
Defendant 6 to 11, they filed a separate written statement opposing the claim of the plaintiff. So far as counterclaim is concerned, they had not filed any written
No,
statement.
they are not contested regarding counterclaim is concerned.
Counterclaim, they had not
Only
filed.
they disputed the plaintiff's
Yes,
claim.
my lord. They concentrated only in opposing the claim of the plaintiff. The trial court, Lord, dismissed the case, they dismissed the suit, holding that the plaintiff was given an adoption to another family and he is not entitled for a share. And passed a decree that the defendants 1 to 5 are entitled for 1/4 share, half share.
Counterclaim was allowed.
A counterclaim was allowed. And passed a decree holding that the defendants 1 to 5 are entitled for half share. And the remaining defendants, 6 to 50, 6 to 15 are entitled for the remaining half share.
Remaining half share.
But so far as relationship is concerned, I will.
Then who challenged this decree?
Lord,
Plaintiffs or defendants?
Lord, decree was challenged by the defendants 5 to 6. D6 to D15.
6 to
Defendants
15.
D6 to D15.
Ah.
Question the decree granting.
There are two regular appeals, sir.
Yes, Lord.
ಮೂರು
55 of
two ಅಲ್ಲ.
2011.
55, 60, 55.
Yes, 55 of 2011 was preferred by the defendants 6 to 15. RA 60 of 2011 was preferred by the LRs of the plaintiff.
LRs of the plaintiff.
Yes, both the appeals were clubbed together and common judgment was passed. But RA 60 of 2011 was dismissed and RA 55 of 2011 was allowed for a limited purpose of proving the correctness of the survey numbers and boundaries mentioned in the suit schedule properties. Lord, the reason is, Lord, 14 items of the suit schedule properties were inomalants.
All are inomalants.
Not all, 14 items. 14 items.
How many items total?
Totally 26.
26.
26, including
inomalant.
Inomalants. An application was filed by the Karta for grant of occupancy right before the Special Deputy Commissioner for abolition of inums. But occupancy right was granted in favor of Narasappa, Venkatanarayana, who was the Karta of the family. While granting the occupancy right, the wife of the second branch, Lord Venkatanarasappa, Lakshmamma, and his two minor sons were also there. Therefore, occupancy right was granted jointly in favor of Venkatanarayana and also Lakshmamma and his minor sons in the year 1960.
That means grant in favor of the family.
Yes. Therefore, Lord, considering that, trial court allowed my counterclaim and granted the decree. First appellate court, Lord, holds that the survey numbers mentioned in the order passed by the Special Deputy Commissioner are not tallying with the survey numbers mentioned in the plaint. Lord, there is no dispute regarding that. Identity is not disputed, boundaries are not disputed, correctness of the survey numbers are not disputed, and I have the plaintiff himself was the retired revenue inspector, and he himself had produced the ADR records, RTC, mutation, patta, everything. So all those things relate to the suit schedule properties. At the time of granting occupancy right in the year 1960, old survey numbers were mentioned. Later on, Lord, resurvey was held and new survey numbers were given. These old survey numbers and new survey numbers are given in exhibit P25 that is available in the record. Even then, Lord, the first appellate court has remanded the matter only to prove the correctness of the survey numbers and boundaries. That is so far as
exhibit
25. Exhibit D25.
Records ಬಂದಿಲ್ಲ 2015 matter. Records ಬೇಕಾಗುತ್ತಲ್ಲ ಹಾಗಾದ್ರೆ.
ಬೇಕಾಗುತ್ತೆ.
ಯಾವುದು ಇಲ್ವಾ? RSA is against?
Not RSA is by the plaintiff.
That is concurrent finding na challenge ಮಾಡ್ರದಾ?
Yes. Yes.
Adoption.
They say that
you are disputing the adoption.
I am disputing the adoption. I am saying that only for the purpose of obfuscation, that is conducting the death ceremony, I was adopted. Not regular adoption did not take place at all. There is no evidence at all produced by the other side.
Adoption ಗೆ ಸಂಬಂಧಪಟ್ಟ ಮೆಟೀರಿಯಲ್ ಇಲ್ವಾ?
ಏನಿಲ್ಲ. There is nothing produced.
What do you say with regard to the adoption?
So far as adoption is, I am supporting the plaintiff, my lord.
You are supporting.
Therefore, I am claiming only 1/3 share. He was also living with the joint family.
Hmm.
And my lord, he was taken in adoption by Narasimha Murthy.
So, after the adoption, whether he went to the adopted family or not?
They are
Lord,
not
No,
joint.
joint
he
family.
was in the adopted family, my lord. Till the age of 73, he was not challenging that. At the time of attaining majority,
But
at the time of
all are in the only
the-
one family.
till the age of,
According to him, that all are living together.
no, my lord, they are not living together. He was in his adoptive father place.
Registry is directed to get the records of original suit in OS number 127 of 2002 and also the regular appeal number 55 of 2011 and 60 of 2011. Yavuru?
From KGF.
KGF.
Yes,
List this matter on. Huh? 14/7.
Lord, interim order granted earlier
ಏನದು entry ಮಾಡ್ರು?
only to stay alienating or cutting and removing the trees.
ರಿಮ್ಯಾಂಡ್ ಆರ್ಡರ್ ಏನಾಯ್ತು ಅಲ್ಲಿ ರಿಮ್ಯಾಂಡ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮುಂದೆ ಬರಿತಾ ಇದೆಯಾ ಆಯ್ತು ಇಲ್ವಾ?
ಇಲ್ಲ.
ಇಲ್ಲ ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಹೌದು, ಅದೇ ಸ್ಟೇ ಆಗಿದೆ.
ಸ್ಟೇ ಆಗಿದೆ.
ಸ್ಟೇ ಆಗಿದೆ.
ಆಮೇಲೆ ಮತ್ತೆ ಇನ್ನೇನ್ ಆರ್ಡರ್ ಇದೆ?
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾಟ್ ಟು ಕಟ್ ಅಂಡ್ ರಿಮೂವ್ ದಿ ಟ್ರೀಸ್ ಅಂತಿತ್ತು. ಅದು ಇಲ್ಲೇನು ಕೊಟ್ಟಿಲ್ಲ, ಬಟ್ ಸ್ಟೇ ಹ್ಯಾಸ್ ಬಿನ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಟು ನಾಟ್ ಟು ಪ್ರೊಸೀಡ್ ಫರ್ದರ್ ಇನ್ ದಿ
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಟ್ರಯಲ್.
ಅದಿರ್ಲಿ ಬಿಡಿ, ರೆಕಾರ್ಡ್ಸ್ ಹೋಗ್ಬರ್ಲಿ.
ದಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೈ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನೋ ಎಷ್ಟು? ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತಲ್ಲ 4-5 ಸರಿ ಬಂದಾಗ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಏನಿದೆ ಅದನ್ನ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು. 14/7.
49.
Appellant was the plaintiff in OS 285 of 2006, which was a suit for declaration and injunction.
ಶೇಷಾದ್ರಿ ಇಲ್ವಾ? ಶೇಷಾದ್ರಿ ಕೌನ್ಸಿಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
Lord, they have not filed wakalat. In fact, I have sent the copies of the amended plaint.
Wakalat not filed.
Amended appeal memo ಅವರಿಗೆ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟಲ್ ಕಳಿಸಿದ್ದೀನಿ. 2 ವಾಪಸ್ ಬಂದಿದೆ, 1 ಬಂದಿಲ್ಲ.
ಒಂದು ರಿಮಾಂಡ್ ಏನು?
On the ground that there is a matter before the land tribunal, hence this request to be stayed. Merely because pendency of a matter before the land tribunal.
That plaintiff is the absolute owner of the suit shall property after the death of his father Gangappa. Defendants are hereby restrained permanent injunction, granting permanent injunction. Appellate court ಅಲ್ಲಿ ಏನು ರಿಮಾಂಡ್ ಏನಕ್ಕೆ?
Remand on the ground that the matter was pending, tenancy issue was pending before a land tribunal. And due to that, this matter is stayed. There must be an issue before the civil court as far as the tenancy is concerned. There was no such issue at all. And now, as of now, all the matters are over and his tenancy application is rejected. This learned judge has remanded the matters with a direction to stay the original suit at page 24, my lord.
ಓನ್ಲಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ರೀ.
ಇಲ್ಲ, page 24, running page 24. Point number 4. At the most, the trial court may stay the further proceedings pending decision of the land tribunal in the said dispute pending before it between the present defendants and the present plaintiff.
Which para you are reading?
Para 26.
26.
Para 26, point number 4. Adar hindindu para
25.
25. No. In view of the above conclusion, this court is not competent to discuss the merits of the rival claims of the parties to the suit. Hence, this court refrains from discussing the merits of the rival claims of the parties to the suit. Suffice it to hold that the findings given by the trial court in its impugned judgment and decree passed by it are one without jurisdiction. Hence, the same needs to be interfered with by this court. In view of the above conclusion, point number 1 is held in the affirmative, 2 and 3 are held in the negative. The only question is, the matter was pending before the land tribunal. The form number 7A was filed by the defendants. And that is now over. Everything is over now. that land, it had reached this, pardon?
As on the date of disposal of the suit, whether the same was pending in the land tribunal?
Disposal of the suit, it was pending.
Pending.
It was pending.
Then how can the trial court can grant the relief of
My lord,
declaration?
there are two or three decisions of our High Court where if there is an issue regarding tenancy raised in this suit, that issue cannot be decided by the civil court.
ಆಯ್ತು ಮತ್ ನಿಮ್ಗೆ ಹೆಂಗೆ?
ಅದ್ರಲ್ಲಿ ಆ ಇಶ್ಯೂನೂ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ. There was no, the matter was over by the time the suit was filed. Ex parte order was passed granting occupancy rights. Thereafter, I got it reopened because I preferred an appeal and got it reopened for the reason that I was not served with the notice, but wrong address was given.
ಆಯ್ತು.
ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ ಟ್ರಿಬ್ಯುನಲ್ ಹೋಯ್ತು, ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ರಿಜೆಕ್ಟ್
ಯಾರ್ದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು?
ಇವ್ರದೇ ಡಿಫೆಂಡೆಂಟ್ಸ್. Forum number 7A was rejected.
ಆಯ್ತು.
Then thereafter they preferred an appeal.
ಹಾ.
ಅದು ರಿಜೆಕ್ಟ್ ಆಗೋಯ್ತು.
ಆಯ್ತು.
ಅದ್ರ ಮೇಲೆ KAT ಗೆ ಬಂದ್ರು, ಅಪೆಲೇಟ್ ಅಥಾರಿಟಿಗೆ. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು, ದ ಲ್ಯಾಂಡ್ ಡಸಂಟ್ ವೆಸ್ಟ್ ವಿತ್ ದ ಸ್ಟೇಟ್ ಅಂತ ಏನೋ ಒಂದು ಫೈಂಡಿಂಗ್ ಕೊಟ್ರು. ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಬಂದ್ರು. ರಿಟ್ ಅಲ್ಲಿ ದೇ ಸೆಡ್ ನೋ, ಒನ್ಸ್ ದೇ ಸೇವ್ ಟೆನೆನ್ಸಿ, the land has to vest with the state, there is no question of vesting, revesting with that person ಅಂತ ಹೇಳಿ reconsider ಅಂತ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಹಾಕಿದ್ರು.
ಮತ್ತೆ ಈಗ ಕನ್ಸಿಡರ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆಗೋಯ್ತು. ಅದ್ರ ಮೇಲೆ ಅಪೆಲೇಟ್ ಅಥಾರಿಟಿ ಮುಂದೆನೂ ಆಗೋಯ್ತು.
ಕೋರ್ಟ್ ನ ರಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಮಾಡಿದ್ಮೇಲೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಮತ್ತೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತು.
ಆಯ್ತು.
ಆಮೇಲೆ ಅಪೆಲೇಟ್ ಅಥಾರಿಟಿಲೂ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತು, ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲೂ ರಿಜೆಕ್ಟ್ ಆಗೋಯ್ತು. ದಟ್ ಇಸ್ ದ ಎಂಡ್ ಆಫ್ ಇಟ್.
Then appellate court why given such finding in area?
At that time ಅಲ್ಲಿ reopen ಆಗಿತ್ತು. ಅವಾಗ ನಾನು ಅಪೀಲ್ ಹಾಕಿದ್ನಲ್ಲ, that was reopened. The issue was not there. There must be an issue, specific issue in the suit to the effect that whether there is a tenancy. ಆ ಇಶ್ಯೂನೇ ಇಲ್ಲ. If your lordship would kindly see in the original suit, what are the issues that are framed? They only say that my application is pending, that's all. They don't contend that they are in possession.
Plaintiff proves that he is the owner of the suit property as per sale deed dated 25/1941.
It is held in the affirmative. Whether there is interference with his possession, affirmative. Whether suit is properly valued, affirmative. Plaintiff is entitled for relief of declaration, affirmative. ಅಷ್ಟೇ ಇರೋದು. No question of tenancy was raised there. And merely because the pendency.
You claimed the right only based on the sale deed?
Yes, 1941. 1941 sale deed to my father. On that basis, I am in possession. 5 acres and odd is the extent. The claim before the land tribunal was to an extent of 3 acres and odd. And that was rejected. Second innings was also.
What is your extent?
5 acres, 20 guntas, sir.
Sale deed only?
Yes.
In respect of the very same land?
Same land.
Tenancy right was
Yes.
claimed?
In respect of the land which I have purchased, tenancy rights was claimed. And there was no tenancy in the agoit. Adu ex parte agi ನಮ್ಮ ಮೇಲೆ ಆರ್ಡರ್ ಆಗೋಯ್ತು ಅದು.
Now it has attained its finality?
Yes, it has final. There is no matters pending now. And the question of remanding it doesn't arise.
But ಈ contesting ಒಬ್ರೇನಾ? ಈ defendants ಗೆ ಅವ್ರ ಒಬ್ರೇನಾ?
ಡಿಫೆಂಡೆಂಟ್ಸ್ ಗೆ ಇಬ್ಬರಿದ್ರು, ಒಬ್ರು ವಕಾಲತ್ ಹಾಕ್ತೀನಿ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡ್ರು. ಅವ್ರು
ನೀವೀಗ ಏನ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ, ಏನ್ ಟೆನೆನ್ಸಿ ರೈಟ್ಸ್ ಕ್ಲೈಮ್ ಮಾಡಿದ್ರು ಅದು ಎಲ್ಲಾ ಕಡೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ, ಅದ್ರ ದಾಖಲೆಗಳನ್ನ ಹಾಕಿದೀರಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದೆ,
ಎಲ್ಲ ಕೊಟ್ಟಿದೆ. Registry is directed to
copies were given. If it is taken return ಏನಾದ್ರು ಆಗಿದ್ರೆ ಬೇಕಾದ್ರೆ ನಮ್ಮ ಹತ್ರನೂ ಇದೆ ಕಾಪೀಸ್. I can produce also.
Registry is directed to get the records of the trial court and also the appellate court. List this matter on 21/7.
Interim order.
Interim order ಏನಿದೆ?
Not stay of this appellate court judgment. ಯಾಕಂದ್ರೆ ರಿಮ್ಯಾಂಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲಿಗೆ, ಅದಕ್ಕೋಸ್ಕರ they will proceed with it.
ಅದು ಯಾವಾಗ ಆಗಿರೋದು ಆರ್ಡರ್?
Appellate, that is in 12th August 2015.
15.
There was an interim order up to a particular time. Why there was a delay ಅಂದ್ರೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಬೇರೆ ಇತ್ತು ಇದರದ್ದು.
ಈಗ ಆಯ್ತು, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಾ ಅಲ್ಲಿ?
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಒಂದು ನಿಮಿಷ.
ಇದೇನು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಹಾಕಿದಾರಲ್ಲ ಮೇಡಮ್?
17/2/22 ನಲ್ಲಿ that was extended till next
filing of amended cast title ಬೇರೆ ಇದೆ ಅಲ್ಲ.
ಅದು ನೆನ್ನೆ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಹೇಳಿದ್ರೆ ಅದು ರೆಡಿ ಇದೆ. ನಾನು I could not serve, ಅವರು ಲಾಯರ್ ಯಾರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. I have sent it by registered post to the parties. 2 ರಿಟರ್ನ್ ಆಗಿದೆ, 1 ರಿಟರ್ನ್ ಆಗಿಲ್ಲ.
ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ 2 ಟೈಮ್ ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್?
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ by oversight it was not extended. Now since it is
ಆಗಿಲ್ಲ,
2/6 ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. 2/6/22
ಆಗಿಲ್ವಾ? ಯಾವಾಗ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರೋದು? ಆಗಿದೆ, ಆಯ್ತು. The interim order earlier granted is extended till state of hearing. This matter on 21/7. Next.
50, P.N. Harish, Viraya Hiramat,
But second defendant's appeal, my lord,
Divergent finding ಇದೆ.
divergent finding. Lord,
ಒಂದು ಲಿಮಿಟೇಷನ್ ಸೆಕ್ಷನ್ ಆರ್ಟಿಕಲ್ 58 ಮೇಲೆ ಬಾರ್ಡ್ ಅಂತ ಡಿಸ್ಮಿಸ್
ಹೌದು,
ಮಾಡಿದ್ರು.
ಹೌದು,
That is reversed
yes,
and remanded.
yes. Really, last time also made submission, records are required because there are.
Records ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ, ಕಾಲ್ಪರ್ ಆಗಿ.
ಇಲ್ಲ sir.
ಇಲ್ವಾ? Registry is directed to get the records of the trial court and appellate court. This matter on 21/7.
Please,
15/7
ಯಾವ
ಯಾವ ಊರು?
ಶಿವಮೊಗ್ಗ.
ಶಿವಮೊಗ್ಗ
21/7.
ಆಗುತ್ತೆ.
51, ಕಲ್ಯಾಣ್ ಆರ್,
ಕಲ್ಯಾಣ ಆರ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಬ್ಸೆಂಟ್ ಡಿಸ್ಮಿಸಲ್ ಗೆನ ಇಟ್ಟಿದೀವಿ. ಹೇಳ್ರಿ ಏನು?
ಕೈಂಡ್ಲಿ ಪಾಸ್
ಇದೀರಾ?
ಕೈಂಡ್ಲಿ ಪಾಸ್
ಏಕೆ? ಪಾಸ್ ಓವರ್ ಯಾಕೆ?
ಟೋಟಲ್ 10 ಅಲ್ಲಿ ಎಲ್ಡಪ್ ಆಗಿದೆ.
ಅದರ್ ಸೈಡ್ ಸರುಡ
ಸರ್
ಆಯ್ತು ಪಾಸ್ ಓವರ್.
52,
ಪಾಟೀಲ್ ಸಂಗನಗೌಡ ಗುರನಗೌಡ.
Lord, I am for the appellant in this case, my lord. The claimant appeal, my lord, in the last occasion, my lord, the council appeal for the Irabri Nigam has taken time to verify the amount and they have deposited, my lord. Date of deposit.
My lord, this is the thing. In the last date of it, there is 3079 days delay. They submitted that.
3,007
Sorry, my lord. 379 days delay. They submitted that there is financial difficulty. For that reason, I could not come before the honorable court. And also they told that the deposit was done. The MA after this one, the deposit was done in the year.
Deposit only they.
I could come
filed
here.
This anta.
I'm sorry. My lord, I took time to say that when was it deposited?
Amount was deposited.
When was the amount deposited? My lord, the court fee. First they filed MA, my lord, LAC ಮೇಲೆ MA ಹಾಕಿದ್ರು. MA ಅಲ್ಲಿ ಅವ್ರು ಪೇ ಮಾಡಿರೋದು 42,000. ಇದು 42,000 ಅವರು ಕೋರ್ಟ್ ಫೀ ಪೇ ಮಾಡಿದ್ರು. MA ನಲ್ಲಿ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ ದಟ್ ಮಚ್ ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟ್. ಅಂದ್ರೆ ಅವರು ಏನು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು ಅಥವಾ ವಾಟ್ ವಾಸ್ ದೇರ್ ಕ್ಲೈಮ್ ದಟ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ದಿ ಇನ್ MA. My lord, before this honorable court, my lord, the court fee is 1,39,000 change. 1 lakh. 1,36,000 ಎಷ್ಟೋ ಬರುತ್ತೆ. My lord, once LAC was passed, my lord, LAC 34 of 2006 was passed, my lord. My lord, we have paid 10,62,934 rupees. In the year 2015 ಅಲ್ಲೇನೆ ನಾವು 10,62,934 rupees pay ಮಾಡಿದ್ವಿ. MA ಆದ್ಮೇಲೆ what they are telling is right, that is in the year 2023 we have deposited. But there is 379. My only request before honorable court is, my lord, 10 lakhs we have already paid when the LAC was granted. 10 lakhs. They paid only 42,000 fees in MA. Illi 1,36,000, my lord. My only request before this honorable court is interest should be.
ಅಂದ್ರೆ ನೀವು ಕೊಟ್ಟಿದ್ದ ದುಡ್ಡೆಲ್ಲ ಬರೀ ಕೋರ್ಟ್ ಫೀ ಮಾತ್ರ ಇಟ್ಕೋಬೇಕು.
ಹಂಗೆ ಇಟ್ಕೋಬೇಕು ಅಂತಲ್ಲ ಸ್ವಾಮಿ. What they are doing, they are coming to the, that is their responsibility to pay the amount.
ಆಯ್ತು, ಡಿಲೇ ಓನ್ಲಿ 379 days.
ಅದೇ ಅಲ್ಲ, ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಇಂಟ್ರೆಸ್ಟ್ ಶುಡ್ ಬಿ ಅಷ್ಟೇ, ಸಬ್ಮಿಷನ್ ಅಷ್ಟೇ. ಡಿಲೇ ಮೇ ಬಿ ಕಂಡೋನ್, ಐ ಆಮ್ ನಾಟ್ ಟೆಲಿಂಗ್.
Heard the appellant counsel on IA number 1 of 23 and there is a delay of 379 days in filing the application for condonation of delay.
Sorry my lord, ಅದು 1090 days ಬರುತ್ತೆ ಡಿಲೇ. ಐ ಥಿಂಕ್ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಬರುತ್ತೆ ಅಂತ ಅನ್ಸುತ್ತೆ. ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಅದು.
ಬಟ್ ಈಗ ಇರೋದು ಆಫೀಸ್ನರ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದು
379. ಐ ಅಗ್ರಿ ವಿತ್
379 ಇರೋದು.
ಅದೇ ಫಾರ್ ದಟ್ ಪೀರಿಯಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ.
Delay application.
Page number, my lord, 37. Page 37, my lord, is the application for condonation.
The counsel appearing to the appellant would submit that accrued by the judgment and award dated 1/12/2011 passed in LAC number 34 of 2006. An appeal was filed. Appeal, MA, na?
MA.
MA was filed. That is numbered as 27 of 2015. And MA 27 of 25
2015 million.
passed the judgment on 18/6/2020. And thereafter learned counsel appearing for the claimant had informed the same to the claimant. However, he could not file the appeal before this court immediately on account of poor economic condition and as huge court fee was required to be paid on the appeal. He was anticipating to file appeal after receipt of compensation amount as awarded by lower appellate court. And the same was paid in the year 2022. And hence there was a delay of 379 days. The counsel appearing for the respondent filed the statement of objections, contending that land was acquired long back and only court fee of rupees 42,000 was paid before the appellate court. And the court fee payable before this court is 1,39,000. The counsel would submit that when the land was acquired in the year 2015, an amount of rupees 10,62,934 was paid.
Sorry, Mala. In the year 2015, when the
15,
LAC was passed.
15,
Please.
10,62,934 was paid. And only meager amount was paid in MA. And the very reason assigned in the application that could not file appeal within time due to economic problem cannot be accepted. The reason assigned that award amount was paid in 2022 and there was a delay in filing 379 days cannot be accepted. The counsel would submit that in respect of the delayed period of 379 is concerned, not entitled for interest. ಏನ್ ಹೇಳ್ತೀರಿ ಇಂಟ್ರೆಸ್ಟ್ ಸಂಬಂಧಪಟ್ಟಂತೆ 379 ಡೇಸ್ಗೆ?
Lord, actually the amount received, Lord, in 2022, immediately, Lord, the appellant has filed this appeal. There is no further delay in filing the appeal by paying the huge court fee of rupees 1,32,000, Lord. The award, Lord, is only for 1,30,000 per acre, awarded by the lower appellate court.
Having got the appellant counsel and also the counsel appearing for the respondent.
And also we have paid.
In dispute that land was acquired 1 acre 31 guntas. Howda?
Please, please.
And the same was acquired in the year
1997, my lord.
1997. And award was passed and the same was challenged. And the same is numbered as LAC number 34 of 2006. And the same was disposed of after 5 years. That is on 1st day of December 2011. And not satisfied with the award amount, MA is filed in 2015. And the same was disposed of on 18th day of June 2020. Having perused the same, in the month of June 2020, there was a COVID and COVID benefit was also given to the appellant. And also the other ground urged before the court is that the compensation amount was paid in 2022. And the fact that subsequent to the award passed in MA, amount was paid in 22 is not disputed by the counsel for the respondent. But counsel would submit that in the year 2015, an amount of compensation of rupees 10,62,934 was paid. Having considered land was acquired in 1997, an amount was paid long back in 2015. The court cannot expect that the land loser can retain the amount to pay the court fee in 2023.
My lord, one more submission.
The sentence and the contention of the counsel for the respondent cannot be accepted. That amount was paid long back. and the same would have been utilized for payment of court fee. The fact that in this appeal, court fee of rupees 1,39,000 is paid is not in dispute. And when such being the case, the delay of 379 days delay also on account of only after payment of the compensation amount, the appellant has approached the court, and the courts are also shall not be too technical while considering the delay, and when the reason is assigned that could not file the appeal within time, since not having the money to file the appeal, and the amount of rupees 1,39,000 is also a substantial amount. And hence the very contention of the respondent that not entitled for interest for the delayed period cannot be accepted, and court has to take note of the factual aspects of the each case, and a substantive justice must be done, not on the technicality, and hence the delay of 379 days is condoned.
My lord, only once.
Records
We
may
have
be-
paid interest. We have paid interest, my lord. Till 2023, we have paid interest.
Interest ಕೊಡ್ಲೇಬೇಕು.
Other.
As per the
that also.
statute only.
Statute, we have
Aye.
paid, my lord. That also we have paid.
List this matter for admission and call for records of the lower court and also the appellate court. List this matter on 21/7.
Please.
Records ಬಂದಿಲ್ಲಲ್ಲ ಮೇಡಮ್?
Yes.
ಇಲ್ಲ.
53.
IA 2 of 23 will be heard along with main appeal.
Please.
ನೀವು objections ಇದ್ರೆ ಹಾಕ್ಬೋದು additional documents.
Please.
Next 53. Ekade VS.
Appellant.
Both TCRs kept below.
This
Frame additional
matter is
issues.
remanded by the appellate court. Exceeding the jurisdiction, it is a very peculiar order at page number 40, your lordship may kindly see. Expanding the scope of suit for injunction to the suit for declaration. That cannot be done.
Suit ಅಲ್ಲಿ ಏನ್ claim ಮಾಡಿರೋದು?
The suit for the plaintiff is the purchaser of the property from defendant number 2 and 3. And he is in possession of the property. The defendant number 1.
Suit is only for the permanent injunction?
Permanent injunction. That came to be declared in my favor. Against which defendant number 1 has filed a appeal. In the appeal, this remand order came to be passed. While passing the remand order, the court has allowed the application order 41 rule 27 also. And further, your lordship may kindly see the relevant portion is very strange and peculiar. Further, it says page number 40. The learned trial court shall allow the plaintiff to convert the suit into one for comprehensive relief of declaration and consequential relief, and allow the defendant number 1 to produce additional documents. It shall frame appropriate additional issue, and an opportunity shall be given to both parties to lead additional evidence, if any, and thereafter the matter shall be decided afresh after considering the whether it is necessary for make recourse to the order under 26 of CPC. Considering the circumstances, reasons discussed here and above, it is ordered that the parties shall bear their own cost. The parties shall appear before the learned second additional civil judge JMFC Madhur on 21/3/2023 for the purpose of receiving the direction of the court as to further proceedings in the suit. Whether this type of order can be passed. That is the reason I am before this honorable court. There is an order of interim.
Can order 41 rule 27 application
application. No, that has also not been properly considered. Simply said the appellate court has got the power. Therefore, we are allowing it. That is the only observation insofar as allowing the application. And further, this type of order came to be passed. I should file an application to convert the suit into one of declaration and other reliefs.
With respect to the declaration, your lordship kindly see the observation made by the court why it has to be converted, my lord. Your lordship kindly see para 24, my lord. Para
24 of the appellate court.
Appellate court judgment. It is clearly stated why it has been made out, my lord. Further, I may be permitted to read. Further, the foregoing discussions and reasons for the 45, the observations made herein above that the question involved in this suit are not limited to the deciding a mere question of possession of suit for injunction simpliciter contrary to the observation made in the impugned judgment, I am of the considered opinion that the denial of the title and challenge to the title of the plaintiff and vendors by the defendant number one in this case as a cloud on the title of the plaintiff and his vendors in respect of the suit property, such being the case, an action for declaration is a remedy for the plaintiff, Honorable Supreme Court so and so in decision, wherein it is clearly stated, my lord, where the plaintiff believing that the defendant is only a trespasser or wrongful claimant without a title, files a mere suit for an injunction, and in such a suit, the defendant discloses in his defense that the details of the right or title claimed by him which raise a serious dispute or cloud over the plaintiff's title, then there is a need for the plaintiff to amend the plaint and convert the suit into one for declaration. Alternatively, he may withdraw the suit for bare injunction with permission of the court to file a comprehensive suit for declaration and injunction. He may file the suit for declaration with consequential reversal even after the suit injunction is dismissed, where the suit is arised only on the issue of possession and not any issue of title. Here in this, my lord, the issue with regard to the title is a dispute, my lord. It is clearly denied by the defendant. And the court has come to the conclusion, first appellate court has come to the conclusion clearly, my lord, as on the date of the filing the suit, there is no revenue document standing in the name of the vendor or to the purchaser, my lord. And it was stand in the name of the defendants, my lord. Accordingly, he has challenged the kata which has been wrongly made out in the name of the plaintiffs, my lord. That was set aside, and later on we come up to this honorable court. It has remanded the matter, and later it has been allowed in favor of me. Kata was changed in favor of me, my lord, saying that the kata was standing in the name of my husband. Prior to that, my father-in-law's name was there, my lord. And after his death, Subramaya's name was included. And rounding of that particular revenue entries, my lord, the name of this particular person has been made out. There is no basis for which an order has been passed, my lord. Exhibit D21, my lord, order.
You are also claiming the title in
Yes, my
respect
lord.
of
I
this
have also put up a construction. I am residing there, my lord. There is a house is there. I am residing there. Kata was standing in the name of my father-in-law. Later it was come to the Subramaya. He is my husband. And rounding off of Subramaya, as in the year 2011, they got the kata into their name.
What is the basis?
The basis they are saying that the sale deed.
Sale deed executed by whom?
The sale deed executed by the sons of Chikkamuddaya. There is no entries prior to that.
Chikkamuttaya has got the title?
There is no basis. That is the observation was made out in the exhibit D21. You have to kindly see.
Lord, in so far as the possession and interference is concerned, that has been categorically proved before the trial court, and there is.
When your title is disputed.
No, it is the title is not disputed. See, matter went. Written statementally, or simply they say. See, apart from that, my lord. Now, what has to be looked into is.
The law is settled.
That's
when there is a cloud on the title.
Yes.
You have to go for only for the comprehensive relief of declaration.
So that is right. That is right. Now,
when
by virtue.
File the written statement denying your title, when there is a cloud on your title, how can you maintain?
There is no cloud. There is no cloud, my lord. It requires consideration. That is the reason. That it requires consideration.
Consideration a cloud iddag ಏನು ಮಾಡಬೇಕು?
Cloud ಇದ್ದಾವಾಗ ಸರಿ. Cloud ಇದ್ದಾವಾಗ either I have to file amendment to convert the suit for declaration or not. That is see, and see, they are attacking the if that is the case, my suit has to be dismissed. That on the other hand, it came to be allowed. It came to be allowed, and the first appellate court, without looking into the proper appreciation of the evidence by the trial court, passed this type of order. Whether such an order can be passed? That is my question. Such an order cannot be passed. If that is the case, then they have to file a suit for declaration to say that I am the title holder.
You are not having title.
Prima facie, now prima facie.
Not having title, that's why you are not seeking the relief of declaration.
No, I am having title. I am having a title based on the sale deed. Based on the sale deed.
Vendor ಹೆಂಗ್ ಬಂತ ಹೇಳಿ. Sale deed ಆಯ್ತು. Sale deed ಬರ್ಕೊಡೋನಿಗೆ ಇರಬೇಕಲ್ಲ title.
ಅವ್ರಿಗೂ ಟೈಟ್ಲ್ ಇದೆ. ಅವ್ರಿಗೂ ಟೈಟ್ಲ್ ಇದೆ. ಟೈಟ್ಲ್ ಇಲ್ಲದೆ ಬರ್ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ತೋರಿಸಿ
It requires consideration. That is the reason, my lord. The documents.
The appellate court comes to the conclusion that
that is the reason. That is the reason LCR is necessary, my lord.
LCR ಬಂದಿದೆ. WS ಇದೆಯಾ ಇಲ್ಲಿ?
ಬಂದಿದ್ರೆ ನಾನು ನೋಡಿ ಹೇಳ್ತೀನಿ, because I don't have.
What is the WS? ಅವ್ರದ್ದು.
WS your lordship.
Whether they have disputed the title?
Yes, my lord. in the judgment
Claims
itself.
the title in respect of the very same suit settled
Yes, my
property.
lord. Yes, my lord. Your lordship
See,
kindly see the judgment of the trial court at page, it extracted is there, my lord. There are 4 of the trial court judgment, my lord.
The lordship may kindly see the order of the trial court.
Hmm.
At para 18 onwards, page number, ink page number 63. The defense taken by the defendant number 1 and the particulars of the document produced by them do not substantiate. It is the case of the defendant number 1 that the suit property is their ancestral property, and the defendant number 2 and 3.
First paragraph the written statement and specific contention ತಗೊಂಡಿದ್ದಾರೆ. The allegation in para number 2 and 3 of the plaint that the plaintiff is the absolute owner in possession of the suit shell property and having purchased the same through a registered sale deed dated 26/5/2007 from defendant number 2 and 3 for lawful consideration is absolutely false, and defendant number 2 and 3 have no right to execute the sale deed ever since the sale deed plaintiff is in lawful possession and settlement possession enjoyment of suit shell property is absolutely false ಅಂತ. ನಿಮ್ ವೆಂಡರ್ ಟೈಟ್ಲೇ ಇಲ್ಲ ಅಂತ
that is their contention, but that has been adverted to by the trial court.
ನಿಮ್ದೆಲ್ಲಿದ್ದಾರೆ ಕ್ಲೈಮ್ ಟೈಟ್ಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್
That
ಆಫ್ ದಿ
is
ವೆರಿ
the
ಸೇಮ್
ancestral
ಪ್ರಾಪರ್ಟಿ.
property, my lord. It was there. You lordship kindly see the exhibits, my lord.
Did not got in pursuance of the registered sale deed got the revenue entries in his name. Plaintiff had made a petition to
And
the
also
panchayat.
exhibit D21, my lord. I
Also,
challenge
they
that
said
kata, my
recital
lord.
is consideration of panchayat authorities absolutely false. It is not the absolute property of the defendant number 2 and 3.
Yeah.
Kata entries was standing in the name of the defendant number 2 and 3 at the time of execution of the sale deed is also false. And the mutation was executed in the name of defendant number 2 and 3 and defendant number 2 and 3 bearing number so and so 73. And the RTC has been written in Guntas is absolutely false. It is the first defendant has got every right, title, interest over the suit settled property. The defendant is not the person in the locality and this is not illegally trying to grab the property of the plaintiff on the basis of the concocted document. The defendant has filed the appeal before the Taluka Panchayat so and so. Since the plaintiff notices the said fact, they immediately filed the application to implicate himself in the plaintiff appeal those and so on to party in the person. And Panchayat of property understanding the said aspect illegally rejecting the so and so. Plaintiff is false and Taluka Panchayat passed final order setting aside the kata made in the name of the defendant number 2 and 3. Put the kata in the name of the defendant number 1.
Defendant number 1.
That is.
That the defendant number 1 with intention to create. New defendant number ಎಷ್ಟೇ?
Defendant number 1.
1.
ಅದ್ರಾಗ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಫಸ್ಟ್ ಐ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ದಿ ಖಾತಾ ವಿಚ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಾಂಗ್ಲಿ ಮೇಡ್ ಔಟ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ದಿ ಪ್ಲಾಂಟಿವ್ ಐ ಚಾಲೆಂಜ್ ಬಿಫೋರ್ ದಿ ಪಂಚಾಯತ್ ಮೈ ಲಾರ್ಡ್.
ಆಯ್ತು.
Panchayat allowed it. And later it has
Appeal
come
was
before
filed.
the writ petition, my lord. In the writ petition, court says that under 269 it has to go before the executive officer, not before the president, my lord.
ಹೌದು.
And it has been remanded back. Later, my lord, it was allowed after remand. Exhibit D21 is the document which clearly says.
ನಿಮ್ದು ನೀವು ಈ ಪ್ರಾಪರ್ಟಿ ಕ್ಲೈಮ್ ಮಾಡಿ ವೇರ್ ಇಸ್ ದ ಸ್ಪೆಸಿಫಿಕ್ ಪ್ಲೀ ಇನ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
With regard to this property,
ಪ್ರಾಪರ್ಟಿ ನಮಗ್ ಸೇರಿದ್ದು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದೆ?
ಹೇಳಿಲ್ಲ ಅವರು.
it is stated, my
ಹೇಳಿಲ್ಲ.
lord. It is stated, my lord.
ಇಲ್ವಲ್ಲ? That's what I read.
Allah, it is stated, my lord. I will-
Unless you claims the title or the suit shell property, there cannot be any cloud
Yes.
on the title.
It is claiming my
ಎಲ್ಲಿದ್ದಾರೆ ತೋರ್ಸ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ.
the document, my lord.
ಅಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿ.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಇಲ್ಲೆಲ್ಲೂ ಇಲ್ಲ.
ಇಲ್ಲ.
Except you are stating in paragraph number 5. It is the first defendant has got every right, title, interest over the suit shell property.
Yes, ma'am.
On what basis you are claiming that you are the owner?
That is, my lord, this property.
Except stating that plaintiff vendor was not having any title. You must make a specific plea in the written statement that no,
That is
no,
fine,
no,
my lord.
this property belongs
Comes
to
to
me. I am having the title.
Yes, my lord.
And so on, so the title document.
With regard to that, my lord.
ಅದು ಮಾಡದಲ್ಲೇ ನೀವು ಟೈಟ್ಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಬರೀ ಕ್ಲೌಡ್ ಆನ್ ಟೈಟಲ್ ಅಂತ
ಅಲ್ಲಲ್ಲಿ how it has come ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. Your lordship kindly see in the extract. I am not having the written statement.
That's why I read the written statement.
I am not having the written statement, my lord. Your lordship-
ಸ್ಪೆಸಿಫಿಕ್ ಪ್ಲೀ ಇಲ್ಲ, ಇದು ನಂದೇ ಪ್ರಾಪರ್ಟಿ ಅಂತ
Your lordship-
ನಂದು ಟೈಟ್ಲ್ ಇದೆ ಇದಕ್ಕೆ,
Para four, my-
ಅವ್ರದ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಏನು ಹೇಳಿಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ.
Lordship,
Only on the kata they say. Kata which was challenged before the concerned authorities and one authority has allowed it and thereafter that has been set aside and again the writ petition came to be
My
filed.
lord, I
All
would
these
like to
things
make
are
a
on the
submission, my lord.
kata. But
The
prima
court has-
facie, I have a title deed with me and I am in possession of the property.
The
and
title
Khata-
deed,
Specific custom, when there is no plea in the written statement,
That
that
as stated,
you are claiming that you are the owner of the suit scheduled property, and there is a cloud on the title. How can the first appellate court can direct him
Your
to
Lordship, I may
amend
be-
the plaint
I-
and seek for the relief of declaration?
it is for the direction given to the other side to make. the
ಅದನ್ನ
amendment
ಯಾಕೆ
of the
ಅವ್ರಿಗೆ
case, my lord.
ಕೊಡ್ಬೇಕು ಅಂತ
Because
ಕೇಳಿದೆ. Is it not exceeding the limit
And
Yes,
also,
yes.
for bare injunction?
and also it is the
Unless there is a
my lord, it is also an observation of the first appellate court is that.
observation itself is wrong.
Is my,
Unless,
that is
unless
not-
you made a claim in
not
respect
with,
of the
not
suit
with
property
respect,
that you are
not
the
with
owner of the
respect to
property.
remanding, my lord, other observation based on the document, my. The other observation that was made out, my lord,
First,
as
there must be a pleading.
pleading,
that
your lordship.
claiming that you are the owner of the property,
I'm-
title based on so and so.
Your lordship-
ಏನು ಇಲ್ಲ ನಿಮ್ದು, except one sentence.
ಅಲ್ಲ,
The
I may
defendant
be
having the
permitted to
title.
clarify.
And it is the first principle, my lord, without there being a plea, any amount of evidence or any amount of argument will not hold any water.
No, no, no. The
That is the
question
first principle.
Let us set ಮಾಡನ್ನ, let the matter decide by the appellate court on merits. That's all.
I will convince your lordship, it is not the on the.
ಅಲ್ಲ, ಅದೇ
pretext of
remand
that
ಮಾಡ್ಬೋದು.
particular thing, my lord.
Remand
The
ಆಗ್ಬೇಕಾಗಿ.
para 4, my lord. Para
First appellate court ಗೆ remand ಮಾಡಿ,
my,
in respect of the scope of the suit is concerned, for the permanent injunction is concerned, whether the trial court committed an error in granting the relief of permanent injunction, let the trial court decide, that's all.
Appellate court.
my lord, I have stated in the para.
ಎಲ್ಲಿದೆ written statement?
The suit property, your lordship, I may be permitted to few lines, my lord, in the judgment.
Judgment ಬಿಡ್ರಿ.
ಅಲ್ಲ,
ನಾನು
extract
ಕೇಳ್ತಾ-
ಮಾಡಿರೋದು. Written
First
state,
pleading ತೋರ್ಸ್ರಿ.
ಅದೇ
ಇದು
ನಾನು
written statement ಅಲ್ಲಿ.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಇಲ್ಲಿ ಓದ್ತೀನಿ, ನಾನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
First over, ಮಧ್ಯಾಹ್ನ ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಅಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಇದೆ ನಾನು.
ಇಲ್ಲಿ the suit property
I gone through the written
ಅಲ್ಲ,
statement.
one
whether
minute,
such
1 minute.
plea is taken ಅಂತ.
The suit property was originally belonged to the father-in-law of the defendant number 1. And he was in the possession of the same.
ಎಲ್ಲಿ ಹೇಳ್ತಾ ಇದೀರಿ ನೀವು?
ಇಲ್ಲ.
That is the written statement, my lord.
ಎಲ್ಲಿದೆ ನೋಡಿ. ಮತ್ತೆ ನಾನು ಅಮೆಂಡ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ, ಇದೆ ಸ್ವಾಮಿ, ಕೊಡ್ತೀನಿ.
ಒರಿಜಿನಲ್ ಇಲ್ವಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಇಲ್ಲ.
Except stating the title.
Father-in-law, ಅದನ್ನೇ ಅದು ಬರ್ದಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ. Subramaya is my husband.
Para 5 ಹೋಗಿ. It is the first defendant has got every right, title, interest over the suit shell property. The defendant is not powerful. ಅಂದ್ರೆ ಅವ್ರು ಪ್ಲೀಡ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ. Not illegally tried to grab the property of the plaintiff on the basis of the concocted document. ಆಮೇಲೆ ಪ್ಯಾರಾ 6 ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದು, ಅಪೀಲ್ ಅಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದ್ದು ಅದೆಲ್ಲ ಹೇಳಿದಿರಿ. ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ನಿಮ್ ಸ್ಪೆಸಿಫಿಕ್ ಡಿಫೆನ್ಸ್?
ಇಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್, your lordship kindly pass over and I will look into that.
ಪ್ಯಾರಾ 8 ಅಲ್ಲೂ ಇಲ್ಲ.
ಎಲ್ಲೂ ಇಲ್ಲ.
It is the first defendant is in occupation as owner thereof ಅಂತ ಮಾತ್ರ ಹೇಳಿದಿರಿ. ಏನೂ ಇಲ್ಲ ನಿಮ್ಮ written statement.
ನೋಡ್ಬಿಟ್ಟು kindly pass
What
over.
they say is, I am not in possession ಅಷ್ಟೇ ಹೇಳ್ತಾ ಹೋಗ್ತಾರೆ.
ಕ್ಲೈಂಟ್ ಡಿನೈ ಹೇಳಿದ್ ಬಿಟ್ರೆ ನಿಮ್ದೇನು ಸ್ಪೆಸಿಫಿಕ್ ಕ್ಲೀನೇ ಇಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
Extraction is there in the judgment, my lord. I will look into the written statement and I will submit.
ಆಯ್ತು ನೋಡಿ ಹೇಳಿ, ಪಾಸ್ ಓವರ್.
Before.
54.
Lord, miscellaneous second appeal is by the plaintiff before the trial court. My lord. Suit for specific performance. My lord,
Till the direction was given to execute by receiving an amount of rupees 1,55,000.
my lord,
And the same was reversed in the appeal and remanded.
remand. My lord, suit filed, my lord, on 5/12/2012
R4 ಗ.
before the trial court on
3 and
5/12.
4 are minors ಅಂತಿದೆ ಮೇಡಮ್.
One submission, my lord, before that, R3, it's as per my information, he attained majority.
R4.
R3, R4 ಗೆ ನಿನ್ನೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
R4
ಮೈನರ್ ಇದ್ರು.
ಇಬ್ರು ಮೇಜರ್.
ಇಬ್ರು
R3
minor
is
ಇದ್ರು ಮಕ್ಕಳು.
major as per
As on
my
the date of
information.
filing
ನೀವು
the
ವಕಾಲತ್
application.
ಹಾಕಿರೋದು R4 ಗೆ.
R4 ಗೆ ನಿನ್ನೆ ವಕಾಲತ್.
ಮೇಜರ್ ಆಗಿದಾರ ಅವರು?
ಇಲ್ಲ.
ಮತ್ತೆ
ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು.
3 and 4 are the minors ರೀ. Earlier.
R4 ಅಟೈನ್ ಮೆಜಾರಿಟಿ. R3 ಗೆ ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಮುಖಾಂತರನೇ ವಕಾಲತ್ ಹಾಕಿ.
R3 ಗೆ
ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾನ್ಸ್.
ಕುಲ್ಕನೆ.
ಹೌದು.
ಫಸ್ಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿಸ್ಕೋಬೇಕಲ್ಲ R4 ನ.
ಅವ್ರು
ಗಾರ್ಡಿಯನ್ ಡಿಸ್ಚಾರ್ಜ್. ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರಲ್ಲ, ನೀವಾರು ಅಟೆಂಡ್ ಮೆಜಾರಿಟಿ ಅಂತ ಹಾಕ್ಬೇಕಲ್ಲ ಅಪ್ಲಿಕೇಶನ್.
R3 is ಅಟೈನ್ ಮೆಜಾರಿಟಿ.
ನೀವು ವಕಾಲತ್ ಹಾಕಿರೋದು ಈಗ ಯಾರಿಗ್ರಿ?
R4 ಗೆ ಮತ್ತೆ R1 and 2.
4 ಗೆ ಹಾಕಿದಿರಿ.
ಹೌದು.
ನಾವು minor attained majority.
So minor guardian ಅಂತಾನೆ represent ಮಾಡಿ ವಕಾಲತ್ ಹಾಕಿ. The R4 is represented by R2. 3 and 4 are the children of R2.
ಹೌದ್ರಿ ಇಬ್ರು ಮೈನರ್ಸ್ ಇದ್ರು. ಈಗ ನಾವು who has attained the majority?
R3.
R3 ನ ಮತ್ತೆ ಇಲ್ಲಿ R4 ಅಂತ ಹಾಕಿದ್ರಿ ಇಲ್ಲಿ ವಕಾಲತ್ತಲ್ಲಿ.
ಹೌದು. R4 represented by guardian ಅಂತ ಹಾಕಿದ್ವಿ ವಕಾಲತ್.
ಮೇಜರ್ ಆಗಿರೋದು ಯಾರು ಹೇಳಿ?
R3.
R3 ನ R3 ಮೇಜರ್ ಆದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕು, ವಕಾಲತ್ ಹಾಕ್ಬೇಕು. ನೀವ್ ಹಾಕ್ಬೇಕಲ್ರಿ, ಡಿಸ್ಚಾರ್ಜ್ ಕೇಳ್ಬೇಕು.
I will file a necessary application.
ಇನ್ನೊಬ್ರು ಯಾರು?
R4 ಸನ್ ಅವನು ಮೈನರ್.
R4 ಗೆ ಬಟ್ R3 ನು ಈಗ ಮೇಜರ್. ಹಾ ಹಾ R4 ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ವಾ? ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಮೇಡಮ್.
R1 and 2 ಮತ್ತೆ R4 ಗೆ ನಾನು
2 and 4 ಗೆ ಅವರೇನೆ.
ಕರೆಕ್ಟ್ ಪ್ಲೀಸ್.
ಆಯ್ತು,
ಕರೆಕ್ಟ್.
ಹಾ ಆಯ್ತು. ರಿಮ್ಯಾಂಡ್ ಆರ್ಡರ್ ಏನ್ ಹೇಳಿ ಫಸ್ಟ್ ನೋಡೋಣ.
Lord,
ರಿಮ್ಯಾಂಡ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್, ದೆನ್ ವಿಲ್ ಸಿ.
miscellaneous second appeal is by the plaintiff before the trial court, my lord. My lord, the defendant 1 and 2, my lord, father and son, my lord, they have executed an agreement of sale in favor of the plaintiff.
Father and son.
Father and son. And suit, my lord, dates are relevant here. Suit filed, my lord, on 5/12/2012.
Agreement ಯಾವಾಗ?
2008.
15/5/2008.
15/5/2008.
Agreement.
ಹೌದು.
ಆಯ್ತು.
ಇಲ್ಲಿ periodically they have received the amount in the year 2010, 12. Thereafter, my lord, the suit filed, my lord, on
agreement ಪ್ರಕಾರ ಎಷ್ಟು?
2,40,000.
ಟೈಮ್ ಎಷ್ಟ್ರಿ? ಪೀರಿಯಡ್ ಏನು? whether time is the essence of the contract?
ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ
ಇದರಲ್ಲಿ ಪ್ರಕಾರ
ಅದನ್ನ ನೋಡಿ ಹೇಳ್ತೀನಿ. ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ.
ಮತ್ತೆ
ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಸೂಟ್ ಮೈ ಲಾರ್ಡ್ ಫೈಲ್ಡ್ ಮೈ ಲಾರ್ಡ್.
ರಿಮಾಂಡ್ ಏನು ಕೇಳಿ ರೀಸನ್.
ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಮೈ ಲಾರ್ಡ್, ದಿ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್, ಸಮನ್ಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಆರ್ಡರ್ಡ್. Before service of summons, my lord, one advocate, my lord, SSB, my lord, he appeared before the trial court and he undertakes to file wakalat on behalf of the defendants number 1 and 2. That is, my lord, on 23/1/2013. 23/1/2013. The undertaking has been recorded. Thereafter, my lord, the case has been listed, my lord, for filing of written statement. That advocate who is appeared before the trial court, my lord, he failed to appear and failed to file written statement. Consequently, my lord, the suit proceeded ex parte and decreed ex parte. Thereafter, my lord, on 30/8/2013, I filed, my lord, the execution proceedings before the trial court. Very same advocate, my lord, pursuant to the service of summons, my lord, very same SSB advocate, my lord, appeared before the execution proceedings and he filed wakalat on 5/10/2013. 5/10/2013. Where 13 ಅಲ್ಲೇ
ಆಗ್ತಾರ್ರಿ ನಿಮ್ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿರೋದೇ 23/1/13 ಅಲ್ಲಿ. ಹೌದು. ಮತ್ತೆ ವಿತಿನ್ 10 months ಅಲ್ಲೇನಾ?
ಹೌದು. ಎಕ್ಸಿಕ್ಯೂಷನ್ 30/8/2013 ಹಾಕೊಂಡ್ವಿ. ಸಮನ್ಸ್ ಆರ್ಡರ್ ಆಯ್ತು 5/10/2013. And the very same advocate has filed wakalat, my lord, on behalf of the judgment debtors, my lord, on 5/10/2013. Thereafter, my lord, the objections not filed and the case proceeded. Execution ನಡೀತಾ ಇತ್ತು. And during pendency of the execution proceedings, my lord, the second defendant died, my lord, on 2/11/2019. And the appellants herein, my lord, they are the wife and children of this deceased second defendant. Along with the first defendant, my lord, they preferred an appeal in the year 2024. There is a delay of about 11 years in filing the appeal. My lord, the reason assigned, my lord, the inquiry has been held. The reason assigned by the, my lord, the second respondent herein, pursuant to the death, my lord, during the lifetime of the, my lord, the second defendant, they have not chosen to file any appeal. My lord, only after the death, my lord, after the lapse of, my lord, the 5 years, this LRs, my lord, they have preferred an appeal. The findings recorded by the trial court, my lord, that advocate, my lord, SSP, my lord, he has not, my lord, he undertakes to file wakalat. Thereafter, he has not turned out. Hence, it is an ex parte. Hence, the matter has been remanded. before the trial court from the date of, my lord, the service of summons. Having not taken into consideration, my lord, the execution, very same advocate has been appeared and he is representing the defendant number 1 and 2, who are the judgment debtors in the execution proceedings. And more than, my lord, this during the lifetime of defendant number 2, my lord, defendant number 1 and 2, my lord, they have not chosen to file any appeal. It is only after the death, my lord, their LRs, my lord, they have preferred the appeal. The reason assigned by the, my lord, the affidavit and the reason assigned.
Wakalat is filed on behalf of the second defendant also?
Houdu.
In both the trial court as well as the
Houdu.
executing court?
Executing court.
ಏನ್ರಿ
Wakalat has not been filed. It's
Suit
only
ಅಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡಿದ್ರು, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ
undertake ಮಾಡಿದ್ರು.
ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡ್ರು, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಇಬ್ರಿಗೂ ವಕಾಲತ್ ಹಾಕೋದು.
Suit summons itself was not issued by the trial court. And
Summons issue ಆಗಿದೆ.
summons itself is not issued and they have not
Voluntarily undertaken to appear.
No, we have not given any undertaking and we have not engaged any advocate. Advocate, it appears that the order sheet appears that some advocate has undertaken. So when the next date of hearing, when wakalat is not filed and suit summons is not issued, the trial court ought to have issued a suit summons to the defendant list. On that ground, or in the appeal, the appellant court.
ಆಯ್ತು, ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಸೈನ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ ವಕಾಲತ್?
Executing court, we had no knowledge about in
5/10/2013.
ಅದ್ರ ಬಗ್ಗೆ
Maybe permitted.
When you are having the knowledge, when your father is having knowledge about
the thing is,
the suit as well as the execution petition.
The thing is, the suit is for specific performance. They are reached that the 2008 agreement. They
Original
filed a
suit,
suit.
the order sheet ಇದೆಯಾ?
ಎರಡೂ ಇದೆ. OS ಇದೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದೆ.
ನೋಟಿಸ್ ಹೋಗಿತ್ತಾ? ಬಟ್ ವಾಲಂಟರಿ ಬಂದ್ರ ಅಡ್ವೊಕೇಟ್.
PF itself is not paid.
ನೋಟಿಸ್ ಹೋಗಿತ್ತು ಬಿಫೋರ್ ಸರ್ವಿಸ್ ಆಫ್ ಸಮನ್ಸ್.
ಒರಿಜಿನಲ್ ಸೂಟ್ ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಅದು ಕೆಳಗಡೆನೆ ಇದೆ. ಇದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮೇಲೆ
ಎಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದೆ.
ಅಲ್ಲ, ಕೆಳಗೆ ಇದೆ, ಅದ್ರ ಕೆಳಗೆ ಕೊಟ್ಟೆ, ಇನ್ನೊಂದು ಸಪರೇಟ್ ಆಗಿದೆ.
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
ಹೌದು. Summons ordered before service of summons, my lord, SSP advocate appeared. Very same counsel appeared before the execution proceedings also, and he filed wakalat for the judgment debtors.
The original suit, as per my instruction, the PF was not paid, so that the suit summons was not ordered.
ಇದೆಯಲ್ಲ
SSB
suit summons.
My lord, kindly go through the execution proceedings also. Very same advocate has a
summons and an IA. Date was issued. Illenant ಬಂದು plaintiff by so SS. PF not paid ಅಂತ ಇದೆ. ಆರ್ಡರ್ ಆಗಿದೆ, TIA ಆಗಿದೆ. ಇಶ್ಯೂ ಸೂಟ್ ಸಮನ್ಸ್ ಅಂತ ಆಗಿದೆ.
Next, my lord, I would like
PF not paid ಅಂತಿದೆ, ಮತ್ತೆ ಬಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ SSB ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಅಂತ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೂ ನೋಡಿ ಒಂದ್ಸಲ, ಅದು
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬೇಡ, ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ನೀವು PF ಕೊಡದಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಹಂಗ್ ಬಂದು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಏನೋ ಫ್ರಾಡ್.
No, very same advocate, my lord, he is
ಸರಿ ರೀ, ಹೌ ಕ್ಯಾನ್ ಹಿ ಕಮ್ ಅಂಡ್ ಅಂಡರ್ಟೇಕ್ ವಿತೌಟ್ ಎನಿ ಇಶ್ಯೂಯನ್ಸ್ ಆಫ್ ಸೂಟ್ ಸಮನ್ಸ್? ಆರ್ಡರ್ ಶೀಟ್ ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು. ಆರ್ಡರ್ ಶೀಟ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ TI ಆಗಿದೆ, PF ಕೊಟ್ಟಿಲ್ಲ ನೀವು. ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಆದ ತಕ್ಷಣ ಇವತ್ತು ಕಂಪ್ಲೈ 39(1)
ಆಗಿರುತ್ತೆ.
ಇಲ್ಲಿ PF ಕೊಟ್ಟಿಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. SS ನೋಟಿಸ್ ಅಂಡ್ TI ಆಫ್ ಡಿಫೆಂಡೆಂಟ್, PF ನಾಟ್ ಪೇಯ್ಡ್ ಅಂತಿದೆ. ಇದು ಫಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಆರ್ಡರ್ ಶೀಟ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ. Now it appears to be mischief. How can an advocate come and voluntarily appear without suit summons, without TI order?
My lord, in compliance of 39(1) and 2.
No, counsel.
Notice.
Let the matter be decided on merits. That's all.
My lord, in compliance of 39(1)
The case of specific performance
intimation has been given to the parties. 39(1) and 2 complaints ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿರ್ತೀವಿ.
ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ.
ಅದನ್ನ I will furnish.
PF ಕೊಟ್ಟಿಲ್ಲ ನೀವು. PF ಕೊಡ್ಬೇಕಾ ಬೇಡ? ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಆದ ತಕ್ಷಣ
PF ಅಲ್ಲಿ ಕೊಡಬೇಕು, ಬಟ್ the same has been communicated.
And also ಕೋರ್ಟ್ ಇಂದ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ, ಸಮನ್ಸ್ ಹೋಗಿಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ ಗೆ. ಯಾರೋ ಒಬ್ಬ ಅಡ್ವೊಕೇಟ್ ಬಂದ್ಬಿಟ್ರೆ, ಇಬ್ರು ಅಡ್ವೊಕೇಟ್, ಪ್ಲೈಂಟಿಫ್ ಅಡ್ವೊಕೇಟ್, ಡಿಫೆಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಸೇರ್ಕೊಬಿಟ್ರೆ?
Very same advocate.
This type of fraud should not take place.
Let the matter be decided on merits. Kindly go through, my lord, the execution proceedings.
Execution
very same advocate has representing the judgment debtors.
Maybe. How can he come and voluntarily file? ಇದರಲ್ಲೂ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲುವೆ ವಾಲಂಟರಿನಾ? Execution petition 35 of 2013.
Five ten two thousand
Only we
thirteen
came
served
to know
ಆಗಿದೆ
all
ಅಂತ
these
ಇದೆ
things
ಅದ್ರಲ್ಲಿ.
after the death of the second defendant, please. my lord.
5/10/2013.
And the second
The
defendant is
summons
no
served.
more now. These LRs are fighting. We came to know all this transaction only after the death of the second defendant. Immediately thereafter, we filed an appeal.
Second defendant ಗೆ cause notice ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ.
Not been served. please.
Execution ಅಲ್ಲಿ.
Not been served.
Execution ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ.
5/10/2013.
ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ ಇಬ್ರುವೆ. Even that was a,
It's as per order 5, said once if any undertaking is taken subsequently.
Not undertaking ರೇ execution ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ ವಕಾಲತ್ ಎಲ್ಲಿದ್ದಾರೆ ಅವ್ರದ್ದು? D1 and D2 ದು?
ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ ತಗೊಂತೀನಿ.
ವಕಾಲತ್ ಇಲ್ವಾ?
ಇದೆ ವಕಾಲತ್ ಇದೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ ನೋಡೋಣ.
ಇಲ್ಲ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ ತಗೊಂತೀನಿ.
ಶ್ರೀನಿವಾಸ ಬಿನ್ ಗುರುಸ್ವಾಮಿ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅವ್ರ ಫಾದರ್.
ಹೌದು
ಕರೆಕ್ಟ್.
ಅವ್ರು ಯಾವಾಗ ತೀರ್ಕೊಂಡಿದ್ದು?
ಅಲ್ಲ ಅವ್ರಿದ್ದಾರೆ
ಇನ್ನು
ಅವ್ರಿದ್ದಾರೆ.
He has not filed any appeal.
Along with the LRs of the second defendant has filed preferred an appeal, please.
ಆಯ್ತ್ರಿ ನಿಮ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಇದಾರಲ್ಲ
ಇದ್ದಾರೆ.
ಅವ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ.
Only we came to know.
Execution ಅಲ್ಲೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ.
We had no knowledge at all, my lord. Maybe some mischief was done.
Mischief by you also?
Not maybe, my lord.
When you have signed the wakalat in execution petition, your father as well as your grandfather had signed the wakalat. In 2013 itself.
Execution petition.
When you filed why you filed the appeal in 2020? ಯಾವಾಗಿದು? 23 ಅಲ್ಲಿ.
23.
After lapse of 10 years.
Correct, please, my lord. The first appellant court made an observation that the issuance of
ವಕಾಲತ್ ಕೊಡಿ.
Issuance of suit summons itself is
execution ವಕಾಲತ್ ಕೊಡಿ.
Please.
ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ
ಮತ್ತೆ
or else record may kindly be called for, please.
Record ಕಾಪಿ ತಗೊಳ್ಳಿ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ MSc ಅಲ್ವಾ ಇದು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ನರ್ ಬರೀ ಅಪಲೇಟ್ ಕೋರ್ಟ್ನರ್ 1 page ಆರ್ಡರ್ ಬರ್ದವ್ರೆ.
Well, that's what suit summons was not issued. On that ground, it was remanded.
Where it is discussed with regard to the execution petition, service of summons.
ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ?
In the objection also, they filed
ಒಂದೇ ಪ್ಯಾರ ಆರ್ಡರ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Only the suit summons itself is not.
ಸರಿ ರೀ, ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ. ಅದು ವೆರಿ ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದೀರಿ.
That we have to.
That
we don't. There are no such documents to show that.
When we go through the order sheet of the trial court on 12/12/22, ex parte injunction was granted in favor of plaintiff respondent in the present case. Summons were ordered to be issued to the defendants. However, on 23/1/23, one advocate SSC undertakes to file wakalat for the defendant. At this stage, it is pertinent to note that the trial court has not issued any summons to the defendant. Subsequently, neither the defendants nor the advocate who undertakes to file wakalat appeared before the trial court. Thereafter, trial court by placing the defendant as ex parte and passed the judgment. As could be seen from the records of the trial court, there is no memo filed by the counsel to undertake to file wakalat. Only on oral submission, the trial court has passed the ex parte order against the defendants. When some were not issued and the counsel who undertakes to file wakalat not appeared and did not file wakalat and did not intimate. Where is the discussion with regard to the execution is concerned? You objections ಹಾಕಿದಿರಾ ಇದರಲ್ಲಿ?
In the objection also, they have not stated anything
delay
of execution.
ಹಾಕಿದ್ದೀನಿ.
Delay consider ಮಾಡಿದಾರಾ ಇದರಲ್ಲಿ?
Very same grounds, my lord, I have urged in the present appeal also.
The objection
delay ಇದೆ.
ಆ ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ರಿ RA 23 ನಲ್ಲಿ ಅವಾಗ ಡಿಲೇ ಇರ್ಲಿಲ್ವಾ?
ಡಿಲೇ ಇದೆ 11 years
ಡಿಲೇ 11 years
11 ವರ್ಷ ಡಿಲೇ ಇತ್ತು.
ಆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
The objection statement filed by the appellant herein is page number 52.
ಮಾಡಿದ್ದಾರೆ.
ನೀವು objections ಹಾಕಿದಿರಾ?
ಹೌದು ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ? ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಇಲ್ಲಿದೆ 11 ವರ್ಷದ್ದು.
They filed an objections to the main appeal, my lord. It's at page number 52. In page number 52, they have stated that
ಈಗ ಕೋರ್ಟ್ನವರು ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡುವಾಗ ಎಲ್ಲಿದ್ದಾರೆ ಆರ್ಡರ್? ಡಿಲೇ ಕಂಡೋನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಅದನ್ನ
ಸಪರೇಟ್ ಆರ್ಡರ್ ಮಾಡಿದಾರ? ಎಲ್ಲಿದೆ ರೀಸನ್? ಅದ್ರಲ್ಲಾರು ಇದೆಯಾ? ಅಟ್ ಲೀಸ್ಟ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರೆ. ನೀವು ತಕರಾರು ಹಾಕಿದೀರಾ?
ತಕರಾರು ಹಾಕಿದ್ದೀನಿ.
ನೋಡಿ ಅದು ಕೊಡಿ ನೋಡ ತಗೊಳ್ಳಿ ಇಬ್ರು ಕೊಡಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 37.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೈಂಡ್ಲಿ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನಿದೆ?
ಇದೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲಿಲ್ಲ. 3/4/2025 there was an order.
3/4/25 ಆರ್ಡರ್ ಇದೆಯಾ? ಏನ್ ಆರ್ಡರ್ ಇದೆ?
Last date it was not extended.
ಇದೆಯಾ ಮೇಡಮ್ ನೋಡಿ ಇದೆಯಾ? ಆಯ್ತು, interim order granted earlier is extended till next date of hearing.
55.
My lordships, appellants in this matter, in both the matters, my lordships. An humble request, can I seek for a short adjournment, my lordships?
Why, counsel?
My senior is not doing well, he's still recovering from fever. 25th next week, my lordships.
Other side are? Told appellant counsel seeks time on the ground of ill health. Ill health.
Either Swami, he's not well. Hushariilla Swami.
ಅದನ್ನೇ ಕೇಳಿದ್ದು. Ill health ಅಂದೆ, ill health.
Ill health.
And counsel for R7 and 8, 5 and 6 present, R3 and 4.
Your Honor.
Idara?
3 and 4.
3 and 4 also present, and counsel for R7 and 8 absent. Is this matter on?
25th, my lordships.
25/6.
Pledge, my lord.
56. Harshendra.
Harshendra.
I appear on behalf of the counsel for the petition of please. The advocate on record, he is unavailable, please, my lord. He's met with an accident. He's been hospitalized.
Yavaga?
Friday, 6th of this month, he met with an accident. He's still in the hospital.
Your proxy?
Yes, please.
Proxy counsel Sri?
Shamant SN.
Shamant?
Yes, please.
Initial ena?
Yes, N.
SN. Submits that counsel on record is met with an accident and he is hospitalized, and hence list this matter. ಎಷ್ಟು ವಾರ ಬೇಕು? 2 ವಾರ. ಯಾವಾಗ ರಿಕವರಿ ಆಗ್ತಾರೆ? ಏನ್
For 3 months he will be out of.
ಮೇಜರ್ ಇಂಜುರೀಸ್ ಏನು?
Major injuries ಅಂದ್ರೆ ಕಾಲ್ ಮುರಿದಿತ್ತು, ಏನೋ ಸರ್ಜರಿ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
3 weeks.
3 weeks.
List this matter on 14/7.
Much of.
57.
Srinivas Rao CN. ಬೆಳಗ್ಗೆ ಯಾರ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಏನೋ ಮಾಡಿದ್ರು ಕೊಡಿ. ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿದೀವಿ. ಅಪೀಲ್ ಡಿಸ್ಮಿಸಲ್ ಆಗಿ ರೆಸ್ಟೋರ್ ಆಗಿರೋದ? This appeal was filed on 15/11/21, and thereafter office objections was not complied, and subsequently the appeal was dismissed on 23rd day of April 2024, and also filed an application for restoration. It kodi judgment kodi and concurrent pending kodi, and subsequently applications are filed, and the same are also considered, giving an opportunity to comply with office objections. And dismissal order was also recalled. The counsel, though filed the appeal in 2021, is not pursuing the matter diligently. This appeal is filed against the concurrent finding. In view of compliance of office objections in previous occasion on 9/6/25. Earlier, and also when the matter listed before this court on 9/6/25, this court wide order dated 2/6/25 had ordered to list the matter for admission, and there was no representation. And taking into note of the same also, in both the occasion in the early morning and also in the afternoon did not appear. An opportunity is given to the appellant counsel and made it clear that if the appellant counsel doesn't appear on the next date of hearing, the appeal will be dismissed. In spite of this order, the appellant counsel is not pursuing the matter and has no grounds to adjourn the matter. And in view of the earlier order, the appeal is dismissed.
58, Anusha L.
Non-filing of amended cost title.
Two more weeks time.
Huh?
maybe. 2 more weeks time maybe.
Okay, no date. ಹೇಳಿ ಏನು?
ಯಾಕಂದ್ರೆ I was not the person who filed the appeal. I did not file the appeal. I have come as an LR of the first appellant. So I have to secure the appeal copy.
The appellant counsel seeks time on the ground that he is appearing on behalf of the LRs of proposed appellant number 1 and not having the records. And counsel for R1 to 6 is present. And list this matter on 27/6.
Much.
59, MB
Chandrachud.
Janardana G.
Divergent pending ಇದೆ records ಬೇಕಲ್ಲ? Divergent pending ಇದೆ records ಬೇಕಲ್ಲ ಅಂದೆ.
ಬಟ್ ಅವರು ಆಶ್ರಯ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಕೇಳಿದಾರೆ ಪೊಸಿಷನ್. ಇಟ್ಸ್ ಎ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಇನ್ ಪೊಸಿಷನ್ ಆಫ್ ಅಫಿಷಿಯಲ್ ಲಿಕ್ವಿಡೇಟ್. ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ 10 acres 33 ಗುಂಟ.
Earlier suit was
ಅವನು ಕೇಳ್ತಿರೋ 1500 ಅಡಿ.
Earlier suit was dismissed and now reversed.
Earlier suit was dismissed ಅಂದ್ರೆ ನಮ್ಮ ಹೆಸರು 2 ಡಿಗ್ರಿ ಇದೆ ನಮ್ಮ ಹತ್ರ. ಮೊದಲು earlier proceedings some other lady was started.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗ್ತದೆ. ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಲುಕ್ ಇನ್ ಟು ದಿ ಮೆಟೀರಿಯಲ್ ಅಂದೆ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ.
May not necessary, not only sketch is disputed, but that sketch I could able to place it. I have a certified copy.
ಹೇಳ್ರಿ ಏನ್ರಿ ಚಂದ್ರಚೂಡ್? ರೆಕಾರ್ಡ್ಸ್ ಬೇಡ ಅಂತಾರ ಅವರು.
ಸ್ಕೆಚ್ ವಿಚಾರ ಪೊಸಿಷನ್ ವಿಚಾರ ಸ್ಕೆಚ್
ಆಗುತ್ತೆ. The liquidator filed a suit. How the liquidator came into possession of the property is the question.
Suit for bare injunction.
Suit for bare injunction. What is the capacity of a
documents in the exhibit P1 to 25?
What is the capacity of a liquidator to came in possession of a property?
So this matter is listed for admission and the first instance suit was dismissed and the same is reversed in the first appellate court. And hence it requires records of trial court and appellate court and list this matter for admission along with both the court records on 21/7.
Interim order to continue.
Interim order is already. Interim order granted earlier is extended till next date of hearing. ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ ಅಂತಲ್ರಿ, ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು. ಮೇಂಟೈನ್ ಸ್ಟೇಟಸ್ ಅಷ್ಟೇ. ಆಯ್ತು ಅಷ್ಟೇ. ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತಿಲ್ಲ, ಮೇಂಟೈನ್ ಸ್ಟೇಟಸ್ ಅಂತಿದೆ ಅಷ್ಟೇ.
60 I speak Kulkarni.
But I have for the appellant short accommodation for this ground.
Counsel, morning I have refused.
Please.
Again, don't seek time.
What happens? My submission is it was dismissed for non-compliance. It was restored by this court.
ಆಯ್ತು.
What happens?
ಆದ್ರೂ ಕೋರ್ಟ್ ಎಲ್ಲ ಲೀನಿಯನ್ಸ್ ತೋರಿಸಿದೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು
ರೆಸ್ಟೋರಿಂಗ್ ಯುವರ್ ಅಪೀಲ್ ಆಲ್ಸೋ.
I only appeal copy judgment ಇದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನತ್ರ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ 21 ಮ್ಯಾಟರ್ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ.
21 ಮ್ಯಾಟರ್ ಆದ್ರೇನು 21 ಅಲ್ಲ ನೀವು ಒಕ್ಕಲ ಸೈನ್ ಮಾಡಿದಿರಿ, ಹೌದಾ?
ಹೌದು ಸರ್.
ಮತ್ತೆ ನಾವು ಯು ಕ್ಯಾನಾಟ್ ಸೀಕ್ ಟೈಮ್.
ಅಲ್ಲ ನಾನು WS
ಏನು ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಹಿಯರ್ ಬೈ ಡಿಸ್ಮಿಸ್ಡ್ ವಿತ್ ಕಾಸ್ಟ್ ಅಪೀಲ್.
ಅಲ್ಲ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು I will make some next week. I will only argue the matter.
Got the right of easement over the same.
Where the defendants and the place ನಾನು ಏನ್ ಕಂಟೆನ್ಷನ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ.
ಅಲ್ಲ ರೀ, ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಆಫ್ ಕಾರ್ಡ್ ಟ್ರ್ಯಾಕ್ as described in suit schedule and the plaintiffs have got right of easement over the same.
Contentions in WS ಅನ್ನತ್ರ ಇಲ್ಲ.
ನೀವು ಅಲ್ಲಿ ಹೋಗಕ್ಕೆ ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಅವನು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ರೆ ನಾನು I will go through ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ನಾನು ತರ್ಸ್ಕೋತೀನಿ.
ನಿಮ್ಗೆ ಓದಕ್ ಟೈಮ್ ಇಲ್ಲ, ಕೋರ್ಟಿಗೆ ಟೈಮ್ ಇದೆ ಓದಕ್ಕೆ.
ಸಾರಿ ಅಲ್ಲ ನಾನು ಡಬಲ್ ಎಸ್ ಏನಿಲ್ಲ, ನಾನು ಸ್ಪೆಸಿಫಿಕ್ ಕಂಟೆನ್ಷನ್ ಇದೆ ಅಂತ ನಾನು ನೋಡ್ತೀನಿ. ದಟ್ಸ್ ರೀಸನ್ ದ ಡಿಫೆಂಡೆಂಟ್ಸ್. ನೆಕ್ಸ್ಟ್
ಪಶ್ಚಿಮ ಭಾಗಕ್ಕೆ ಬಂಡಿದಾರಿ ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಲಡ ವಿತೌಟ್
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಅದೇನ್ರಿ
Whether there is existence of cart rock or not as alleged by the plaintiff, the said IA came to be allowed. Appointed court commissioner, there exists existence of cart track road. ಎಲ್ಲ ಇದೆಯಲ್ಲ
ಅದ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿ
ಎಲ್ಲ ಕೋರ್ಟ್ ಇವನ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡೆ ಕೊಟ್ಟಿರೋದು ಈಸ್ಮೆಂಟ್ರಿ ರೈಟ್.
ಅದು ಕನ್ಫರ್ಮೇಶನ್ ರಿಪೋರ್ಟ್ ಅನ್ನತ್ತಾರೆ.
Therefore he has submitted his sketch as per exhibit P8. The court perused exhibit P8 wherein clearly shown by the court commissioner that there is an existence of cart track road towards the eastern side of the property of Parvatappa and defendants. Plaintiff's property is in so and so, which has been shown in so and so. Therefore the court commissioner also submitted his report regarding existence of cart track which has been shown as ABCD in exhibit C8.
ಅಲ್ಲ ಅದನ್ನೇ ನಾನು ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿ ಹೇಳ್ತೀನಿ. ಸರಿ ವಿತೌಟ್ ಟಿಕೆಟ್ ಇಸ್ ಪಾರ್ಟೆಡ್. ಐ ವಿಲ್ ಆರ್ಗ್ಯೂ.
Defendant counsel cross examined the court commissioner but nothing was elicited in to disprove his report.
ಅಲ್ಲ ಅದು ಎವಿಡೆನ್ಸ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಸರ್. ವಿತೌಟ್ ಫೇಲ್ ನೆಕ್ಸ್ಟ್
ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಇಟ್ಕೊಂಡು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನಾನು ಮಾಡ್ತೀನಿ. ಟೇಕ್ ಇಟ್ ಆಸ್ ಪಾರ್ಟೆಡ್
ಕೌನ್ಸಿಲ್
ರಿಕ್ವೆಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಐ ವಿಲ್
ಎಲ್ಲ RSA ಹಾಕೊಂಡು ಕೂತ್ಕೊಳ್ಳೋದು. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದು ಅದು ಪರ್ವರ್ಸಿಟಿ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಆ ಪರ್ವರ್ಸಿಟಿನೂ ಇಲ್ಲ, ಏನು ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಬರೋದು
ವಿತೌಟ್ ಫೇಲ್ ಐ ವಿಲ್ ಆರ್ಗ್ಯೂ ದಮ್. ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಹೋಗ್ತಾರೆ, ಸ್ಪಾಟ್ ನೋಡ್ತಾರೆ, ಕಾರ್ಟ್ ರೋಡ್ ಇರುತ್ತೆ, ಈಸ್ಮೆಂಟ್ರಿ ರೈಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೂ ತಕರಾರು. ಇನ್ನು ನೋ ಗ್ರೌಂಡ್ಸ್, ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್.
Next week I will argue the matter on merits. Please, humble request. I will get the trial court and I will go through and I will make submission and I will leave it to the court. Take it as parted.
Appellate court also considered the material and also the admissions as well as the commissioner report. Nothing is there to decide in second appeal.
Next week I will go through it.
Third, this appeal is filed in 2021 and the same is also against the concurrent finding. With regard to the existence of cart track road and easement right is granted and also the permanent injunction is granted, and appellate court also having considered both oral and documentary evidence available on record, and particularly both the courts taken note of commissioner report. Commissioner report also very clear in terms of exhibit C8 that there is a cart road, and the same is also considered by the appellate court, and when such material available on record, there is no any perversity in the finding, and hence I do not find any ground to
next week I will argue
and frame any substantive question of law.
Next week, sorry, please madam.
No counsel.
Please, I will argue the matter.
Dismissed. ಏನಿಲ್ಲ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನಾನು
ನೀವು ಓದ್ಲಿಲ್ಲ, ನಾನು ಮತ್ತೊಂದ್ಸರಿ ಓದ್ದೆ. ನಾನು ಓದ್ ನೋಟ್ಸ್ ಮಾಡಿದ್ದೆ, ಮತ್ತೊಂದ್ಸರಿ
ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ
ನೋ ಕೌನ್ಸಲ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನಾನು ಮಾಡ್ತೀನಿ ಸರ್. ಮೈ ಲಾರ್ಡ್ ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
ಇನ್ ದ ಪ್ರೀವಿಯಸ್ ಅಕೇಶನ್ ಏನಾಗಿದೆ ನೋಡಿ.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ನಾನೇ ಅಪೇರ್ ಆಗಿದೆ, ವಿತ್ಡ್ರಾ ಆಯ್ತು, ರೀಕಾಲ್ ಆಯ್ತು, ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಯ್ತು, ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಯ್ತು. ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಅಡ್ಮಿಷನ್ ಇತ್ತು.
So the appellant counsel seeks time even though this second appeal was filed in 2021 and hence on cost of rupees 10,000 urgent to ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
ಫಸ್ಟ್ ವೀಕ್
ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜುಲೈ.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜುಲೈ and cost is payable at registry.
10,000
on
cost may be reduced
37
10,000 baht.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಸೆಕೆಂಡ್ ಅಪೀಲ್.
Kindly reduce the cost.
No reduction.
61 action 62 BN Shetty.
For a respond, my lord.
Alexandra people.
I haven't been served with a copy of the IAF filed by the appellant, my lord. Haven't been served with the copy of the.
Not been served.
No.
Copy, entire petition is served. I filed a memo, my lord. Last kindly see that.
I have twice I have sent an email to them saying only the copy of the appeal has been served, but not the copy of the application, my lord, which is being filed.
I will serve it.
IA 1/24 ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್,
ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ, ಬಟ್ if ಸರ್ವ್ ಆಗಿಲ್ಲ ನಾನು
I repeatedly have sent emails to them. Twice I have sent emails.
ಕಳಿಸ್ತೀನಿ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಆಯ್ತು.
Twice I have sent an email saying
allow me to verify.
Yes.
1/24 ಇದೇನ್ರಿ ಇದು ಸ್ಕ್ರೂಟಿನಿ ಬ್ರಾಂಚ್. ಕೊಟ್ಟಿಲ್ವಾ? ನೀವ್ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದಿರಿ ಕಾಪಿನ?
ಅಲ್ಲ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದಲ್ಲಿ
ಯಾವಾಗ?
along with that.
Memo of service,
Yes.
Only appeal copy has been served, my lord. That's it, my lord.
23rd February ಗೆ ಫೈಲ್ ಮಾಡಿದ ಮೆಮೊ.
ಏನ್ ಇಮೇಲ್ ಕಳ್ಸಿದ್ರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಸಾಫ್ಟ್ ಕಾಪಿ ಕಳ್ಸಿದ್ದಾರೆ, ಬಟ್ ಅಪೀಲ್ ಮಾತ್ರ ಇದೆ, ಕಾಪಿ ಇಲ್ಲ.
If it is not so, I will furnish copy, one more copy my lord. That is not a problem.
Also they
ಹೇಳಿರಾಗೋಗ್ತಿತ್ತಲ್ವಾ?
ಅಲ್ಲ ನಾನು ಹೇಳ್ದೆ ಕಾಪಿನ ಬಂದಿಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ ಒಂದು more.
Twice have sent an email, my lord, despite that.
Respondent Kvator counsel submits that only appeal memo, copy of the appeal memo is sent through email, and copy of IA 1 of 24 is not sent, and hence appellant counsel is directed to serve the copy of IA number 1 of 24 on the counsel for the Kvator forthwith.
Yes, ma'am.
List this matter on. ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
I mean medical treatment ಇದೀನಿ ಸ್ವಾಮಿ, ಒಂದು 2 weeks ಟೈಮ್ ಕೊಡಿ.
ಅದೇ 3 ವಾರ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, 3-7 ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ.
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ.
ಹಾ.
53.
ಗಂಗಾಧರಪ್ಪ ಎವಿ, ಸದಾಶಿವಪ್ಪ ಕೆಜಿ. PI granted reversed. ಇದು ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ತೊಳಿ. This appeal is filed against the divergent finding and hence records are necessary. Registry is directed to get the records of the trial court and appellate court and list this matter on 21/7.
64. Appear for
P.
the
Whatever.
The state, my lord.
State,
State, my lord.
I prefer appellant.
AGA R1 has not filed MA. ಹೇಳಿ counsel ಹೇಳಿ.
Plaintiff's appeal. Concurrent finding. The case of the appellant is that plaintiff is that the survey number 73 was totally measuring 546 acres 30 guntas, out of which 7 persons were in unauthorized occupant, including the appellant hearing. They filed the application seeking for regularization, and 7 persons were regularized. 4 acres each acres was regularized in respect of 7 persons,
including you,
including the appellant hearing. And in the meantime, a notification was issued notifying 355 acres as forest land in the very same survey number. And we filed after Sagula chit was issued in favor of the all 7 applicants, and all 7 applicants also filed the suits as against the respondents hearing. And this, in respect of this appellant hearing, the trial court as well as the lower appellate court dismissed the suit on the premise that the forest land cannot be granted, and also on the ground that
ಪ್ರಕಾರ notification ಆಗಿದೆ ಯಾವಾಗ?
Notification is earlier, your lordship, that is exhibit D9.
Forest land ಅಂತ notification ಆಗಿದೆ ಯಾವಾಗ?
17/12/1982.
1982. ನಿಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಯಾವಾಗ?
2011.
ಮತ್ತೆ ಹೇಗಾಗ್ತದೆ? How can they grant the land in the year 2011?
Total extent of
land.
Total extent of land in that survey number is 546 acres 30 guntas.
ಆಗ್ಲಿ.
ಅಲ್ಲ ನಾ ಹೇಳ್ತಿದ್ದೀನಿ, ಅದ್ರೊಳಗೆ ಏನಾಯ್ತು ಅಂದ್ರೆ ಬ್ಲಾಕ್ ನಂಬರ್ 1 ಒಳಗೆ 78 acres ನೋಟಿಫೈ ಆಗುತ್ತೆ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಅಂತ. ಬ್ಲಾಕ್ ನಂಬರ್ 2 ಒಳಗೆ 277 acres ಆಗುತ್ತೆ. ಟೋಟಲ್ 355 acres ಫಾರೆಸ್ಟ್ ಅಂತ ರಿಸರ್ವ್ ಆಗುತ್ತೆ. ಅದರ್ ಎಕ್ಸ್ಟೆಂಟ್ 140 acres is remained with the revenue department.
Is it your case that
this area does not falls under within the notified area ಅಂತಾನೆ? ಅದಕ್ಕೆ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ against the Sagoli chit, challenging the Sagoli chit, the forest department has preferred an appeal before the assistant commissioner, and during the pendency of the suit the assistant commissioner set aside the Sagoli chit and remands back to the committee to verify whether these properties fall within the area of the forest land or not. Till today, no survey has been conducted and no further steps have been taken. In an identical matter in respect of other applicants, the matter have come up before this honorable court, and this honorable court has decreed the suit on the ground, the lordships, from para 12 onwards, in respect of very same survey number. Finding starts from paragraph 18, your lordships. Facts from paragraph 12. Very same exhibit D14 is relied by this honorable court. That is the order of remand passed by the assistant commissioner. paragraph 18, your lordship may read. Exhibit D14 is the order dated,
And madam, why it was not examined?
and we have given our consent to hold the joint survey. But till today, no joint survey has been conducted and no steps have been taken. All those things have been observed by this honorable court while allowing the appeal at paragraph 18 and 19.
New party in adrally.
Section,
Exhibit D14, I am also one of the
You are also a
party.
party.
I am also one of the party.
No joint survey was conducted.
Till
for the
today,
reason
no,
just
they have
told.
not conducted. And it is a suit for injunction. Issuance of Shagol Street itself shows that I was in possession of that property.
Revenue records ಎಲ್ಲ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆ.
ಹೌದು,
It's a
ಖಾತಾ
bogus
ನನ್ನ ಹೆಸರಿಗಾಗಿದೆ.
it's a bogus Sagoli chit, my lord, issued by the Tahsildar Shivamogga. The revenue department has no power with the Sagoli chit, my lord. Because in respect of forest, hence the Sagoli chit issued by
No
the
such finding, madam, in the order, exhibit D14.
Yes, my lord.
Assistant Commissioner allowed the appeal and remitted back the matter to the concerned authority to survey the land
Yes, my lord.
and examine whether the land comes within the notified area or this property is other than the notified area.
It's a reserved forest area, my lord, section 24.
ಸರಿ ಮೇಡಮ್, ಅದನ್ನ ರಿಮೈಂಡ್ ಆಗಿದೆಯಲ್ಲ, ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ನೀವು? ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ 2012 ಅಲ್ಲಿ ಆಗಿರೋ ಆರ್ಡರ್ ಇದು.
Revenue authority has no power with the forest department.
You are also a party in exhibit D14.
Exhibit D14, I am also party.
It's a reservation forest area.
ಅರ್ಥ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೀನಿ ನಾನು.
Yes, ma'am.
You only challenge the grant before the assistant commissioner. ಹೌದಾ? Assistant commissioner set aside the order of grant
Yes, ma'am.
and directed to survey the land whether it comes within the notified area or not. Why you have not surveyed the land and obtained the report whether it comes within the notified area or not?
I'll secure the instructions, my lord.
ಈಗ ಆಲ್ರೆಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್, ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ನಮ್ ಕೋರ್ಟ್ನವರೇ ಮಾಡಿದಾರಲ್ಲ. ಕಾಪಿ ಕೊಟ್ರೇನ್ರಿ ಅದರ್ ಸೈಡ್ಗೆ?
ಕೊಟ್ಟಿದೆ.
Appellant counsel furnished the copy of the order passed by this court in regular second appeal 1614 of 2019 to the counsel appearing for the state. AGH 6 time to
1 week time.
verify and submit. List
1
this
week
matter
time.
on ಯಾವಾಗ ಬೇಕು? 1
1
week.
week.
Totally 27/6.
Acha.
65 AV Gangadharappa.
Suit for partition by the sisters. Kindly see the genealogical tree which I have produced along with the memorandum of appeal. One Hulgappa was the propositus. He died on 28/10/1992. 1992.
92.
Except defendant number 1, that is Sridhara. Others, kindly see, Sulochana died unmarried, Manju died unmarried, and plaintiff is Suvarna. Defendant number 2 is Sushila. So as on the date of death of the father, except Sridhara, there was no other person because all the daughters were married and they were living in their respective husbands. Now, two contentions I am urging before this honorable court. Number 1 is, for the purpose of marriage of these daughters, some of the properties were sold and there was debt which was required to be discharged by the appellant. Accordingly, it was discharged. So no concession has been made by the courts below. Now, secondly, I would like to submit before the court. Now, the death is on 28/10/1992 when the father died, leaving behind the sole surviving son. If there were to be a notional partition as on the date of death, son would be entitled to half share and the other half share will have to be divided amongst all the class 1 heirs. In other words, these daughters will be entitled to only 1/6 share. Now, the courts below have granted equal share to the son as well as the daughters. That is the error committed by the courts below in ignoring the fact that the death of the father had taken place much prior to the Amendment Act came into force. If there were to be a notional partition, the son would be entitled to half share and father will be entitled to half share. That half share will have to be divided amongst the son and the daughters. So they will be entitled to only 1/6 share. This aspect of the matter has not been taken into consideration by the courts. That is the substantial question of law I have framed before this honorable court in the second appeal. B and C may kindly be noticed at page 8 and of the memorandum of appeal. B and C are the substantial questions of law which are required to be considered by the High Court in the second appeal.
ಆಯ್ತು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಆಗಿರೋದಲ್ಲ ಯಾವ ಇಯರ್ ಅಲ್ಲಿ?
That is prior to the death of the father. Properties were sold. Some of the properties were
Now
sold.
they are not claiming any right in
No,
respect of
they
the
are not
properties are
claiming
sold.
any.
Only in respect of remaining properties are
Only one
concerned.
property. That is only one property, 3 acre 9 guntas. These daughters are married. They are comfortably living. They don't require. It's only out of vengeance this suit has been filed. In fact, they gave a statement before the revenue authorities that they have no claim in respect of the property, and because he is the only youngest brother. So they have given an affidavit to the effect.
Affidavit will not
Affidavit will not
fit their right.
Yeah, that's right. But what I submit before the honorable court is, these are all the facts that should have been taken note of by the courts below while passing the.
That has been discussed by both the courts. Sale were taken place long back.
That's what
1979 ಗಿಂತ ಮುಂಚೆ. Father and mother died intestate, leaving the children, daughters and also the son. And hence they are entitled for equal right, that's all.
No, my submission is if there were to be a notional partition prior to the death.
How could be a notional partition?
Prior to the death.
When
As on the date of.
Both of them left the children.
No, that's right. As on the date of death of the father. Mother died prior to the death of the father and father died in 1992. So this Amendment Act was not in force and it was never been constituted.
Even though no amendment, there was no any documentary proof regarding partition or
No,
anything.
I am not claiming that there was. I am not
Then
claiming
if
there
not
was
this-
any partition, but all that I submit before the honorable
Then
court is-
automatically the daughters and also the
Yeah,
sons
they
are
will be the
entitled.
class 1 heirs, no doubt. But I submit before the court, if there were to be a notional partition immediately prior to the death of the father,
The question of
the son
notional
will be
partition
entitled
also,
to half share.
question notional partition also doesn't arise.
Notional partition does
This-
arise, it has to be.
This matter is
considered.
listed for admission. I heard the counsel for the appellant. This appeal is filed against the concurrent finding. The suit is filed for the relief of partition and separate possession. That is one of the daughter.
Other daughter remained ex parte before both the courts.
Another daughter remained ex parte. And claim made in the suit that suit settled property belongs to her father, Ulagappa, and Srimati Durgamma, and along with her brother Sridhar constituted Hindu undivided joint family consisting of joint family suit settled property and after the death of their parents, she is also entitled for a share in the social property. The defendant appeared and filed the written statement contending that Pulakappa, in order to perform the marriage of plaintiff and defendant number 2, sold 3 acres 18 guntas of land in survey number 23 of Hosakote village in favor of the purchaser in the year 1992 for meager sale consideration of rupees 12,000 and also borrowed hand loan for the marriage expenses. And after his death, his son Sridhara repaid the loan amount out of his salary, and as such plaintiff is not entitled for any share in the suit settled property. The plaintiff, in order to prove her case, examined herself as PW1 and got marked document exhibit P1 to 5. That is, exhibit P1 is the genealogical tree, exhibit P2 and 3 are the mutation register extract, P4 is the RTC extract, exhibit P5 is the record of right. The defendants, in order to defend their claim, the defendant number 1 has examined herself as DW1 and 2 witnesses by name Lakshmanappa, Basappa and examined as DW2 and 3 and got marked document exhibit 1 to 3. The trial court, having considered the case of the plaintiff and also the defendant and also the original documents and also the documents which have been placed before the trial court, comes to the conclusion that the property belongs to their parents, Ulagappa and their mother, and also taken note of the evidence of DW2 is not believed regarding DW2 has not at all stated how much loan was borrowed by Huligappa, what was the sale consideration, nothing has been disclosed. And also taken note of section 91 and 92 of the Indian Evidence Act. Whenever a document is reduced in the form of writing, then the document is alone is admissible in evidence and no other evidence can be given with respect to the contents of those documents. And also discussed in detail even if the property is sold for clearing the debt, then also it amounts to performance of an obligation and the same is sold for legal necessity, and comes to the conclusion that property belongs to the family and the very contention of the defendants that he had cleared the loan is not been proved. And regarding claim is concerned of 1/3 share also, while answering the point number 1 in detail discussed, and comes to the conclusion that they are equally entitled for the share and decreed the suit granting 1/3 share. The said order is challenged before the appellate court in RA number 47 of 22. And appellate court, also having reconsidered the grounds urged in the appeal as well as both oral and documentary evidence, formulated the point whether the defendant number 1 proved that the other joint family properties were sold for meeting the marriage expenses of the plaintiff and defendant number 2, due to which plaintiff and defendant number 2 have no right to claim share over the property, whether the judgment is requires interference of this court. The appellate court, also having reassessed the material available on record with regard to the claim of 1/3 share as well as documents considered, in paragraph number 17 taken note of that there is no dispute with regard to the relationship between the parties, and also taken note of that properties were acquired by Hulagappa from his father and they are the joint family properties. The defendant number 1 do not assert the suit properties as the self-acquired property. However, only contention taken by the defendant number 1 is that since other joint family properties were sold for meeting the marriage expenses of the plaintiff and defendant number 2, they have no right to claim their share over the property. Having taken note of this issue also, This point for consideration also discussed the evidence of DW 1 and 2 and also the PW 1, and also comes to the conclusion that the marriage of defendant number 2 was during the year 1979, whereas marriage of the plaintiff was during in the year 1985. The sale of property by Durgamma and Sridhara was subsequent to 1992, when there was huge gap between the date of marriage and sale transaction. One has to doubt the sale of property for meeting the marriage expenses, and taken note of this aspect into consideration in paragraph number 21 and 22, made an observation with regard to the marriage was taken place long back, and also even discussed in detail that there is no any registered instrument has been obtained either from the plaintiff or from the defendant number 2 for relinquishing their right over the social property while selling the other properties. The appellate court also considered the discussion made by the trial court as well as the first appellate court in paragraph number 23, comes to the conclusion when the property has been sold for family necessities, it is found binding on all the sharers. Hence, it cannot be a ground to say that in respect of other properties, the co-partners have no right to claim share. Having considered both oral and documentary evidence, appellant court also reassessed the material available on record. However, the counsel appearing to the appellant would vehemently contend that when the father died in the year 1992, if property is divided between the father and son, and half share father got, there would be a notional partition, and the son as well as the daughters are equally entitled for a share. And then this court has to frame substantive question of law. The counsel also would vehemently contend that allotting equal share to the plaintiff without noticing the fact that some portions of the family property were sold during lifetime of father for legal necessities, such as meeting the marriage's expenses of daughter, is an erroneous finding. And also, both the courts have not justified the fact that when the father died on 28/10/1992, that the daughters were married long before, and coparcenary property came to the hands of the husband of the first appellant as sole surviving coparceners, and there cannot be any 1/3 share. Having considered the grounds urged in the appeal, as well as the reasoning of the trial court, and no dispute with regard to the relationship between the parties, both the courts also taken note of the fact that property was sold subsequently, and marriage was taken place in the year 1979 and 1985 about the plaintiff and defendant. And even though specific defense was taken that property was sold for the marriage expenses of both the daughters, and both the courts not accepted the contention, and the fact finding was given by both the courts that the same cannot be accepted. And even the appellate court also reassessed the material and reasoning given by the trial court, as well as in the paragraph number 23 also taken note of the Mullah's Hindu law, where it is also held that marriage expenses of a male co-partners and daughters of co-partners is a family necessity. And even observed that even if the property has been sold for meeting the marriage expenses of the daughter, it has to be said as for family necessity. When the property has been sold for family necessities, it is binding on all the sharers. Hence, it cannot be a ground to say that in respect of other properties, the co-partners have no right to claim share. In the case on hand, having sold the property, subsequent properties which are available to the family, equal share has been given, and hence such reasoning is given by the trial court as well as the appellate court. And the very contention that allotting of 1/3 share is also erroneous cannot be accepted. And the fact that both the husband and father, both the father and mother died in the year 1992 is not in dispute, and subsequently property belongs to the family is also not in dispute. When such being the case, the daughters and also a son entitled for equal share over the social property, and hence the contention of the appellant counsel cannot be accepted, and not find any substantive question of law as contended by the appellant counsel. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
Onkar KB.
Hmm.
Nagaraj
For the
Rao.
petitioner herein, my lord,
Yes.
I seek 10 days time, my lord. The senior on record counsel is not in town, my lord.
Hmm. Not in town.
Please, my lord.
Date given matter, counsel?
My lord, 10 days time may be granted.
No, counsel. Date given matter and the abruptly bandanta case alla.
Please, my lord. There is a divergent finding in the matter. On the previous date, the other side counsel had precipitated to not to interfere in the matter. The execution has been filed, my lord.
Order sheet kodi. ಹೌದು ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಮತ್ತೆ ನೀವ್ ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಿ? Why you are seeking time?
Please, the execution also is filed. It is stated for steps, my lord, on 14th of July.
Records ಬಂದಿಲ್ಲಲ್ಲ ಮೇಡಮ್? So, registry is directed to get the records of the trial court and appellate court and list this matter on 8/7.
67.
Appellant counsel also seeks time ಅಂತ ಹಾಕ್ಬಿಡಿ. On the ground that counsel on record is not in station.
67.
Yes,
For the appellant in this case.
Umesh B and ಹೇಳ್ರಿ.
Plaintiff's appeal, my lord. Suit for declaration, my lords. Declaring that the plaintiffs are the.
She is not a legally wedded wife.
Please, my lords. The trial court decreed the suit in part.
Issue notice against the respondent and call for records of both the courts.
My lords. Sought for an interim relief, my lord. They are about to withdraw the amount, my lord.
List this matter on
21.
21/7. ಏನು ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ ಅಮೌಂಟ್?
Death benefits.
Death benefit.
Please, me. Mother is also a party, me.
Heard on IA number 1 of 25. And suit was at the first instance dismissed. Coming to the conclusion.
Decreed. Suit decreed, me.
Decreed.
Please, me. In the appeal, suit has been dismissed.
Dismissed.
Partly decreed.
Partly decreed.
Please, me. Holding that she is not the legally wedded
Partly
wife.
decreed that.
She is not the legally wedded
She
wife.
is not the legally wedded wife of late Ramachandra Murthy.
Please. In the appeal, my lords, reverse.
And in the appeal, and the same is?
Entire suit has been dismissed. Holding that she is legally
Reversed.
wedded wife. Please.
And the suit is dismissed. Now the counsel would vehemently contend that in view of dismissal of the suit, the respondents.
First respondent.
First respondent matrana?
Houdu.
First respondent may withdraw the benefit?
Death benefits.
Death benefit of
Ramachandra
Ramachandra Murthy. And having considered that there is a divergent finding, it is appropriate to stay the
No. Injunction, my lord, not to disperse the amount. The other respondents are the authorities, my lord. Employers.
Earlier order itta nimge suit hakdaga
Suit ಹಾಕ್ದಾಗ
ಇರ್ಲಿಲ್ಲಲ್ಲ.
Not to disperse and then we have challenged the legality of our wife status, my lords. Now court was decreed saying that she is not legally wedded wife. Now the appellate court has reversed that order, my lord. Now they are going to withdraw the amount.
And in view of the divergent finding, the
not to disperse the
number,
amount.
new restraint, respond number 2 to 4.
Please.
Are restrained from releasing the schedule service death benefits of deceased Ramachandra Murthy in favor of the respond number 1.
Please.
Till the next date of hearing.
Please.
68. Devkumar HB.
Devkumar HB.
Appellant, my lord. There is divergent findings are there.
Decreed in part in respect of owner of A scheduled property. Reversed in appeal.
Appeal.
Directed to hand over
the possession.
The possession.
They sought for counterclaim. Concurrent finding in respect of
property within 3 months.
Yes, sir. Concurrent finding with regard to observed possession. That is the
Schedule A.
Schedule A.
Reversed in respect of one appeal allow ಆಗಿದೆ, ಇನ್ನೊಂದು appeal dismiss ಆಗಿದೆ.
Another appeal mean profits na adna pursue ಮಾಡಿಲ್ಲ actually.
How did the appellant counsel and suit was decreed in part, declaring that the plaintiff was the owner of A scheduled property. And the same is reversed in entertaining one appeal, and other appeal was dismissed and directed to hand over the vacant possession of B scheduled property. Howdalla?
Coffee land.
That is within
3 months.
3 months. And having taken note of the divergent finding, it is necessary to call for records of the trial court and appellate court and issue notice against the respondents.
I have sought
ಏನ್ ಕೇಳಿದಿರಿ?
ಅದರಲ್ಲಿ stay of the RA.
Appellate court order.
ಹೌದು ಸರ್.
Having heard the appellant counsel on IA number 1/25 and also divergent finding, and when there is a direction to hand over the vacant possession of B scheduled property, it is appropriate to grant the stay as sought till next date of hearing.
69.
Appear for the appellant. Well, the trial court records were summoned, but it is still noted as awaiting.
ಬಂದಿದೆಯಲ್ಲ, awaiting both TCRs ಅಂತೇನ ಇದೆ, ಬಂದಿದೆಯಾ?
Next week I will do.
Records are received from the trial court. List this matter on. Ibru idira? Yes. Both the counsels are present. List this matter on. 37.
Please. Interim order may kindly.
Interim order granted earlier is extended.
Great.
70 adjourn ಆಗಿದೆಯಾ? Remaining matters at 2:30.
70 madam.
70 ಆಗಿದೆ ಬೆಳಿಗ್ಗೆ.
adjourn ಆಯ್ತಲ್ಲ, ಬೆಳಗ್ಗೆ ಯಾರೋ ನಿಮ್ಗೇನೋ ಹೇಳಿದೀವಿ ಅಂದ್ರಲ್ಲ.
Inform me, but I was waiting for the time.
ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಅಂದ್ರು?
Inform ಮಾಡಿ.
ಇಲ್ವಾ?
ಫೋನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು, ಬಟ್ ಇಲ್ಲಿ ಬಂದು ರೀಚ್ ಆದಾಗ ಮಾಡ್ತಾರೆ ಅನ್ಕೊಂಡಿದ್ದೆ.
ರೀಚ್ ಆದಾಗಲ್ಲ, ಮೊದ್ಲೇ ಕೇಳಿರು ಬೆಳಗ್ಗೆ. 27 ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್.
27. Lord, may I request Lord, I will be out of town. 6th, 7th, kindly have it. 7th.
Other side ಗೆ ನೀವು
I will intimate. 7th, make it 7. 7. I will inform.
7 ಮಾಡಿ ಅದು ಅವ್ರಿಗೆ ಹೇಳ್ರಿ, ನೋಡ್ರಿ ಯಾರು ಡೇಟ್ ಚೇಂಜ್ ಮಾಡಿ.
I will inform.
ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನಾಯ್ತಿರೋದು? ಮಾಡಿದ್ರಾ?
ಇದರಲ್ಲಿ ಅದೇ
ಏನಾಯ್ತು?
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಫ್ ಮೆಮೊ ಹಾಕಿ ಅಂತ ಹೇಳಿ.
ಈ ಖಾತಾ ಅದೇನು ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮತ್ತೇನ್ ಹಾಕ್ತೀರಾ?
ಅಲ್ಲ, ಒಂದು ವೀಕ್ ಟೈಮ್ ಇದೆ.
ಯಾಕೆ?
ಅದೇ ಅವರು
ಅದರ್ ಸೈಡ್ ಅವರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರದೇ ಗಲಾಟೆ, ನೀವು ಕೊಟ್ಟಿಲ್ಲ ದುಡ್ಡು ಅಂತ ಬರ್ಲಿ
ಅದೇ ಅದನ್ನೇ ಅಲ್ಲೇ ಹಾಕ್ಲಿಕ್ಕೆ
2:30
ಅಲ್ಲ ಕೈಂಡ್ಲಿ ಔಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಅವರು ಬರ್ಲಿ ಹಾಕ್ಲಿ ನೋಡೋಣ. ಇಬ್ರು ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ಡೇಟ್.
ಇಲ್ಲ ಅವ್ರಿಗೂ ಏನೋ ಇಂಟಿಮೇಷನ್ ಮಾಡಿದ್ರಂತೆ, ಅವ್ರು ಬಂದಿಲ್ಲ, ಬರ್ತೀನಿ ಅಂತ.
ಅವ್ರಿಗೂ ಬೇಕಂತ ಟೈಮ್ ಅಂತ ಕೇಳಿದಾರ ನಿಮ್ಗೆ?
ಹೌದು ಸ್ವಾಮಿ.
ತಗೊಳ್ಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 71. ಹಾ ಹೇಳಿ ಏನು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 22 is present. ಇವತ್ತವರೆಗೂ ಏನು ಮಾತಾಡಲಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೇಟ್ ತಗೋತಾರೆ.
ಅಲ್ಲ ಹಾಕ್ತೀನಿ ಅಂತಂದ್ರಲ್ರಿ ಏನ?
ಅಲ್ಲ ಇವರು
ಕ್ಯಾಲ್ಕುಲೇಷನ್
ನೆಗೋಷಿಯೇಟ್ ಮಾಡಿ.
ಅಲ್ಲ ಇವರು ಫಾರ್ ದಿ ಫಸ್ಟ್ ಟೈಮ್ ಇನ್ ದಿ ಅಪಿಯರೆನ್ಸ್ ಆಫ್ ಲಿಬರ್ಟೀಸ್ ಅಂತ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಗ್ಯುಲರ್ ಅಪಿಯರ್ ಆಗ್ತದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಇದು.
ಹೌದು ಸರ್,
ಪೆಂಡಿಂಗ್ ಇದೆ.
ಎಫ್ಎಲ್ ಏನ್ರಿ? ಹಾ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಏನೋ ಮಾಡಿದ್ರು.
ಅದೇ ಸೆಟಲ್ಮೆಂಟ್
ಗೆ ಏನೋ ಮಾತಾಡಿಲ್ವಾ?
ನಮ್ಮ ಹತ್ರ ಇವತ್ತು
ಆಯ್ತು ಬರ್ಲಿ, ಎಲ್ಲ ಕೌನ್ಸಿಲ್ ಬರ್ಲಿ, ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ 2:30.
ಇದೊಂದು ಡಿಫ್ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ 68 ಅದೊಂದು 21 ಕೊಟ್ಟಿದ್ದಾರೆ, ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ 68 ಸೈನಿಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ ನಮ್ಮ ಒಳಗಡೆ ತೆಗೆಸ್ಬಿಟ್ಟು. ನೀನ್ ಹೇಳ್ತೀನಿ 58 27/6 ಇವ್ರು ಬಂದಿದ್ರು ಪಿ ನಟರಾಜ್ ಇವ್ರು ಇರ್ಲಿಲ್ಲ ಅವರು ಇದ್ರು ಹೌದು 68 to 21 sir.
deviation ಇದ್ರೆಲ್ಲ ಇದು ಮಾಡ್ಕೊಂಡು ಎರಡು ಕೋರ್ಟಲ್ಲಿ ನಾನು ರೋಡ್ಗೆ ಇನ್ಸರ್ಟ್ ಸಿಕ್ಕಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ
ಏನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 28 ಅರ್ಚನಾ 78 ಇದೆ ಇದೆ
ಅದಕ್ಕೆ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಮಾಡ್ತಾರೆ ಅದೇ ಅವರು ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಇಲ್ಲಿ ಅವ್ರು ಇನ್ನೊಂದು ಏನ್ ಹೇಳ್ತಾರೆ ಬೈಲ ಇಲ್ಲ ಬೈಲನೇ ಬಂದಿಲ್ಲ ಬೈಲನೇ ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲಿ ಕ್ವಶನ್ ಇರೋದು ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ಗೆ ಪ್ಲಾನ್ ಪ್ಲಾನ್ ತಗೊಂಡು ನಾನು ಇವಾಗ ಅದಕ್ಕೆ ನಮ್ಗೇನು ರೋಡ್ಗೆ ಏನಾದ್ರು ನಾವು ಪ್ರಾಪರ್ಟಿನ ಅಕ್ವೈರ್ ಮಾಡಿದ್ದೀವಿ ರೋಡ್ಗೆ ಏನಾದ್ರು ಅಕ್ವೈರ್ ಮಾಡಿದ್ದೀವಿ ಏನೇನಾದ್ರು ಮಾಡಬೇಕು
ಅದೆಲ್ಲ ಹೇಳ್ಕೊಡ್ತೀನಿ 3140 ಈಗ ನನ್ನ ಮಧ್ಯಾಹ್ನ ಇದಕ್ಕೆ ಹೋಗ್ಬೋದು 2:30 ಮನೋಹರ್ ಮನ್ ಡೇಟ್ ಹಿಂದಿ
ಸರ್ 3 weeks ಅಂತ ಹೇಳಿ
ಈಗ ಇವತ್ತು 44 ನೀವು ಇದನ್ನು ಹತ್ರ ಬಂದ್ರಪ್ಪ
ಸರ್ 42 weeks ಆಗಿದೆ ಪಕ್ಕದಲ್ಲಿ
ಮಧ್ಯಾಹ್ನ ಇದು ಹೋಗ್ಬೋದು ಇನ್ನು ಇದಕ್ಕೆ ಅದಾಯ್ತಲ್ಲ ಪಾಪ ಇದು ಆಯ್ತು ಬಂದಿರಿ ಬಿಡಿ ಕಮಲಮ್ಮ ಏನು ಬೇಕು ಒಂದು ರಿಪೋರ್ಟ್ ಮಾಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ಅಲ್ಲ
ಇಲ್ಲ ಇದು ಸ್ಟಿಚ್
ಆಗಿದೆ ಹಾಕ್ತೇವೆ ನೀವು ಇದು ಮುಂದೆ ಸ್ವಲ್ಪ ನಾನು 25 ಮುಗಿಸ್ಕೊಂಡು ಅದು ಕಂಪ್ಲಿಲ್ಲ ಎಲ್ಲ ನಂತರದ ಇಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಫಸ್ಟ್ ಎಂಟ್ರಿನೇ ನಮಗೆ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಲ್ಯಾಂಡ್ ಅಸೆಸ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಕೋರ್ಟ್ ಹಾಕಿ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಏನಿಲ್ಲ ಅಂತ ನಾವು ಆಗಲೇ ಅದನ್ನು
ಒಂದೇ ಸಲ ಹೋಗ್ಬಿಟ್ರೆ ನೀವು
ಇವತ್ತು ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ತಾ ಇದ್ದೆ.
RP branch.
ನಂಬರ್ ಎಷ್ಟಪ್ಪ ಎಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಎಲ್ಲೂ
ಸ್ಟೇಷನ್
ಹಾ ಇದೆ ಮೂರಿದೆ.
ಹೌದ್ರಾ ಸರ್? ಆಮೇಲೆ ಫೋನ್ ಮಾಡ್ತೀನಿ ಸರ್ ಟೋಟಲ್.
ಇದು ನೀವು ಹೇಳಿದ್ದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಈಗ ಬರ್ದಿದ್ದಾರಲ್ವಾ,
ಓ ನೋಡಿ ಚೆಕ್ ಮಾಡಿ.
ಅದೇನಾ ಕರೆಕ್ಟಾ?
ಇದೆ.
ಆಮೇಲೆ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿದ್ದೀನಿ ಅಂತ ರಿಗಾರ್ಡಿಂಗ್ ಪೇಮೆಂಟ್ ಅಪ್ ಟು ಡೇಟ್ ರೆಂಟ್ ಅಂಡ್ ಅರಿಯರ್ಸ್ ಅದನ್ನ ಹಾಕಿದ್ದೀವಿ ನಾವು ಐಎ ಜೊತೆಗೆ. ಎನಿ ಪ್ರೂಫ್ ರಿಗಾರ್ಡಿಂಗ್ ಪೇಮೆಂಟ್ ಅಪ್ ಟು ಡೇಟ್ ರೆಂಟ್. ಹಾಂ ಅಂಶು
ಮಾಡಿದ್ದಾರಲ್ಲ ಇದೆ
ಅಲ್ವಾ ಅಂಶು
500 ಬರೀ 500 ಫೀಸ್ ಕಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಎನಿ
ರೆಂಟ್
ಪೇಮೆಂಟ್
ರೆಂಟ್ದಲ್ಲಿ ಇದೆ ಮೇಡಮ್.
ಇದು ಏನೋ ಹಾಕಿದ್ದೀವಿ ಅಂತ ಐಎ ಜೊತೆಗೆ ಏನೋ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ ಅನ್ಕೋ.
ಇದು ಐಎ, ಇದು ಕೋರ್ಟ್ ಫೀಸ್, ಇದು ಫೀಸ್, ಇದು ಪ್ರಾಪರ್ ಕೋರ್ಟ್ ಫೀಸ್ 500 ರೂಪಾಯಿ ಏನು ಈ ಕಾಸ್ಟ್ ಇದೆ. ಸ್ವಲ್ಪ ಫೋನ್ ಮಾಡಿದ್ರೆ ಓಡ್ ಬರ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ಗೆ ಅಲ್ಲಿ ಹೇಳಕ್ ಬೇಕಲ್ವಾ? ಇಲ್ಲಾಂದ್ರೆ ಇವ್ರ ಹತ್ರ ಹೇಳ್ಬೇಕಲ್ವ? ಈಗ ಎರಡೇ ಇರೋದು ಇದು. ಎರಡೇ ಐಎಸ್. ಅಯ್ಯೋ ಬೇಗ ಬರ್ಬೇಕಲ್ಲ, ಫಸ್ಟ್ ಮ್ಯಾಟ್ರೇ ಇದೆ. ಇದು ಹಾರ್ಡ್ ಶೀಟ್ ಇರ್ಲಿ ಸದ್ಯ ಒಂದ್ ಬಚಾವಾದ್ವಲ್ಲಮ್ಮ. ಬೆಳಗ್ಗೆ ದೊಡ್ಡ ಇದನ್ನ ಇತ್ತು ಅಂದ್ರೆ ಈಗ ನೋಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕೈಯಲ್ಲೇ ಬರ್ಬೇಕು ಸಾಕು.
ಒಂದು ಆಗಿದೆ ತಾನೆ, ಅದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ.
ಅದು ಓಕೆ, ಅದು ಓಕೆ, ನನ್ಗೂ ಅದೇ ಸರಿ ಅನಿಸ್ತದೆ.
ವೈಟ್ ಶೀಟ್ಸ್ ಇಲ್ವಾ? ವೈಟ್ ಶೀಟ್ಸ್ ಇಲ್ವಾ? ಬೆಳಗ್ಗೆ ಹಂಗೆ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ, ಅಕಸ್ಮಾತ್ ಬೇಕು ಅವ್ರು ನಾವು ಮತ್ತೆ ಚೇಂಜ್ ಆಗ್ತೀವಿ ನಾವು. ಅಲ್ಲ ಇಟ್ಕೊಂಡು ನೋಡ್ತೀನಿ, ಮತ್ತೆ ಹೋಗ್ಬೇಕಂದ್ರೆ ಚೇಂಜ್ ಮಾಡಬೇಕು. ಅವ್ರದ್ದೇನೆ ಇಟ್ಟಿದ್ದೆಲ್ಲ ಅದು ಇರೋದು ಎರಡನ್ನು ನೋಡೋದಲ್ವಾ? ಅಲ್ಲೊಂದು ಫೈಲ್ ಇಟ್ಟಿದ್ದೆ, ಇದು ಅವ್ರದ್ದೇನೆ. ಇದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಬರ್ದಿದ್ದಾರಲ್ವಾ?
ಇದು ತಪ್ಪಿದೆ. ಯಾವ್ದಾದ್ರು ಒಂದು ಮಾಡಬೇಕು. ಇದು ಅದರ್ ದನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಇದ್ರೆ ಮಾತ್ರ 46 ವರೆಗೂ ಬರುತ್ತೆ.
ಇದು ಏನೋ ಬರ್ದಿದ್ದಾರಲ್ಲ,
ಇದಿದೆ, ಯಾವ್ದಾದ್ರು ಒಂದು ಬರೀಬೇಕು, ಎರಡು ಕೆಳಗಿಲ್ಲ ಮೇಡಮ್.
ಆಮೇಲೆ ಎನಿ ಪ್ರೂಫ್ ರಿಗಾರ್ಡಿಂಗ್ ಪೇಮೆಂಟ್ ಆಫ್
ಅಪ್ ಟು ಡೇಟ್ ರೆಂಟ್ ಹಾಕ್ಬೇಕಲ್ಲ.
ಹಾಕಿದ್ದೀವಿ ಅಂತೇನೋ ಅಂದ್ರೆ ಐಎ ಜೊತೆಗೆ ಹಾಕಿದ್ದೀವಿ ಅಂತ, ಐಎ ಜೊತೆಗೆ ಏನೋ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದಾನೆ ಅಂತ.
ಅದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮೇಡಮ್, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಅದು
ಎನಿ ಪ್ರೂಫ್
ಹಾಕಿಲ್ಲ. ಪ್ರೂಫ್ ಏನಿರುತ್ತಾ ಇದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ. ಇದು ಅರಿಯರ್ಸ್ ಕೊಡೋಕ್ಕೂ ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. ನಮಗೆ ಡೇಟ್ ಆಫ್ ವೇಕೆಂಟ್ ಪೊಸಿಷನ್ ಅಂದರೆ ಬಾಡಿಗೆ ಕಟ್ಟಬೇಕು, 1 ಇಯರ್ ತಗೋತೀವಿ. ಆಮೇಲೆ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಎಷ್ಟು ಕೊಡಬೇಕು? 800 ಪ್ಲಸ್ ಅದು ಇಂಟು 12, 800 ಆಗಿದೆ ಮೇಡಮ್. 800 ಅಂತ ಸ್ಯಾಲರಿ ಇನ್ಹೆನ್ಸ್ ರೆಂಟ್ ಇದೆಯಲ್ಲ, ಇಂಟು 12 ಮಾಡಬೇಕು. ಅದು ಮತ್ತು ಇದು ಕಟ್ಟಬೇಕು. 115. ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಮಾತ್ರ 46 ಸಬ್ ಕ್ಲಾಸ್ 1 ಇದು ಶಿವಮೊಗ್ಗ. ಸೊ ಅವ್ನು ಎರಡು ಹಾಕಿದ್ದಾನೆ ಕೇಳಕ್ ಬರಲ್ಲ. ಒಂದು ಹೊಡಿಬೇಕು ಸ್ಟ್ರೈಟ್ ಔಟ್ ಮಾಡ್ಬೇಕು. ಸರಿ ಇದೇ ತರ ಒಂದು ಮೆಮೊ ತಗೊಂಡಿದ್ದೀವಿ ಮೇಡಮ್, ಅದಕ್ಕೆ ಅವರೇ ಸರಿ ಮಾಡಿ HRC ರೆಕಾರ್ಡ್ಗೆ ತಗೊಂಡಿದ್ದೀವಿ.
ಪ್ರೂಫ್ ಇವತ್ತು ಕೊಡ್ಬೇಕಲ್ವಾ, ಅದೊಂದು ಕೊಟ್ಟಿಲ್ಲ.
HRC
HRCನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರ್ಬೇಕಲ್ಲ.
HRC ಆಸ್ ಪರ್ HRC ಆರ್ಡರ್ ಅಂತಾನೆ ಹಾಕಿದ್ದೀನಿ ಮೇಡಮ್. ಯಾಕಂದ್ರೆ ಈಗ ಕೊಡಬೇಕು ಅಂತ ಆಯ್ತು, ನಾನು ಕೊಡೋಣ ಅಂತ RR ಬಂದು ರೆಂಟ್ ರಿವಿಷನ್ ಬಂದು ಅದು ಅಲ್ಲೂ ಕನ್ಫರ್ಮ್ ಆಯ್ತು HRC ಲೋಯರ್ ಕೋರ್ಟಲ್ಲಿ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದರು ಅವರು. ಸೊ ಅದ್ರ ಪ್ರಕಾರ ಕೊಟ್ಟು
ನಾವು ಕಟ್ ಮಾಡಿ
46 ಬರಲ್ಲ, 46 ಓನ್ಲಿ ಫಾರ್ ಬೆಂಗಳೂರು, 115 ಅದರ್ ದೆನ್ ಬೆಂಗಳೂರು.
Fast program. ಅದನ್ನ ಇನ್ನ ಇನ್ಕ್ರೀಸ್ ಮಾಡಬೇಕು ಅಂತ. ಅಲ್ಲ ಎಲ್ಲಂದ್ರಲ್ಲಿ ಹೋಗಿದ್ ಕಡೆ ಎಲ್ಲ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು. ಹಳೆ ಬ್ರೇಕ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಇಲ್ಲ ಏನಿಲ್ಲ. ಒಂದೆರಡು ದಿನ ನಾನು ಟೈಮ್ ಯಾವತ್ತು ಗೊತ್ತಿರಲ್ಲ. ಎಲ್ಲಾನು ಒಂದೇ ತರ ಟೈಮ್ ಅದೇ ಕಲರ್ ಗ್ರೀನ್ ಕಲರ್ ಸಮಥಿಂಗ್ ಸ್ಟೋನ್ ಪಾಪ ಕಷ್ಟಪಟ್ಟು ಕೂತ್ಕೊಂಡಿರೋ ವಾಶ್ರೂಮ್ ಬ್ರಷ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಏನೋ ಸರ್ವೈವ್ ಆಗಿದ್ದೀನಿ. ನೀನು ಹೆಂಗೆ ಸರ್ವೈವ್ ಆಗ್ತೈತೆ ಜೀವನದಲ್ಲಿ ಮೆಜೆಸ್ಟಿಕ್ ಹೋಗಿದೆ ಮುಂದೆ ಕಳೆದು ಹಿಂಗೆ ಕಳೆದೋಗುತ್ತೆ ಕದ್ದಲ್ಲಿರೋದು ತಗೊಂಡಿದ್ದು ಒಂದು 10,000 ಇದೇ ಅಷ್ಟು ಸಿಕ್ ಹತ್ಕೊಂಡು ಹೊರಟೈತೆ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಏನು ಗೊತ್ತಾ ನಿನ್ನೆ ಹೇಳ್ಕೊಟ್ಟಿದ್ದು ಪಾಪ ಎಷ್ಟು ಕಷ್ಟ ಪಟ್ಕೊಂಡು ಏನೋ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಹಾಕ್ಕೊಳ್ತಾರೆ ಅಲ್ಲಿ ಹೋಗಿ ಪಾಪ ಎಷ್ಟು ಬೇಜಾರು ಮಾಡ್ಕೊಂಡಿರುತ್ತೆ passed out matter, serial number 1, Anshuman.
My lord, serial number 1, my lord.
Yes, counsel. Hmm. 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 Yes, counsel. Make your
My
submission.
lord, I have complied with all the office objections, my lord. I have corrected the, I have added the trial court order as well, along with typed copy, my lord, in the IA.
Regarding
My lord,
payment of,
my lord, regarding that, my lord, petitioner is a indigent person, my lord. He is illegally, he is unlawfully occupied that premises, my lord. And that the same thing is granted by the government in the year 1999 to the petitioner's husband, my lord, respondent's husband, my lord. So since then he was peacefully staying there, my lord.
there is an order. You have to make the payment of rent and also deposit that amount. There is a direction. You comply with the
Yes, my
office
my
objections.
lord, there is no. My lord, my lord, he has no money to pay, my lord. And so far he has not paid one single year's rent.
Proviso says, when your petitioner can appoint an advocate, why petitioner cannot pay the arrears of rent?
My lord, the case is pro bono, my lord.
Pro bono, you continue to do the same pro bono. But as per the statute, you deposit the rent, that's all. There cannot be any
Sometime
exemption in an HRRP
Sometime maybe.
without depositing the
Sometime
arrears of
maybe.
rent. Time already given, fifth time matter is listed for non-compliance.
My lord, that is the only office objection, my lord. He does not have money.
There are
I'll make sure he pays, my
two
lord.
office objections, one more also regarding provision. You mentioned
Provision,
both the provisions. Correction also made and not striked out the earlier provision which you have mentioned. That also you have to correct.
That I'll do as well, my lord.
The petitioner is given 1 week time to comply with office objections on cost of rupees 500. List this matter on 27/6.
Please, my lord.
51.
Next. 50.
51. Kalyana.
Lord, the plaintiff had filed a suit for partition and also had challenged, my lord, the release date executed by, my lord, plaintiff along with other defendants in favor of the defendant number 2, relinquishing their right interest in respect of the scheduled property by receiving certain amount as stated under the release date. Now, my lord, the plaintiff, after receiving the amount executing the release date, files a suit for partition, contending that, my lord, the defendant number 2 has not paid the money as agreed under the release date, and there is a violation of contract, breach of contract. That is what said in the plaint. My lord, a perusal of the release date would clearly demonstrate that, my lord, amount of 15 lakhs was paid to each of the persons who have relinquished their right, my lord, including the plaintiff. When the document speaks that, my lord, the amount was received, it is stated. And now, my lord, if she has contended that, my lord, there was a fraud played and fraudulently her signature is obtained, that would have been a different aspect. See, what the plaintiff says is that, my lord, promised amount is not paid and there is a breach of contract. Therefore, my lord, the application for rejection of plaint was made, plaint was rejected, and against which regular appeal was filed by the plaintiff. In the appeal, the appellate court reverses the order and holds that, my lord, at this juncture, plaint cannot be rejected. Lordship may kindly, for a moment, my lord.
Whether all this can be adjudicated in an application filed under Order 7 Rule
My lord,
11 Council?
adjudication, my lord, is different from, my lord, whether they
have paid the entire amount or not, or balance amount they have paid. Whether it can be decided in an application under Order 7 Rule 11.
My lord, the contents of the, my lord, release deed is perused. It would clearly state that, my lord, they are relinquished their right by receiving money.
That requires the trial also.
Your lordship may kindly peruse para number 6, my lord.
Para number 6 of the
Plaint, my lord.
Where is that plaint copy? Have you produced that copy?
My lord, LCR is summoned, my lord, secured.
LCR
Lordship may
ಬಂದಿದೆ
kindly.
madam?
Trial court record is. My lord, para 6 of the plaint, my lord. When such being the facts, the second defendant got conversion of the order in respect of 2 acres, 20 and 39 guntas out of total extent converted from agriculture to non-agriculture residential purpose as per the order dated 25/4/2012. In meantime, the second defendant has executed joint development agreement in favor of 18th defendant along with defendant number 3 to 6, which is duly registered in the office of so and so. On same day, the second defendant got registered release deed from defendant number 7 to 17 along with the plaintiff by saying that the second defendant agreed to pay a sum of rupees 15 lakh to the defendant number 7, 8, 9, 10 and 14 along with the plaintiff. But the second defendant is not paid amount as agreed by him. When the plaintiff questioned the same, he has given only 9 lakhs. Further, he is agreed to pay balance amount after 3 months' time with 2 villas. Again, when the plaintiff was approached in the month of December 2014, on that time, the defendants are in collusive manner with each other. They are totally refused to write up the plaintiff either claiming balance amount or property, even though the plaintiff is entitled for equal share over the scheduled property. Thereby aggrieved by the defendant's illegal acts, the plaintiff conveyed the panchayat in the locality in the month of April last week 2015 in the panchayat. Also, the defendants not heeded the voice of the plaintiff or panchayatars. When the second defendant not stands his words with the plaintiff, there was a breach of contract between the plaintiff and the defendant number 2. Thereby, the plaintiff lodged a complaint before the jurisdictional police station on 7/5/2015. In turn, the concerned police have advised the plaintiff to approach the civil court as the matter is civil in nature. My lord, when there is an allegation stating that, my lord, there is a breach of contract, whether a suit for partition could be maintainable, whether the plaintiff could challenge the release deed. Now the relief sought is partition and challenge the release deed. If, my lord, the plaintiff has alleged that, my lord, there was a fraud played or there was an amount which was promised by him, but it was wrongly shown as been paid, which is a fraud played by the defendant number 2, subsequently paid. If that is the allegation made, my lord, then the plaintiff would be maintainable. In the facts and circumstances of the case, my lord, para 6 does not disclose any cause of action to the plaintiff to maintain a suit for partition. And also, your lordship may kindly peruse the release deed dated 20th September 2014. My lord, but for what is said in the para number 6, my lord, in view of the averment stated in para 6, my lord, there is no cause of action to the plaintiff. What is averred is that, my lord, under the release date, he agreed to pay some certain amount. Your lordship may kindly peruse the release date.
That's why I asked you when there is a pleading in the plaint that there is a fraud.
My lord, there is no pleading, there is fraud.
Huh?
There is no pleading.
That is the pleading.
Your lordship may kindly
You
para
took-
6.
You took the signature.
Para
Making
6.
a false promise.
Allah,
That
your
is-
lordship
that
may
is-
kindly.
That is the averment in the plaint, para number 6 also.
Para 6, there is no such averment.
Counsel.
He says that, my lord, there is breach of
Disputed-
contract.
Disputed facts cannot be
My lord,
decided.
I am not saying
in
that
an
the-
application
my lord,
filed under Order 7 Rule 11.
my lord, for a moment, your lordship may kindly appreciate. What is said in para 6 is that the second defendant agreed to pay a sum of rupees so and so.
Howdu?
Lord, under the release date.
Ah.
Your lordship may kindly peruse the release date.
Release date question the same, he has given only 9 lakhs, further agreed to
My
pay
lord,
balance amount of-
subsequently he says, whether there was any due, my lord, whether there was any due under the release date as per the registered release date. What release date? There is a legal presumption, my lord, so far as the registered instrument is concerned.
That requires trial counsel. Without the
lord,
trial, how can a
when-
court can
when he
dismiss
says
it
that, my lord,
only on the
under-
ground that there is no cause of
My
action?
lord, under the release date, he says, the second defendant agreed.
Disputed issue has to be decided in the trial
My
court
lord,
only.
it is, what is required is, my lord, they to look into the document.
Maybe there is a document, but there is an allegation in the plaint
My lord,
itself that.
Whether,
it is
whether,
self-considered
whether
as
the
a
document, whether, my lord, averment stated by the plaintiff.
promise that going to make the payment, but payment has not been made, and that
My
is
lord,
the.
under the release date, it is said that, my lord, amount is received. When, my lord, the apex court in Dahiben says, the documents produced along with
While
the,
reversing the order, reasons are also assigned.
my lord,
The
reasons
matter-
assigned is,
Matter requires trial, that's
my
all.
lord, what is, my lord, your lordship may kindly for a moment, kindly appreciate what is said in paragraph number 6. Your lordship may kindly now may be permitted to read the averments of the release date. Release date dated.
ಇದೆ ರೀ, ಅದಿಲ್ಲ ಅಂತಲ್ಲ, that is disputed.
ಅವ್ರು ಹೇಳದ release
Having-
date.
For
My
having
lord,
paid the amount.
my lord,
Matter requires trial.
my lord, if he has said that, my lord, if he has said in the plaint saying that there was a fraud, amount was not paid, that would have been a different. Under the release date, there was a promise to pay. Kindly look into the release date. Under the release date, amount is paid.
Disputed facts has to be
My lord,
decided by the trial court.
now what is required is to look into this document, that's all, my lord. And also they say,
By looking into the document, court cannot take a decision.
my lord, whether amount is paid or not.
Unless the evidence is let in.
My lord, that is the settled law, my lord.
That is
My lord,
pleaded
what
in the
is
plaint-
to be-
pleaded in the plaint itself that
My lord,
not received
now
the
the
entire
plaintiff-
amount.
My lord, the plaintiff is,
Whether amount has been paid or not, that is an issue.
My lord,
That
it
is a
is-
factual finding
my
to be
lord,
given by
your
the
lordship
trial
may
court.
kindly peruse the release date now.
Release date ಅಲ್ಲಿ ಇದೆ ರೀ, ಇಲ್ಲ ಅಂತಲ್ಲ, but
ಅಲ್ಲ, ಅವರ್ಮೆಂಟ್ ಹೇಳೋದೇ ಹಂಗೆ, under the release date promise to agree to pay ಅಂತ. There is no agreement under the release date that he will pay the amount in future. In the full and final settlement, the release date so and so has received an amount of rupees so and so ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ.
That's all. Totally. This matter is listed for admission. I heard the counsel appearing to the appellant. The challenge is made regarding remanding the matter, setting aside the order passed by the trial court in Order 7 Rule 11 A and D. The appellant herein filed an application, Order 7 Rule 11, invoking 11 A and D, contending that there is no any cause of action for filing the suit, and suit is liable to be rejected. The trial court, having considered the grounds urged in the application, comes to a conclusion that there is no any cause of action, and plaint is liable to be rejected. And also made an observation that nowhere in the pleading the plaintiff has stated that as to how the release deed is illegal and not binding on the plaintiff. Nowhere the plaintiff pleaded that she was taken to sub-registrar office forcibly and out of coercion and threat. They got obtained the signature of plaintiff on the release deed, and having considered these reasons allowed the application. The same has been challenged before the appellate court. The appellate court, having considered the grounds urged in the application as well as the statement of objections, reassessed the material on record, and also taken note of that specific amendments are made in the plaint that the property belongs to their father. They are in joint possession and enjoyment of the property, and also contend that second defendant got converted the land out of total extent of 2 acres 39 guntas for non-agricultural residential purposes as per order dated 25/4/2012. In the meantime, second defendant also executed a joint development agreement in favor of the 18th defendant, along with defendant number 3 to 6. It is also the specific government in the plaint that on the very same day, a release deed is got registered from defendant number 7 to 17 and plaintiff, wherein the second defendant has agreed to pay a sum of rupees 15 lakhs to the plaintiff and other defendants. It is further agreed to pay balance amount within 3 months with 2 villas. There is breach of this contract. Looking to these pleadings, the trial court has formed an opinion that the plaintiff should have filed a suit for specific performance of the contract and not a suit for partition, because there is no privity of contract between the plaintiff and defendant number 18. The certified copy of the release deed is also on record. It is executed by the plaintiff also. Having taken note of the relinquishment deed and also the amendments made in the plaint, and specific contention was taken that only made the payment of rupees 9 lakh. And also the fact that joint development agreement also came into existence on the very same day is not in dispute. And when the promise was made to make the payment, giving up 2 villas and rupees 15 lakh, and she has signed the documents. And when such amendment is made in the plaint, the appellate court also having considered the ground urged in the application, comes to the conclusion that that issue to be inquired by the trial court, as fraud vitiates the entire proceedings. When fraud is alleged, the trial court should have permitted plaintiffs to lead evidence, and also further observed that land was a tenanted land. Her father was a tenant. He had applied for granting occupancy rights, but when the application was pending, her father died. In other words, the property is a self-acquired property of her father. By intestate succession, it has fallen in the hand of successors. And also with regard to the discussion in respect of section 6 of the Hindu Succession Act, as well as the taken note of section 91 and 92 of the Indian Evidence Act, very clear that the plaintiff can question the validity of release deed, which is stated to be executed under a false promise. Having taken note of these reasons, and when the disputed facts are involved with regard to the matter requires adjudication, and merely relying upon the document of the relinquishment deed, and also coming to the conclusion by the trial court that no cause of action, comes to the conclusion that the very approach of the trial court is erroneous unless the matter requires adjudicated with regard to the false promise and obtaining a document. And when such allegations are made, the trial court comes to an erroneous conclusion that there is no cause of action. And when such finding was reversed by the appellate court and remitted back the trial court to decide the matter on merits, to consider the matter with regard to the disputed facts to be considered in a original suit, and I do not find any error committed by the trial court, first appellate court, and rightly comes to the conclusion that matter requires trial and disputed facts has to be ascertained only after conducting the trial, and hence I do not find any ground to set aside the order of the first appellate court, and reasons are given while setting aside the order of the trial court, and trial court committed an error in coming to such a conclusion that no cause of action, and specifically pleaded regarding no cause of action, that too in respect of the relinquishment deed executed, and the same was taken by obtaining the false promise, and whether that false promise made and obtained the document, it is a matter of trial, and hence I do not find any ground, and hence appeal is dismissed.
Lord, there is no averment of fraud ಅಂತ since there in the order it has come that way.
ಫಾಲ್ಸ್ ಪ್ರಾಮಿಸ್ ಎಲ್ಲ ಇದೆ ನೋಡಿ ಅದ್ರಲ್ಲಿ. ಆಯ್ತು ಟ್ರಯಲ್
The observations made.
ಸತ್ಯ ಹೊರಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಟ್ರಯಲ್ ಆಗ್ಬೇಕು
ಅಲ್ಲ,
ಅಷ್ಟೇ.
the observation made shall be only for the purpose of deciding.
The observation made in this disposal of MSA shall not influence the trial court considering the matter on merits.
Acha.
53, Hegde vs. Pramoda.
Here in this, my lord, in the written statement, my lord, para number 17, that has been stated. Originally, the property belongs to their father-in-law, my lord, and there are 17 of the written statement. The property belongs to their father-in-law, and after death, and it has come to the Subramaya, there is her husband, and after death.
Originally belonged to the father of the first defendant.
Yes, ma'am.
And he was in possession after the death of Subba Shetty.
Yes,
Son Subraya was in possession. After the death of Subramaya, his wife's first defendant Puttalakshmi was in possession. Social property. 4 daughters were born to Siravana and Puttalakshmamma. They are living in this disputed property in so and so. Appliance, roofing of one son. As for the panchayat records issued by the panchayat, and also the documents are in name of the, prior to that, husband Subba Shetty, name found in the assessment register and demand register extract. Even the Taluka Panchayat has pleaded in order to so for setting aside the kata, which is illegally in the name of defendant number 213, and also the defendant husband, late husband, son of so-and-so's name, electricity direction are taken to the first defendant bearing number so-and-so, Bharat Nagar, and also the so-and-so. It is only possession either on the farm of so-and-so prior to the suit. Hence this case so-and-so. Yes, counsel, what do you say?
It is only what they say is only the possession. Where is the title?
It is
there is nothing has been mentioned with regards to the title.
The father of the first defendant.
It belongs, they say, and further they say they are in possession. Where is the title? First title has to be set up, and that description of the title has to be mentioned in the pleading. Then all these things will come. Now what he is setting up is possession against the possession. It is not the title against the title. Therefore, since title is not there with the defendant number 1, and consistently the authorities, they have stated that we are in possession of the property, and kata also has been changed, and that matter came up before this honorable court, and this honorable court remanded the matter to file an appeal. Therefore, still my name is continued in the revenue records. Where is his? Where is his
record, my lord? It is there.
Therefore,
in the year 1981, 81, my name is there, my lord. In the middle of the thing, my lord, after that, after creating the sale deed, my lord, they will get the round of that particular name and put some Chikkamudda Shetty, and later they have made out the joint kata, my lord. I have challenged it, my lord. That attained finality, which has been passed. Exhibit D21, your lordship kindly see Exhibit D21. That is the order of the revenue court, my lord, wherein it clearly says the vendor of the plaintiff does not have any document to show how the kata has been changed into the name of Chikkamudda Shetty, my lord. And even that is not there.
Exhibit
D21, my lord. That is the order of the
21.
Yes, my lord.
Panchayat executive officer.
Yes, my lord.
That came to be challenged.
That is not challenged. That is attained finality, my lord. That is attained finality.
Exhibit D21.
Once it is remanded, my lord. Once it is remanded, after that an appeal, this appeal was heard, my lord. An order was passed. This was not challenged by the plaintiff. It is attained finality, wherein it clearly says, my lord, there is no basis for the plaintiff to get the change of kata. There is no explanation from the name of Subramaya to in the name of Chikkamudda Shetty, my lord. There is no explanation with regard to that. Only the name has been put out. And when it is came to know that in the 2011, my lord, we challenged it. When it is challenged, it was allowed. Up to High Court, dishonorable court, it has come, my lord. Wherein dishonorable court stated 269, it has to be filed before the executive officer and set aside. Matter remanded back. In 2016, it was passed in favor of me, my lord. So,
suit ಯಾವ year ಹಾಕಿರೋದು?
2011, my lord. Prior to that,
as on the date of filing of the suit, document stands in whose name?
My name. Documents as on the date, there is no document in the name of the plaintiff, my lord, as on the date, except they are showing the sale deed, there is no document. prior to that, my document.
Sale deed ಯಾವ year?
2011.
11.
11. So
documents ಎಲ್ಲ ನೋಡಿ ನಾವು
they
ತಗೊಂಡಿರೋದು.
have manipulated the revenue record. The
And
court
what
says,
they
my
say
lord,
in the
the
written
first appellate
statement-
court says, the plaintiff.
Sale deed ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಯಾರ ಹೆಸರಲ್ಲಿ ಇತ್ತು ಪ್ರಾಪರ್ಟಿ?
ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಡೀಡ್ ಆಗೋಕ್ಕಿಂತ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 and 3 ಹೆಸರಿನಲ್ಲಿ. There was a dispute amongst themselves and Taluk Panchayat officer has passed one order and appellate authority passed another order. All those things are on change of kata.
Sale deed ಯಾವ date?
Sale deed is dated
according to them only based on the sale deed only got the transferred the property.
No. ಅದು ಮಾಡಿದಾರೆ ಅವರು. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ನಾವು.
ಸೇಲ್ ಡೀಡ್ ಗಿಂತ ಮುಂಚೆ ಯಾರ ಹೆಸರಲ್ಲಿ ಇತ್ತು?
ನನ್ನ ಹೆಸರಲ್ಲಿ ಇತ್ತು. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಎಕ್ಸಿಬಿಟ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. I will produce the exhibits, my lord. Exhibit.
and more particularly in the written statement itself they have taken a contradictory stand. They say the identification of the property also is in dispute.
It is matter of trial. It is
dispute. Your lordship may kindly turn to page number 8 of written statement.
Exhibit T21 challenge ಮಾಡಿದಿರಾ?
My instructions are, my lord, it is has been challenged and it has been challenged.
ಎಲ್ಲಿದೆ ಯಾವುದು ಇದೆ ಏನಿದೆ ನೀವು?
ಅಲ್ಲ ನನ್ನ ಹತ್ರ ಈಗೇನಿಲ್ಲ because it is during the course of the
exhibit. My lord, exhibit D1, my lord. Wherein 1986-87 ಸಾಲಿನಂತೆ ಮೈ ಲಾರ್ಡ್ ಸುಬ್ರಹ್ಮಯ್ಯ ಇಸ್ ಮೈ ಹಸ್ಬೆಂಡ್ ಆದ್ಮೇಲೆ ಚೇಂಜ್ ಆಗುತ್ತೆ ನೋಡಿ. ಸೊ 1991 ಅಲ್ಲಿ ಪುಟ್ಲಕ್ಷ್ಮಮ್ಮ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಗೆ ಚೇಂಜ್ ಆಗುತ್ತೆ ಸತ್ತೋದ್ಮೇಲೆ, ಗಂಡ ಸತ್ತೋದ್ಮೇಲೆ. ಈಗ ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ತಗೊಂಡ್ಬಂದ್ಬಿಟ್ಟು 2011 ಅಲ್ಲಿ ನಮ್ಗಾಗಿದೆ ಅಂತ ಖಾತಾ ಇದ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದಾಗ
they have to say under which document they derive the title.
Only based on
that is not necessary. You have to establish, sir, you are the plaintiff. It is the ancestral property.
Prima facie there is a sale deed in my favor and the katas are standing in my name. On the other hand, they have not produced any title document.
My lord, there is no single document to show prior to my name in the document. They have not produced any document to show the revenue document to show the same. Even the authority passed an order that has not been challenged so far, my lord.
Your lordship may kindly see another contradictory statement made in the written statement. Your lordship may kindly see. There they say, as per the records issued by the Panchayat DA Kere, all the records issued by DA Kere bears the name of the first defendant. He says that is his assertion.
That's why in order to establish those things, my lord, I have produced the 41 rule 27, my lord, writ petition order and
in between
tax paid receipts, my lord. Prior to that, I have paid the taxes. Now 2011, they have paid the taxes and showing before the court after filing the suit, my lord. Even the first appellate court says that as on the date of filing the suit, there is no
sale deed ಆದ್ಮೇಲೆ ನಾವು ಅದೆಲ್ಲ ಮಾಡಬೇಕಾಗಿದ್ದು. ಅದಕ್ಕಿಂತ ಹಳೆದನ್ನ I cannot give document. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮುಂದೆ ಸ್ವಾಮಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ, it is the first defendant is in possession. Throughout he says he is in possession. He don't say with regard to the title how he has derived the title. Nothing is there. And para 17 ನಲ್ಲೇ ಹೇಳಿರ್ತೀವಿ ಅದನ್ನು possession ಹೇಳ್ತಾ ಹೋಗ್ತೀರಾ ನೀವು. Then defendant therein 10 feet width gully and the property of the plaintiff is at the distance of 30 feet from the scheduled property. This is a contradictory stand they have taken it. One hand they say this particular property I am in possession of the property, and on the same breath they say my property is 30 feet away from his property. This is in the written statement, and all through what they say is I am in possession of the property. They don't say anything with regard to the title. They don't even give any document of title in the suit. Therefore, the order passed by the first appellate court directing me to amend and include all these things, declaration and other things, is highly extraneous. That cannot be done.
When they are having the document is showing able to establish the title.
And the judgment referred during the course of judgment in RA, that is Shankar Bicharity, that is in my favor. Only the plaintiff has to do it, not the court.
Oh, no.
Nowhere it is mentioned that court has got the jurisdiction to direct me to file a particular suit or to pray for particular prayer. It is the plaintiff who has to make all these things. If at all he want to do it, court cannot direct me that you have to file a suit for declaration or suit for specific performance.
Even with regard to the position, my lord, I have produced the electricity bills, my lord. To show that my possession, I have produced the electricity bill standing in my name, my lord. I put up the constructions. That is exhibits, my lord.
Therefore,
and even they have
the
not
matter
produced
has to
any
again go
document.
before the
Except the
appellate
sale deed,
court
they have not produced.
and give the proper findings on merit.
And the inconsistent pleadings that they are saying, my lord, it is the plaintiff has to establish his case, how he has derived the title. Merely producing the document of the sale deed could not say that I have the title over the property. They will have to establish their vendor's titles also. In the revenue record prior to the 2011, it is standing in my name, Subrayappa, and later it has come to me, my lord. That is the exhibit D1, my lord.
And the trial court, after considering all the documents and everything, correctly held and declared the suit. Trial court has observed, not even a suggestion was put in so far as the title is concerned. That's what the trial court says.
Trial court says interference because
Yes, heard enough, told. Heard the appellant counsel and also the counsel appearing for the respondent. This miscellaneous second appeal is filed against the order of remand made by the first appellate court, directing the appellant herein to seek for the relief of comprehensive relief of declaration since there is a dispute with regard to the title. And also in such any application is filed, the trial court shall allow the plaintiff to convert the suit into one for comprehensive relief of declaration and consequent reliefs, and allow the defendant number one to produce additional documents, and also directed to frame appropriate additional issues, and an opportunity shall be given to both parties to lead additional evidence if any, and thereafter the matter shall be decided afresh after considering whether it is necessary to make recourse to order 26 of CPC. The counsel appearing for the appellant would vehemently contend that suit is filed only for the bare injunction, contending that suit shall property is purchased by the plaintiff and defendant is interfering with possession of the plaintiff and hence entitled for the relief of the permanent injunction. It is also contended that defendant number one having no manner of right, title or interest over the suit scheduled property with a malified intention to knock off the same has filed an appeal before the President Taluka Panchayat Maddur in appeal number 20/2011.12 challenging the kata of the suit property made in the name of the defendant number 2 and 3. In the said appeal, the plaintiff filed application to implead himself as he was the necessary party by virtue of the said sale deed. But the Taluka Panchayat rejected the application of the plaintiff and disposed the matter hurriedly to support the illegal claim of defendant number 1. And the kata of the suit property made in the name of defendant number 2 and 3 has been set aside. But immediately preferred an appeal before the Jilla Panchayat Mandya in appeal number 34 of 2011-12. And the same was allowed by the Jilla Panchayat Mandya, which order dated 7/8/2012. And the kata of the suit property was ordered to made in the name of the plaintiff by quashing the order of Taluka Panchayat. However, the said order of the Jilla Panchayat has been challenged by the defendant number 1 before the High Court of Karnataka, and the same is pending for consideration. Taking disadvantage of the said orders passed by the President Taluka Panchayat Maddur, the defendant with an intention to create evidence in their favor are making illegal attempts to put up illegal construction over the suit property and hence filed a suit for the relief of permanent injunction. In pursuance of the suit summons, defendant number 1 appeared and filed a written statement contending that defendant number subsequently died and her legal representatives were brought on record. The defendant number 1 legal representatives in their separate written statement, nor they adopted the written statement filed their mother, this is defendant number 1, but they contested the suit based on the defense taken by the first defendant. The defendant number 1 during her lifetime in her written statement denied the very case of the plaintiff, that plaintiff was in possession of the social property. On the other hand, it is a contention of the defendant that suit property consists of house of the defendant number 1 is situated, and she along with her sons and daughters were in possession of the suit property. The defendant number 2 and 3 being the residents of Mysore, they never in possession of the suit property. The suit property was originally belonged to the father-in-law of defendant number 1, and he was in possession of the same. After his death, her name has been transferred to the revenue documents, and defendant number 1 is in possession of the property. It is also contended that defendant number 1 and her children are residing in the disputed property in number 134/249 and 136/252. And both the houses and vacant place with asbestos roofing are one and the same. As for the panchayat records also, the property stands in the name of defendant number 1, and same was stood in the name of her husband. First of even the Taluk Panchayat has ordered to enter the name of defendant number 1 by setting aside the khata made in the name of the defendant number 2 and 3. When the defendant number 1 was preparing to put up the wall on the eastern side and the southern side of the social property, the plaintiff has filed this suit, and hence prayed the court to dismiss the same. The trial court, having considered the pleadings of both the parties, framed the issues regarding possession is concerned and allowed the plaintiff to examine, and plaintiff examined as PW1 and got marked exhibit P 1 to 10. On the other hand, 3 witnesses were examined. And also examined 2 witnesses, 3 witnesses PW2 to 4. And PW2 evidence has been got discarded by the plaintiff by filing memo. And evidence of PW1, 3 and 4 remains. On the other hand, defendant number 1D got examined himself as DW1 and got marked exhibit D1 to 21, and also examined 1 witness as DW2. The trial court, having considered both oral and documentary evidence, comes to the conclusion that possession has been proved by the plaintiff as on the date of filing of the suit. And also, though discussed in detail with regard to the claim made by the defendant, and also comes to the conclusion that when the revenue entries are challenged, it amounts to interference to the possession of the plaintiff over the suit property. And discussing the same, comes to the conclusion that plaintiff has succeeded in proving the alleged interference by the defendant and granted the relief. Being agreed by the judgment of the trial court, an appeal is filed before the appellate court, and appellate court, having considered the grounds urged in the appeal memo and also the submission of respective counsel, formulated the point whether the findings in the impugned judgment and decree passed in OS number 440 of 2011 relating to the question of possession and alleged interference and appreciation of evidence are against the settled principles of law, and whether judgment requires interference, and also considered the application filed under Order 41 Rule 27 of CPC. The appellate court, having considered the grounds urged in the appeal as well as the additional documents which have been placed before the appellate court, invoking Order 41 Rule 27, comes to the conclusion that enable it to pronounce the judgment for any other substantial cause, the appellate court may allow such evidence of additional documents. And considering the documents which have been produced as additional evidence, comes to the conclusion that the grounds which have been contemplated within the ambit of clause B under Order 41 Rule 27, that there are sufficient grounds to permit the appellants to adduce additional evidence. Having answered the point number 3 as affirmative, discussed in detail the factual aspects of the case and documents which have been produced, in paragraph number 24 comes to the conclusion that The questions involved in the suit are not limited to the deciding of mere possession in a suit for injunction simpliciter, contrary to the observations made in the impugned judgment, and also contend that when the denial of the title and challenge to the title of the plaintiff and his vendors by the defendant number 1 in the case raised, and when there is a cloud on the title of the plaintiff, his vendors in respect of the suit's property, and relying upon the judgment of Anantala Sudhakar versus P. Buchi Reddy, an observation is made that when there is a dispute with regard to the title and there is a cloud on the title, and when the defendant discloses his defense, the details of the right or title claimed by him, which raise a serious dispute, or cloud over the plaintiff's title, then there is a need for the plaintiff to amend the plaint and convert the suit into one for declaration. Alternatively, he may withdraw the suit for bare injunction with permission of the court to file a comprehensive suit for declaration and injunction. He may file suit for declaration with consequential relief even after the suit for injunction is dismissed, where the suit raised only the issue of possession and not any other issue. The appellate court, having considered the principles laid down in the judgment referred supra, comes to the conclusion that when there is a cloud over the title of the plaintiff, and when such being the case, directed to seek appropriate relief, modifying the plaint and remanded the matter. Now the very contention of the counsel appearing before this court that the appellate court committed an error and without looking into the evidence available on record, comes to the conclusion that matter requires deciding of the title involved between the parties, since the claim made by the defendant is also questioning the title and the very observation is erroneous. The counsel also would submit that when the suit is filed only for the bare injunction and simpliciter for the injunction, ought not to have considered the title of the parties, and the very approach is erroneous. And counsel also would vehemently contend that there is no any specific plea in the written statement regarding claiming of title. And the appellate court, for extraneous reasons, allowed the appeal, including the allowing of the application under Order 41 Rule 27, and directed to amend the plaint. And there cannot be such a direction to be given by the appellate court, and hence it requires interference. Per contra, the counsel appearing with the respondent would vehemently contend that specific denial of title was made and claimed that property belongs to the defendant number 1, and also contend that the property is an ancestral property, originally stands in the name of the father-in-law of the first defendant, and after the death of the father-in-law, property records are changed in the name of the first defendant, and all this document clearly discloses. And counsel also vehemently contend that only based on the sale deed, Kata was transferred, and the same was challenged before the concerned authority, and the Kata change in favor of the plaintiff also set aside, and the same is questioned before the appellate authority, and appellate authority reversed the same, and the same is challenged before this High Court, and also matter is remanded to the concerned authority to take a decision in this regard. The counsel also vehemently contend that after the remand also the order has been passed in terms of Exhibit D21, and the same has not been challenged and it has attained its finality. The counsel would vehemently contend that when the title is disputed and when the claim is made in respect of the very suit scheduled property by the defendant number 1, and all the properties even prior to the sale deed exists in the name of the first defendant father-in-law, and subsequent to the death of father-in-law, all the revenue records are also transferred in the name of the first defendant. When such material is disclosed, the appellate court rightly comes to the conclusion that there is a dispute with regard to the title, and matter requires to be decided by the trial court, having amended the plaint, and the same has to be converted as a suit for declaration. The counsel also would vehemently contend that referring the judgment of the apex court in a case of Anantala Sudhakar, wherein an observation is made when there is a title dispute and cloud on title, matter requires to be amended, the plaint and comprehensive suit is filed, and based on this judgment only, the remand is made. Having heard the appellant counsel and also appearing for the appellant and respondent, the point that would arise for the consideration is whether the first appellate court committed an error that it is necessary to file a comprehensive suit for declaration and consequential relief to adjudicate right of the parties by setting aside the judgment and decree, and whether the first appellate court is right in holding that the parties have not filed any application before the trial court to make recourse to the provisions of Order 26, Rule 9 for local inspection. What order? Having heard the appellant counsel and also the counsel appearing to the respondent, and particularly, it is not in dispute that plaintiff has sought for the relief of permanent injunction based on the sale deed which had been executed in the year 2011, and also the documents which have been transferred based on the sale deed. It is also not in dispute that when the kata was changed in the name of the plaintiff and the same has been challenged by the defendant. It is also important to note that trial court, first appellate court, having considered the dispute involved between the parties, particularly referring the judgment of the apex court in Anantala Sudhakar versus P. Buchireddy case, and extracted the principles laid down in the judgment in paragraph number 24 of the judgment. Having perused the plaintiff claims the relief of only permanent injunction and not sought for any relief of declaration. And defendant who filed the written statement, that is defendant number 1, specifically contended in the written statement that para 8, that it is the first defendant has got every right, title, interest over the suit scheduled property. And also in paragraph number 15, having denied all averments made in the plaint, specifically pleaded that
Right, 17.
the defendant has put up the thatched roofing with asbestos sheet with the help of the iron pillars and stocked cement bricks to put up a wall on the eastern side and southern side only. It is also specifically pleaded in paragraph number 17 that the suit scheduled property originally belongs to the father of the first defendant. Father-in-law. Father-in-law of the first defendant. And he was in possession. And it is an ancestral property. And subsequent to the death of the father-in-law, property was transferred in the name of the first defendant. And all the family members were residing in the suit scheduled property and claimed the title with regard to the very suit scheduled property and denied the title of the plaintiff and also the title of the vendor. Having considered the pleadings of the plaint and as well as the written statement, and also considering the material available on record, and also it is not in dispute that with regard to the transfer of kata is concerned, appeals are filed before the different authorities, and also exhibit D 21 discloses that even after the remand also ordered to keep the property of the kata in the name of the defendant number 1. And when there is a title dispute between the parties in respect of the very same property, and both of them claims their title in respect of the property, and the judgment which has been applied by the appellate court, that is Anantala Sudhakar case, is very clear that when there is a cloud on the title in respect of the suit scheduled property, the relief is only a comprehensive relief of seeking the relief of declaration. It is also important to note that in the judgment of the appellate court also, while discussing the case of the judgment of Anantala Sudhakar case, taken note of and extracted the order, wherein also specific observation is made, where the plaintiff, believing that the defendant is only a trespasser or a wrongful claimant without title, files a mere suit for injunction. And in such a suit, the defendant discloses in his defense the details of the right or title claimed by him, which raise a serious dispute or cloud over the plaintiff's title. Then there is a need for the plaintiff to amend the plaint and convert the suit into one for declaration. First of all, alternatively, he may withdraw the suit and file a comprehensive suit, having considered the principles laid down in the judgment. And also, when there is a clear dispute with regard to the title is concerned, since the defendant number one also claims title in respect of the social property, and both of them have also agitated the matter before the concerned authorities also with regard to the title, that is transfer of kata, and ultimately defendant number one succeeded in terms of exhibit D21 that kata stands in the name of defendant, having allowed the appeal. And when such claim is made, when there is a cloud on the title, it is up title on the property, and rightly relied upon the judgment of Anantula Sudhakar case, and directed the appellant to seek for an order of comprehensive suit. And if plaintiff is not ready to amend the suit for the relief of comprehensive suit, it is left to him to file a separate suit as observed in the judgment of the Anantula Sudhakar case for seeking the relief of the comprehensive suit. But the first appellate court taken note of the title dispute between the parties and cloud on the title, and given an opportunity to the plaintiff to seek for an appropriate relief for the comprehensive relief. And when such interest was also taken note of the plaintiff by the first appellate court, and also an opportunity is given to both parties to lead their evidence in respect of their contentions, and matter has to be adjudicated with regard to the title is concerned, since both of them are claiming title in respect of the very same property. And when such being the case, I do not find any error committed by the appellate court in allowing the application filed under Order 41 Rule 27, and also giving an opportunity to lead both the parties to lead evidence in respect of their respective claim, and direction given to amend the suit for the relief of comprehensive relief is also for the benefit of the plaintiff, or otherwise he has to seek for the relief of independent relief of comprehensive suit by filing an independent suit. And instead of that, directed to seek for appropriate rate, that too in consonance with the judgment of the apex court in Anantala Sudhakar case. And hence the very contention of the counsel appearing to the appellant that case of Anantala Sudhakar is not applicable to the facts of the case and cannot be accepted, since there is a title dispute with regard to the property involved between the plaintiff and defendant number one also specifically claims the title in respect of the very same property, that as an and the same is an ancestral property of the defendant one father-in-law, and relies upon the records also prior to the sale deed of the year 2011 that property was standing in the name of the father-in-law, and subsequent to the death of the father-in-law, same was transferred in the name of the defendant number one. And when such being the case, in remanding the matter, I do not find any error, and hence I answered the point accordingly. In view of the discussions made above, MSA is dismissed.
My lord, the time frame may be fixed, my lord.
ಆಯ್ತು, ಟೈಮ್ ಅಂದ್ರೆ ನೀವು ಅಮೆಂಡ್ ಮಾಡ್ಕೋಬೇಕು.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು
ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಒಂದ್ ವರ್ಷ?
ಒಂದು ವರ್ಷ ಎಲ್ಲ ಬೇಕು
ಬೇಕಲ್ರಿ, ಅಮೆಂಡ್ ಆಗ್ಬೇಕು. ಎವಿಡೆನ್ಸ್ ಆಲ್ರೆಡಿ ಮಾಡಿದಿರಿ, ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರು ಮಾಡ್ಬೇಕು. ಎಷ್ಟು ಬೇಕು ಹೇಳಿ, ನೀವೇ ಹೇಳ್ಬಿಡಿ, ನಮ್ಗೇನಿಲ್ಲ.
ನಾವು ರೆಡಿ ಇದೀವಿ, ನಾವು ರೆಡಿ.
ನೀವು ರೆಡಿ ಇದೀರಿ? 6 months 9 months?
9 months, within 9 months.
ಆಯ್ತು. The trial court is directed to dispose of the matter within a period of 9 months. Both the appellants and respondents and their respective counsels are directed to assist the trial court in disposal of the case within a period of 9 months.
9 months. And observation made in this appeal shall not.
ಏನಾಯ್ತು ಮೇಡಮ್? ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಲ್ಲ, the registry is directed to send the records forthwith to the concerned court, and both parties are directed to appear before the trial court on 14th of July.
ಆಗ್ಬೋದು, ರೆಕಾರ್ಡ್ ಹೋಗಿದ್ರೆ
14th of July without expecting any notice from the trial court, and from that date within 9 months ಕೊಟ್ಟಲ್ಲ, within 9 months dispose of the same. The registry is also directed to send the records to the concerned court to enable the court to take up the matter without fail on 14th of July 2025. The discussion made and observations made in disposing of this MSA shall not influence the trial court while considering the matter on merits.
Reporting settlement 71, Manchuna, Narayan Swami K.
ಏನ್ ಮಾಡಿರ್ರಿ ಬಂದ್ರೇನ್ರಿ ಫೈಲ್ ಮಾಡಿದ್ರೇನ್ರಿ
No, my lord.
ಎಷ್ಟ್ ದುಡ್ಡು ಬಂತು ಎಷ್ಟ್ ದುಡ್ಡು ಬಂದಿಲ್ಲ ಅಂತ
Actually, compromise was not materialized. They have not paid any amount. As per the instruction of my client.
25-30 ಲಕ್ಷ ಕೊಟ್ಟವ್ರ ಅಂತ ಹೇಳಿದ್ರಲ್ರಿ ಅವ್ರೆ
Actually, agreed amount is not paid. Very small amount, major amount is being paid.
But you have received the part amount.
Part of the amount.
Don't make such submission before the court. ಹೇಳ್ಬೇಕು ಪಾರ್ಟ್ ರಿಸೀವ್ ಮಾಡಿದ್ರಿ ಬಾಕಿ ಕೊಟ್ಟಿಲ್ಲ
Partial amount.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ಎಷ್ಟು ರಿಸೀವ್ ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳಿ ಕೊಡಿ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕ್ತೀವಿ ಅಂದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲಿ ಮೇಡಮ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್ ನೀವ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ ಕೊಡ್ರಿ ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಅಲ್ಲ ಮೇಡಮ್ ಇದು ಆಮೇಲೆ ಬಂತಲ್ಲ ಮೇಡಮ್ ಇದಲ್ವಾ ಕಾಂಪ್ರಮೈಸ್ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಲ್ಲ ಇದೆ ಅಲ್ವಾ ಇದು ಬೇರೆ ಮ್ಯಾಟ್ರ ಇದೇ ಮ್ಯಾಟ್ರ್
ಇದೇ ಮ್ಯಾಟ್ರ್ ಸ್ವಾಮಿ
ಮೇಡಮ್ ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಮಾಡೋದು ಲಾಸ್ಟ್ ವೀಕ್ ಏನಲ್ಲಿ ಇಷ್ಟ ಆಗಿತ್ತಲ್ವ ಇದು
ಹೌದು ಆಗಿತ್ತು my lord, yes my lord.
ಟೈಪ್ ಮಾಡ್ರ ಅದ್ರ ಹಿಂದಿನ ಡೇಟ್ ತೆಗೀರಿ ಲಾಸ್ಟ್ ಟೈಪ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿ ಅಂತ ನಾ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ನಲ್ರಿ ಇಬ್ರಿಗೂ ಅಲ್ವಾ ಏನ್ ಪೇಮೆಂಟ್ ಮಾಡಿದಿರಿ ಅದಕ್ಕೆ ಹಾ
ಮಾತಾಡಿದ ನಂತರ ವಾಟ್ ಆರ್ ದ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಪಾರ್ಟಿ ಮಗಳು
According to the instruction given.
ಮದರ್ ಡಾಟರ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ಅವರೇ ಕುರಿತು ಮಾತಾಡಿದ್ದಾರೆ ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಡಾಟರ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ಅವರೇ ಕುರಿತು ಮಾತಾಡಿದ್ದಾರೆ
They are asking another 4 months time for settling entire amount. It's not entire amount, that too part of the amount.
ಈಗ ನಿಮ್ಗೆ ಎಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಹೇಳ್ರಿ
around 20
ಅದನ್ನೇ ನಾನು ಹಾಕಿದ್ದೆ ನೀವು ಹಾಕಿ ಅವರು ಹಾಕಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ ಅವ್ರ ಯಾರ ಇವ್ರು 50 ಲಕ್ಷ ಕೊಟ್ಟಿದೀವಿ ಅಂದ್ರು ನೀವು 20 ಲಕ್ಷ ಬಂದಿದೆ ಅಂದ್ರೆ ಅದಕ್ಕೆ ನೀವೊಂದು
ಸಬ್ಮಿಷನ್ ಮೇಡ್ ವಾಸ್
ಎಷ್ಟು ದುಡ್ಡು
60 ಲಕ್ಷ ಅಪಲೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ 60 ಲಕ್ಷ ಅಪಲೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ
60 ಲಕ್ಷ
60 ಲಕ್ಷ 15 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಆಲ್ ಚೆಕ್ ಪೇಮೆಂಟ್ಸ್
ಆನ್ಲೈನ್ ಚೆಕ್ ಹೇಳ್ರಿ ದುಡ್ಡು ರಿಸೀವ್ ಮಾಡಿದ್ರ ಆನ್ಲೈನ್ ಚೆಕ್ ಬಂದ್ರೆ ಎಷ್ಟು ಬಂದಿದೆ ಹೇಳ್ರಿ ದುಡ್ಡು
well it's that time last time from the appellants and
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ನಲ್ಲ ನಿಮಗೆ ದುಡ್ಡು ಎಷ್ಟು ಬಂದಿದೆ ಹೇಳಿ ಅಂತ ಅವ್ರು ಬಂದ್ ಹೇಳಿದ್ರು ನಮ್ಗೆ ಈ ಖಾತಾ ಬಂದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ನಾನ್ ಅದಕ್ಕೆ ಏನ್ ಹೇಳಿದೆ ಅಮೌಂಟ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಯು ಗಿವ್ ದಿ ಮೋರ್ ಇದು ಜಾಸ್ತಿ ಅಮೌಂಟ್ ಕೊಡಿ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಬೇಕಾದ್ರೆ ರಿಟೈನ್ ಮಾಡ್ಕೊಂಡು ಈ ಖಾತಾ ಬಂದ್ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಐ ಸಜೆಸ್ಟೆಡ್ ಅದರ್ ಸೈಡ್ ಆಲ್ಸೋ ಬಟ್ ನೀವ್ ಅವಾಗ ಏನ್ ಹೇಳಿದ್ರಿ ಇಲ್ಲ ನಮಗೆ ಕೊಟ್ರದ ಬರೀ 20 ಲಕ್ಷ ಜಾಸ್ತಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರಿ ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ದುಡ್ಡು ಹೇಳಿ ಹೋಗ್ಲಿ
ಪಾರ್ಟೀಸ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಮೌಂಟ್ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡೋದು ಬೇಡ ಬಿಕಾಸ್ ಒಬ್ಬೊಬ್ರನ್ನ ಒಂದೊಂದು ಅಮೌಂಟ್ ಗೆ ಅವರು ಒಪ್ಸಿದ್ದಾರೆ ಮೆಲಾಟ್ಸ್ ದಟ್ ಈಸ್ ದೇರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಓನ್ಲಿ they are telling me that don't disclose the figure before the court
submission
because
I am for 22 or 22 till today no words has been taken place between
no
discussion has been taken place
ನೀವು ಯಾವತ್ತು ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ರಿ ಇವತ್ತು ಬಂದಿದ್ ಬಿಟ್ರೆ
ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೆಗ್ಯುಲರ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡ್ರಿ ಇಲ್ಲಿ ಯಾವತ್ತು ಬಂದಿದ್ದೀರಿ ಹೇಳಿ
ಸ್ಟೇ ಆಗಿದೆ ಅಂತ ಮಿಸ್ಲೀಡ್
ಸ್ಟೇ ಆಗಿದ್ ಬಿಟ್ಬಿಡಿ ನೀವು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದಿರಾ ಇಲ್ಲಿ
2 weeks ago
ಹಾಕಿದಿರಾ ಈಗ 2 weeks ago you never appeared before the court
ಮಾತಾಡೋಣ
ನೋಡ್ರಿ ಇದು 2 ವರ್ಷದ ಹಿಂದೆನೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಟೈಮ್ ತಗೊಂಡ್ಕೊಂಡು ಬಂದ್ರು ಇಬ್ರುವೆ ನೀವ್ ಯಾವತ್ತೂ ಬಂದಿಲ್ಲ
ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಗ್ಯುಲರ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಿ
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪಿಯರ್ ಆಗಿರ್ಬೋದು ಇಲ್ಲಿದೆ ಹೇಳಿ ಫಸ್ಟ್
ಇದೆ ಅಂತ ಮಿಸ್ಲೀಡ್ ಮಾಡಿದ್ರು
ಇಲ್ಲಿದೆ ಹೇಳ್ರಿ ಇಲ್ಲ ಪಾರ್ಟ್ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಲ್ಲೇ ಡಿಸಿಷನ್ ತಗೊಳ್ಳಿ ಏನ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ನೀವು ಏನ್ ಮಾಡೋದು ಹೇಳಿ ನಾನು 2 ವರ್ಷದಿಂದ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ
Actually, they are not coming forward to settle the matter.
we have also no voice we are also little embarrassed
ನಾನು ಮೋಸ್ಟ್ಲಿ 1.5 year ಆಗಿರ್ಬೇಕು ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ
embarrassed
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗಿತ್ತು ಸರ್ ಅಪ್ಲೈ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ
Learned counsel for the respondent seeks 4 weeks time to report settlement. Settlement ಅಂತಲೇ ಹೋಗ್ತಾ ಇದೆ ಆವಾಗಿಂದಲೂ. ಆವಾಗ ನೀವೇನ ಮಧ್ಯದಲ್ಲಿ ಹೇಳಿದ್ರಿ ಇಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಇಷ್ಟು ದುಡ್ಡು ಕೊಡೋದು ಅಂತ ಆಯ್ತು ಅದ್ರ ಪ್ರಕಾರ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಪಾರ್ಟ್ ಪೇಮೆಂಟ್ ಅನ್ನ ಮಾಡ್ತೀವಿ ಅಂತ ಪಾರ್ಟ್ ಪೇಮೆಂಟ್ ಎಲ್ಲ ಮಾಡಿದ್ರು.
And court's permission was also sought for selling few apartments which were released.
ಅದು ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಅದು ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದು ಆರ್ಡರ್.
ಮತ್ತೆ ಈಗ ಆಲ್ರೆಡಿ
ಅದನ್ನ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Due to change in the policy, they are not able to conclude the sale deed. That is the difficulty.
There is no transparency.
They wanted to drag on the matter rather than settle the matter. That is the reason this matter is not getting settled, please.
The first order is on 12/2/2020.
12/2/2020
was the first order. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ when all the properties were sold, what were the other properties that can be protected to save the ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಒಂದು 7 ಗುಂಟೆ ಲ್ಯಾಂಡ್ ಇದೆ, ಮಿಕ್ಕಿದ್ದು 15 ಅಪಾರ್ಟ್ಮೆಂಟ್. ಇನ್ಫ್ಯಾಕ್ಟ್ when we offered 10 apartments, court did not agree, and honorable court said they calculated in fact what is the share, what is the land area, what is the FAR ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ court suggested no 10 apartments would not be sufficient, let it be 15 apartments, 14 apartments. ಆ 14 apartments ನಾವು ರಿಸರ್ವ್ ಮಾಡಿದ್ವಿ. Now ಅದರಲ್ಲಿ ಏನಾಯ್ತು, then subsequently they wanted to settle the matter. The developer is not involved in the settlement. It is between inter se, because their share we have already given, we have kept it ready. These apartments were withheld to pay my other few apartments ittu, ಕೆಲವು ಅವ್ರದಿದೆ, ಕೆಲವು ಮಾರಿಲ್ಲ. So ನಮ್ದು ಒಂದು ಕೊಟ್ಬಿಟ್ವಿ ಸ್ವಾಮಿ. We also said we will also contribute one apartment which is unsold. Then totally 14 apartments are reserved. Now they came up with a proposal that we will settle them by way of monetary considerations. ಅಲ್ಲೇನ್ ಮಾಡಿದ್ರು, monetary considerations ಅವರು ಅಗ್ರಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಡಿಪೆಂಡಿಂಗ್ ಆನ್ their shares. ಈಗ appellants ಜಾಸ್ತಿ ಇದ್ದಾರೆ, respondents ಒಂದು ಇಬ್ರು ಇದ್ದಾರೆ. So what they did was the appellant took the lead to see that the matter will be settled by taking into confidence their branch, who is before your honor now, my lord now, who has come before my lord now. Their branch settlement also covers him. So a memo was moved by consent of the parties. Few apartments were ordered to be released, maybe around 5 or 6. 5 apartments were ordered to be released for the purpose of
sell the apartments
ಈ 14ರಲ್ಲಿ
to pay the amount in favor of them.
ಅದನ್ನ they have already processed, and these are the apartments which are released at the hands of this honorable court. Those agreements were entered into with respect to those apartments, and the advances were paid by the purchasers. After being convinced about the order of this honorable court, they have also invested the money. In the meantime, e-khata requirement was brought in by the revenue department, wherein the registration was stalled. Our bank loans ella tagondu, they kept it ready, few of the purchasers. In the meantime, the e-khata process has been initiated, and due to the change in the policies, the sale deed could not be registered. Unless until the sale deed is registered, bank will not release the balance payment. This is where we stand.
In terms of the agreement between the parties in a monetary consideration, what is the agreement? Put in order.
ಅದು ಅವರೇ ಹೇಳಬೇಕು ಸುಮ್ಮನೆ.
Agreement.
There is no agreement whatsoever, please my lord. It is orally agreed between the parties. Orally agreed between the parties.
Orally agreed.
Orally agreed between the parties.
Orally agreement ಪ್ರಕಾರ ಎಷ್ಟು ಹೇಳಿ?
ಅದು ಅವರೇ ಹೇಳಬೇಕು ಸ್ವಾಮಿ.
ನಿಮಗೆ ಎಷ್ಟು ಕೊಡಬೇಕ್ರಿ? ನಿಮ್ಮ
one of the parties to the proceeding.
Daughter of orally agreed. They had agreed to give us 6 plots or 2.5 CR.
6 plots
or 2.5 CR only for the second appellant.
What about the first appellant?
I do not know what has been transpired between them.
ನೀವು ಫಸ್ಟ್ ಅಪ್ಲೆಂಟ್ ಬೇರೆ ಬೇರೆ ಮಾತಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಮಾತಾಡ್ಕೊಂಡಿದ್ದೀರಿ. ಆಯ್ತು ಬಿಟ್ಬಿಡಿ, ಅದು ನಮಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಈಗ ಫಸ್ಟ್ ಅಪ್ಲೆಂಟ್ ಒಂದು ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕಿಲ್ಲಿ, ಅಪೀಲ್ ಹಾಕಿರೋರು ಅವರು ಅಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಹೌದಲ್ಲ? ನೀವು ಫಸ್ಟ್ ಅಪ್ಲೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಈಗ 2.5 CR ಅಲ್ಲಿ ಅಥವಾ 6 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ದುಡ್ಡು?
20 lakhs please madam. 20 lakhs.
20 lakhs ಅಂದ್ರೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ ಅಂದ್ರೆ ಎಷ್ಟು ಜನ ಕೊಟ್ಟಿದ್ದೀರಿ? ಈಗ 3 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? 3 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅಲ್ಲಿಗೆ 60 ಲಕ್ಷ ಕೊಟ್ಟಂಗಾಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, only for appellant number 2, 2.5 CR was agreed. Only for appellant number 2, Muniyang Tamma, 2.5 CR was agreed, or 6 flats.
Or 6 flats.
Yes.
ಏನ್ರಿ?
May not be.
6 ಫ್ಲಾಟ್ ಅಥವಾ
May not be
2.5
correct.
ಕೋಟಿ ಅಂತ.
May not be correct. May not be correct.
that was
ಯಾಕೆಂದ್ರೆ
the
ಎಲ್ರಿಗೂ
agreed
ಸೇರೆ
because-
ಬರೋದು 14 ಅಪಾರ್ಟ್ಮೆಂಟ್.
This is what they are doing right from the day one, please my lord. They agree for one thing,
with
but
respect
they
to the
won't come
branch
up
of
with that.
Guramma, who is one of the daughters out of 7 daughters. Gullamma, out of 1/7 share, they are together, they are entitled for 14 apartments.
ಓ ಎಲ್ಲರೂ
ಎಲ್ರಿಗೂ ಸೇರಿಸಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್. ಆಮೇಲೆ ಇನ್ನಿಬ್ರು ಇದ್ದಾರೆ ರೆಸ್ಪಾನ್ಸ್ ನಂಬರ್ 20.
My lord, if that was the case, they could have been transferred to sit all of them together and come to the conclusion. Why did not ask for individually for each of them to array different?
ಫಸ್ಟ್ ಅಪ್ಲೈಂಟ್ ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗೋದು? ನೀವೇನೋ
I appear for first appellant also.
First appellant also.
As first appellant
What
also.
first appellant says?
Actually, first
That they have
appellant,
received the money?
no, there is no instruction whatsoever since they themselves are talking with him.
But where is your client?
He is not coming before there since there is under the control of the respondents.
ಏನ್ರಿ?
He is under their control now.
ಅಲ್ಲ ಕಂಟ್ರೋಲ್ ಸರಿ, ಈಗ ನಿಮ್ ಕ್ಲೈಂಟೇ ನಿಮ್ಮ ಹತ್ರ ಬರಲ್ಲ ಅಂದ್ರೆ
ಏನ್ ಮಾಡೋ ಸ್ವಾಮಿ, ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ನಾನು ಇದ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನಮ್ಮ ಹತ್ರ ಎಲ್ಲಿ ಬರ್ತಾರೆ ಸ್ವಾಮಿ?
ಲೋಕದಾಲತ್ಗೆ ದಯವಿಟ್ಟು ರೆಫರ್ ಮಾಡಿ ಎಲ್ಲ ಪ್ರೆಸೆನ್ಸ್ ಇರೋ ಫಸ್ಟ್ ಅಪ್ಲೈಂಟ್ ತಮ್ಮ.
My lord, I am ready to.
ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್
ನೀವು ವಕಾಲತ್ ಹಾಕಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಎಷ್ಟ್ರಿ?
22 ಸರ್.
22 ಇಲ್ಲ, ಅದು ವಕಾಲತ್ ಇದ್ದಂಗಿಲ್ಲ.
ಹರ್ಷ ಅಂತ.
ಹರ್ಷ ಫಾರ್ 22.
ಹೌದು ಸರ್. ಐ ಆಮ್ ಗುಣಶೇಖರ್, ಐ ಆಲ್ಸೋ ಸೈನ್ಡ್ ವಕಾಲತ್.
ಏನ್ರಿ ಈಗ ಇಲ್ಲ ರಿಲೀಸ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
My lord, they won't come forward, please my lord.
ಅಲ್ಲ ರೀ, ನೀವು ಕೂತ್ಕೊಂಡು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ?
We are ready to argue the matter upon merits.
ಆಗಲ್ಲ. ಅಲ್ಲ ಅವ್ರ ಪ್ರಕಾರ ಸೆಕೆಂಡ್ ಅಪಲೆಂಟ್ ಗೆನೆ ನೀವು ಅಗ್ರೀಡ್ ಟು ಗಿವ್ 6 ಫ್ಲಾಟ್ಸ್ ಆರ್ 2.5 crores ಅಂತ ಅವ್ರು ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನೀವು ನೋಡಿರಿ ಇಲ್ಲ ಅಂತೀರಿ, ಮತ್ತೆ ಹೆಂಗ್ ಸೆಟ್ಲ್ ಹೆಂಗ್ ಆಗುತ್ತೆ ಇದು? ಸೆಟ್ಲ್ ಹೆಂಗ್ ಆಗುತ್ತೆ ಹೇಳಿ? ವೈ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಗ್ರಾಂಟ್ ಟೈಮ್? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗ್ಲಿ ಬಿಡಿ.
ಆಗ್ಬೋದು ಸರ್
ಅಲ್ವಾ?
ಅಪಲೆಂಟ್ ನಂಬರ್ 1 ಬ್ರದರ್, ಓನ್ ಬ್ರದರ್ ಸರ್
ಅಪಲೆಂಟ್.
ಹೌದು ಸರ್. ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾರೆ.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರಿ, ದಾಖಲೆಯಲ್ಲಿ ತೋರಿಸಿ ಅಷ್ಟೇನೆ. ಈಗ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗ್ತಿಲ್ವಲ್ಲ ಮತ್ತೆ?
We are ready.
ಅಲ್ಲಮ್ಮ, ಈಗ ಆಕ್ಚುಲಿ ಏನು ನಿಮ್ಗೆ 2.5 crores ಒಪ್ಕೊಂಡಿದಾರ 6 ಫ್ಲಾಟ್ಸ್? ನೀವಲ್ದಲ್ಲಿ ಇನ್ಯಾರು ಎಂಟೈಟಲ್ಮೆಂಟ್ ಇದಾರೆ ಹೇಳಿ? ನಿಮ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ 6 ಫ್ಲಾಟ್ ಕೊಟ್ಟಿರೋದು 14ರಲ್ಲಿ, ಇನ್ನು ಉಳಿಯೋದೇ 8.
One more is Timrayappa
and 3 more.
ಅವ್ರಗಳಿಗೆಲ್ಲ ಮತ್ತೆ
that is the reason they are transferred. They are convincing them with the different ratio to each of them. Those who are coming before the court and contesting the matter, they are getting higher ratio. Those who are not coming before the court, they are getting lower ratio. That is the truth.
ಹಂಗೆ ನೀವು ಅವ್ರಿಗೆ ಜಾಸ್ತಿ ಕೊಟ್ಟು ಇವ್ರಿಗೆ ಕಡಿಮೆ ಕೊಡ್ತಾ ಇದೀರಿ ಅಂತ ಅವರು.
Yes, my lords. That's why they are not allowing us to discuss.
ಆಯ್ತು, ಹೋಗ್ಲಿ, ನೀವು ಅವ್ರಿಗೆ ಎಷ್ಟಾರು ಕೊಟ್ಕೊಳ್ಳಿ.
ನಮ್ದಾದ್ರೂ
ಕೊಡ್ಬೇಕಾದ್ರೆ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ ಅಲ್ವಾ? ಕುತ್ಕಾಡ್ಸಿರ ಹೆಂಗ್ರಿ? ಹೇಳ್ಬೇಕು ಬಾಯ್ಬಿಟ್ಟು. ಏನಂತ ಅಫಿಡವಿಟ್ ಹಾಕ್ಸ್ತೀರಿ? ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಯ್ತು ಹೇಳ್ಬಿಡಿ. ಈಗ ಅಪೀಲ್ ಹಾಕ ಬಂದಿರೋದು ಅವರು ಅಲ್ವಾ? ಇವ್ರೆ ಅವ್ರ ಜೊತೆ ಮಾತಾಡ್ತಾ ಇದ್ರ? ನೀವ್ ಮಾತಾಡಿರಂತಲ್ಲ ಮೇಡಮ್?
Lords, they are asking another 5 months time for settling certain amount.
ನಿಮ್ ಕಡೆಯವ್ರು ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ, ನಿಮ್ಮ ಹತ್ರ ಅಂತ ಇದ್ದಾರೆ.
ನೀವೇನೋ ಮಾತಾಡ್ತಾ ಇದ್ರ?
Parties were talking to me. ಅವ್ರು ಮಾತಾಡ್ತಿದ್ರು, ಅವ್ರು ಹೇಳ್ತಿದಾರೆ another 5 months time ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
ಯಾರು ಕೇಳ್ತಾ ಇರೋದು?
Respondents my lords.
ನೀವೇನ್ರಿ 5 ತಿಂಗಳು ಕೇಳಿದ್ರ? ನಿಮ್ಮ ಪಾರ್ಟೀಸ್ 4 months. ಆಯ್ತು, ಈ ಖಾತಾ ಆಗಲ್ಲ, ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಿ? ಆಗ್ಲೂ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಈಗ ನೀವು ಕಥೆ ಹೇಳೋದು ಈಗ ಈ ಖಾತಾ ಆಗಿಲ್ಲ, ಅದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ ಅಂತ, ಹೌದಲ್ಲ? ಈಗ ಹಂಗಾರೆ ನೀವು ಅಡಿಷನಲ್ ಪೇಮೆಂಟ್ ಮಾಡಿ, ಆಮೇಲೆ ಬೇಕಾರೆ ಎಷ್ಟ್ ಮಾಡ್ತೀರಿ? ಯಾವಾಗ ಮಾಡ್ತೀರಿ ಹೇಳಿ?
At least flat agreement ಹಾಕೊಡಿ ಅಂದ್ರೆ ಅದು
ಆಯ್ತು, ಅದನ್ನೇ ಮಾಡಿ. ಇಲ್ಲ ಫ್ಲಾಟ್ ಕೊಡಿ ಅವರಿಗೆ. ದುಡ್ಡಾರು ಕೊಡಿ ಇಲ್ಲ ಫ್ಲಾಟ್ ಆರು ಕೊಡಿ. ಯಾವಾಗ ಮತ್ತೆ ನಾನು ಟೈಮ್ ಕೊಡಲ್ಲ, ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇಬ್ರು ಮಾತನಾಡಿ ಐದರ್ ಯು ಗಿವ್ ಫ್ಲಾಟ್ ಆರ್ ಗಿವ್ ಮನಿ, ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಮೌಂಟ್ ಕೊಡಿ. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ 4 ತಿಂಗಳು ವೇಟ್ ಮಾಡಕ್ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ನೀವು ಅಟ್ಲೀಸ್ಟ್ ದುಡ್ಡು ಕೊಡಿ ಸ್ವಲ್ಪ.
My lord, 2 years ago, it was agreed for 2.5 crores. There the flat value was 40 lakhs. In that ratio, that was agreed. Now the flat value is 80 to 90 lakhs.
ಈಗ ಏನ್ ಜಾಸ್ತಿ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮತ್ತೆ ಚೇಂಜ್ ಮಾಡಂಗಿಲ್ಲ. ಒಂದ್ ವಾರ
2 years they have taken to settle the matter. What should I do with the 2.5 crores?
ಒಂದ್ ವಾರದಲ್ಲಿ ಹೇಳಿ ಅವ್ರು ಏನಿದೆ ಅಂತ. ಫಸ್ಟ್ ಲೆಟ್ ದೆಮ್ ಪೇ ಆರ್ ಲೆಟ್ ದೆಮ್ ಗಿವ್ ಫ್ಲಾಟ್. ನಿಮ್ಗೂ ಫ್ಲಾಟ್ ನಿಮ್ಗೆ ರೇಟ್ ಜಾಸ್ತಿ ಆಗ್ತಾ ಹೋಗುತ್ತೆ.
ಅಲ್ಲ, if they are asking for, no, my concern, if they are asking the apartments over and above their entitlement, it will be difficult
over and
scenario. Their entitlement. ಈಗ ಏನಾಗಿದೆ, appellants ತಾವು ನೋಡ್ಬೋದು ಸ್ವಾಮಿ, ಈ ಗುಳ್ಳಮ್ಮದ ಒಂದು ಶೇರ್ is affected, 1/7 share. 1/7 share. The Gullama branch is represented by this appellant's number 1 to the appellant number Timrayappa.
Error ಅಂತ ಹೇಳ್ಬಿಡಿ, ನಂಬರ್ ಹೇಳ್ಬಿಡಿ.
Appellant number 1, appellant number 2.
Family code
3, 4, 5.
1, 2, 3, 4, 5.
4, 5 are the daughters of the one of the daughters. I mean.
ಅಲ್ಲ, A1, 2, 3, 4, 5 and 22 na? They are the children of Kullamma.
No, please, my lord. Appellant number 1 and 2 are the children's. 3, 4 and 5 are the grandchildren's.
3, 4, 5 are the
grandchildren's.
Grandchildren through whom?
Kullamma. Through one of the daughter. 5 jana, sir. 5.
ಅಲ್ಲಿಗೆ 14 apartments is to be shared amongst
5. Among the 5.
ಅದರಲ್ಲಿ ಒಬ್ಬರಿಗೆ 6 ಕೊಟ್ರೆ ಮಿಕ್ಕವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ? That is where the dispute starts. So that's what they claim, that ಕೊಟ್ಬಿಡ್ತೀವಿ. ಅದಕ್ಕೆ ನಾವು we did not offer apartments. They did not offer apartments. They offered price. ನಿಮಗೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡ್ತೀವಿ, ಮಿಕ್ಕವ್ರು ಬೇಕಾದ್ರೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ
ತಗೊಳ್ಳಿ ಅಂತ.
That was the understanding, not the apartments.
My lord, as per the schedule, survey number 14, where is the apartment is been built up subsequent to the institution of the suit. It is measuring 3 acre 29 guntas. In 3 acre 29 guntas, as per Thotmuniam Act, 7 children, including Gullama, my grandmother. As such, I am entitled to 1/7 share in survey number 14. 1/7 share of 3 acre 29 guntas, it comes to around 20 guntas. I am entitled to 20 guntas.
ಹೌದು, ಅದನ್ನೇ ನಾವು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ವಿ. In fact, court calculated that only. Then they looked into the sanction.
ಆರ್ಡರ್ ಇದೆ ನೋಡಿ, ಒಂದು 2020 ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಇದೆ.
ಇದೆ ಸ್ವಾಮಿ. That was roughly calculated. It was not
accurately calculated. It was accurate.
That was the case. If they give us our land, that's more than enough for this. Actually, they have put up the construction by overriding all rules and regulation after the institution of the suit.
ದುಡ್ಡೇ ಕೊಡ್ರಿ, ನೀವು ಮ್ಯಾಕ್ಸಿಮಮ್ ಹಾಕಿ ಏನ್ ಬರುತ್ತೆ ಅಷ್ಟನ್ನ ಏನ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರಿ ಅದ್ರ ಕೊಡಿ. ಬಾಕಿ ಇವ್ರು ಏನ್ ಇದಾರಲ್ಲ 5 ಜನ ಮಕ್ಕಳು, ಅವ್ರವ್ರು ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ ನಿನ್ನೆಲ್ಲ ಬಾಕಿ ಒಪ್ಕೊಂಡಿದಾರೆ ಎಕ್ಸೆಪ್ಟ್ ಇವರು.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅವ್ರೊಬ್ರು ಯಾರು 22 ಇದ್ದಾರೆ. He was also present. ಇವ್ರಿಗೆ ಬೇರೆ ಎಲ್ಲಾರ್ಸ್ ಯಾರಿದ್ದಾರೆ ಇವ್ರ ಜೊತೆ? ಒಬ್ರೇನಾ? ಇವ್ರು ಒನ್ ಆಫ್ ದಿ ಡಾಟರ್ ಸನ್
ಆಫ್ ಗುಳ್ಳಮ್ಮ, ಒನ್ ಆಫ್ ದಿಸ್.
ಅಲ್ಲಿ ಇವನಿಗೆ ಒಂದ್ ಶೇರ್ ಬರುತ್ತೆ, ಒಂದ್ ಶೇರ್ ಬರುತ್ತೆ. ಇನ್ನ ಇವ್ರ ಕಡೆಯಿಂದ 1-2, ಇನ್ 3 ಜನ ಉಳಿತಾರೆ. 3 ಜನಕ್ಕೆ ಸೆಟ್ಲ್ ಆಗಿದೆ. ಇನ್ ಇವ್ರಿಬ್ರು ನೀವು ಸೆಟ್ಲ್ ಮಾಡಿ, ಅದ ಮಾಡಿ ಅಂತ. ಹೌ ಲಾಂಗ್ ಯು ಕ್ಯಾನ್ ಕೀಪ್ ದಿ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್? ಇವ್ರಿಗೆ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಈ ಮನುಷ್ಯನ್ಗೆ? ಬರ್ಲಿಲ್ಲ ಅಂತ ನೀವು ಬಿಟ್ಟೇನ್ ಸೆಟ್ಲ್ ಮಾಡಕ್ ಆಗಲ್ವಲ್ಲ? ಈಗ ಅವ್ರದ್ದು ಸೆಟ್ಲ್ ಮಾಡ್ಬೇಕು ನೀವು. You are appearing for whom?
In fact, appellant took the initiative to settle him.
1, 2, 3 na?
Appellant took initiative to settle him also. Appellant took the initiative to settle the claim of this Mr. Venkataswamy also. ಅವರು initiative ತಗೊಂಡಿದ್ರು, ಅದರಿಂದ they could not.
No, my lord, we did not. Never we have touched the defendant number 30 to 22. It is that they took up the undertaking that we will settle all of them, talk about your share only. In that context, we spoke with respect to our share.
Narayan Swami ಏನ್ರಿ ಇದಿರಲ್ಲ R1 to R3
R22 some.
7 to 10 and 12 told counsel for R1 to 3 R7 to 10 and 12 to 17 submits that he is going to settle the issue between the R22 and also the appellant number 2 alla
Yes.
appellant number 2 and make submission in the next week. Next ಬುಧವಾರ ಇವತ್ತಿನ 8 ದಿವಸಕ್ಕೆ ಹಾಕಿ ಮೇಡಮ್ 20 26
ಬೇಡ ಸ್ವಾಮಿ 26 I will not be in station.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ
28, 27, 28.
27th ಇರ್ತೀರಾ
ಇರ್ತೀನಿ ಸ್ವಾಮಿ.
27th ವರ್ಕಿಂಗ್ ಅಲ್ಲ 27th ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಫಸ್ಟ್ ವೀಕ್ ತುಂಬಾ ದೂರ ಆಗ್ತದೆ. ನೀವು ಬರೀ ಅದನ್ನೇ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು. ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇಲ್ಲ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ಪಾರ್ಟರ್ಡ್ ಆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ. ನೀವು ಆಗ್ಲೇ ಈಗ ಅರ್ಧ ಗಂಟೆ ಆಯ್ತು.
ಅಲ್ಲ ಈಗ ಫೈನಲಿ my lord, if it is not going to be settled, the interim order is already there, which is under which they are protected. In fact, these are all the properties, only properties available. All other properties are sold.
Already
sold, they are staying with their families.
Purchasers are also staying.
Your share equivalent agi, this honorable court calculated the share. Nan 10 apartments ಹಾಕ್ತೀನಿ ಅಂತ memo ಹಾಕ್ತೆ. Court did not agree. Then we had to calculate as per the plan. Our share 20 ಗುಂಟೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ FIR ನೋಡಿ ಬಿಲ್ಡರ್ ಶೇರ್ ಎಷ್ಟು ಹೋಗುತ್ತೆ, ಲ್ಯಾಂಡ್ ಓನರ್ ಶೇರ್ ಎಷ್ಟು ಹೋಗುತ್ತೆ ಸಾಹೇಬ್ರೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ. Then he said 14 apartments you reserve. And there is another buffer of 7
in respect of all the legal heirs of
Kullama.
ಹೌದಾ?
So their interest has been protected. Even if they are declared a share, these apartments will go to them. ಅಷ್ಟೇ ಇಲ್ಲಿ, otherwise there is nothing to.
My lord, that is not the case before the trial court. Before the trial court, survey number 14 measure 3 acre 29 guntas is an agriculture property as on date of the institution of the suit. Subsequent to the institution of the suit, the builder purchased the property from one of the co-owner and put up a construction. And now he is telling that it is a constructed property.
Subsequent to the filing
Yes,
of
yes,
suit.
please, my lord.
Suit ಯಾವ year though?
2012 Swami. 13 Swami. 13.
Was there any interim order?
ಇಲ್ಲ Swami, interim order ಇಲ್ಲ. However, less operates against them.
ಆಯ್ತು, ಆಗ ಈಗೆಲ್ಲ ಮತ್ತೆ ಹಿಂದಕ್ಕೆ ಹೋಗೋದ್ ಬೇಡ, ಏನೋ ಒಂದ್ ದಾರಿ ಮುಂದಕ್ಕೆ ಬಂದಿದ್ರಿ, ಅಲ್ಲಿಂದ ಮುಂದೆ ನೋಡಿ. ಆಯ್ತು.
Let them give the flats as agreed by them. That's
on 27/6.
Preferably, can you direct them to give the flats?
So ನಾವು ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, we were in fact ready to settle the matter. ಇಲ್ಲೇನಾಗಿದೆ, few of the family members deny the relationship of ಗುಳ್ಳಮ್ಮ. ಗುಳ್ಳಮ್ಮ ಮಗಳೇ ಅಲ್ಲ ಅಂತ ಕೆಲವರು ಹೇಳ್ತಾರೆ, ಗುಳ್ಳಮ್ಮ ಮಗಳು ಅಂತ ಕೆಲವರು ಹೇಳ್ತಾರೆ. So because of this dispute in the relationship, matter could not be settled. Otherwise, developer would have definitely barged in and would have tried to settle it.
This is a new story, Swami.
ಅಲ್ಲ, stay ಇಲ್ಲ.
Kindly see the return statement filed by the.
In fact, in ವಂಶವೃಕ್ಷಲ್ ನಮಗೂ ಇವ್ರ ಹೆಸರು ಕೊಟ್ಟಿಲ್ಲ.
27/6 you make some payment in respect of 22 also or 22 also and also the appellant number 2. Then we will see. The payment ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನಾನು ಕಂಟಿನ್ಯೂ ಮಾಡಲ್ಲ, ಮುಂದಕ್ಕೆ ಹೋಗ್ತದೆ. ನೋಡಿ.
For dismissal 72, Manjunath Prasad Re.
Non-compliance of office objection, cost of rupees 1000. ಕೊಟ್ಟಿದ್ದೀರಾ? ಬಂದೇ ಇರಲಿಲ್ವಾ? Appellant counsel is absent and also not paid the cost as ordered by this court on 9/6/25. And also the order dated 9/6/25 is very clear that if the objections are not complied and cost not paid, list the matter for dismissal, and in spite of listed this matter for dismissal, not paid the cost and not complied the office objections, and hence appeal is dismissed.
73 urgent 74, P.A. Kulkarni.
ಇದೇನ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಆಗಿದೆಯಲ್ಲ?
That 3 persons were claiming succession. The last occasion when I argued before lordships, ಅದರಲ್ಲಿ DNA ಟೆಸ್ಟ್ ಮಾಡಿ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಆ DNA ಟೆಸ್ಟ್ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅವರು. So that therefore I am before your lordship. On the last occasion your lordship directed the other side.
heard in part, list the matter on 18/6/25. ಏನ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದೆ?
ಇಲ್ಲಿ ಅವ್ರಿಗೆ ಏನಂತ ಹೇಳಿದ್ರಿ ಅಂದ್ರೆ ಇದು he was in service, KPTCL, while in service he died. ಸೊ ಅವನ್ ಬೆನಿಫಿಟ್ಸ್ ನಲ್ಲಿ ಒಬ್ರು
ಇದನ್ನ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ,
ಕಂಪ್ಯಾಷನೇಟ್ ಅದನ್ನ ಇವ್ರಿಗೆ ಹಂಚ್ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಅದ್ರ ಬಗ್ಗೆ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದವ್ರು ಇವತ್ತು ಬಂದಿಲ್ಲ ನೋಡಿ.
ಬರ್ಲಿಲ್ವ ಕೌನ್ಸಿಲ್? ಇನ್ನು ಬೇರೆ ಒಕ್ಕಲ ತಕ್ಕವ್ರ ಮಹೇಂದ್ರ
ಪ್ರತಿ ಸಲ ಇದು
R1
ಐ ಥಿಂಕ್
NOC ಇದೆಯಾ ನೋಡಿ.
ಸಿಕ್ಸ್ತ್ ಟೈಮ್ ಆರ್ ಬೆಂಚ್ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
ಒಕ್ಕಲ ತಕ್ಕಿದ್ರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದವ್ರು ಯಾರು? ಸೋಮಶೇಖರ್ KM ಅಥವಾ ಮಹೇಂದ್ರ ಜಿನ ಬಂದವರು?
ಯಾರೋ ಒಬ್ರು ಹುಡುಗ ಬಂದಿದ್ರು, ಅವರು ಹೊಸದಾಗಿ ಬಂದಿದ್ರು ಅವರು.
3/6/25 ಅಲ್ಲಿ ಈಗ ಒಕ್ಕಲತ್ ನೋಡಿ, ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡೋಣ. ಹೆಸರು ಸೋಮಶೇಖರ ತೊಗೊಳ್ಳಿ. Appellant counsel is present. Counsel for respondent is absent. Cause list discloses 2 advocates for R1 and R2. And it appears counsel Sri Mahendra G has filed wakalat for R1 and R2 with NOC from Somashekar KM. Hence, registry is directed to delete the name of Somashekara KM for R1 and R2. List this matter on 27/6. ಎರಡರಲ್ಲ ಅದೇನೆ ಸೇಮ್ ಕ್ಲಬ್ ಆದ್ಮೇಲೆ ಸಪರೇಟ್ ಆರ್ಡರ್ ಬೇಕಾಗಿತ್ತು. 75
ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿ ಬಿ.
ಇದು MSA ನಾ? ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿ ಇಬ್ರು ಇಲ್ಲೇನ್ರಿ? both counsels are absent. List this matter on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 37
76 urgent
77 Rigo. Depositions and exhibits.
The petitioner,
exhibit mark.
Petitions for probate, my lord.
Kept in safe custody. ಹೇಳಿ.
Please, my lord. Petitions to grant of probate, my lord, respect to the last will and testament.
Notice to Gopala Krishna held sufficient.
Yes. It's a final hearing, my lord. The petition one for probate, my lord, in respect of the last will and testament, dated 2/5/2017. 2017, my lord. Of one lady by name Rangamma. The will is a registered will, my lord. Now the petitioner, my lord, is the executor appointed under the will.
Executor.
Yes, my lord. One Ramesh TG is the executor, my lord. Now the testatrix, my lord, expired on 27/6/2019. And I've produced the death certificate at exhibit P1, my lord. The original will is marked as exhibit
certificate of Rangamma.
Rangamma, Lord. On exhibit P1, and the will is marked as exhibit P2, my lord.
Exhibit P2.
Now, my lord, the will had two attesting witnesses, one MN Nagesh and one B Krishnamurthy, who was an advocate. B Krishnamurthy had expired, so MN Nagesh was examined as a witness, my lord, PW2, my lord. He has filed his deposition, my lord. He is examined as PW2, and he has identified the signatures of the witnesses and the testatrix, my lord. Now, further to the filing of the petition, my lord, paper publication was taken in the Hindu and Kannada Prabha newspapers on 13/10/2024, my lord. Thereafter, none of the objectors have come forward. But, my lord, the coordinate bench of this court felt that since the lady had a son by name, an adoptive son by name Krishna, notice was also sent to him, my lord. It was served, he has not come forward, my lord. So, based on this, my lord, the other formalities have been complied with. No objectors have come forward to object the grant of probate. And there is no obstacle for grant of probate, my lord.
You have already complied.
Please, my lord.
Kodi, madam, kodi. Records kodi. Depositions ಎಲ್ಲ ಸೇಫ್ ಕಸ್ಟಡಿ ಇದೆಯಾ? ಹಾಗಾದ್ರೆ ಹಾಕ್ಬಿಡಿ. ಹರ್ಡ್ ರಿಸರ್ವ್ಡ್ ಸೇಫ್ ಕಸ್ಟಡಿ ತರಿಸ್ಬಿಟ್ಟು ನಮ್ಮ ಜೊತೆ ನಮಗೆ ಕೊಡಿ. Registry is directed to get the court officer is directed to get the ಆರ್ಡರ್ ಬೇಕಾ? ಬೇಡ, ಆಯ್ತು.
78
GS ಶ್ರೀಕಂಠೇಗೌಡ ನರಸಿಂಹಮೂರ್ತಿ
ಜಿವಿ.
Read In this case, it is the plaintiff's second appeal.
Hmm.
Plaintiff filed this suit for partition,
Hmm.
relying upon a will dated 24/2/2006,
Hmm.
executed by mother
Hmm.
in favor of plaintiff and defendants
Hmm.
to an extent of half share each.
Hmm.
But, prior to this,
Hmm.
the defendants herein,
Hmm.
they filed a suit in OS 184 of 2006,
Hmm.
claiming that mother has executed a will dated 14/11/2005,
14?
14/11/2005,
Hmm.
bequeathing entire suit schedule properties
Hmm.
in favor of the first defendant only.
Hmm.
That suit came to be dismissed by the trial court.
Hmm.
On 22/2/2008, and against that, RA number 38 of 2008 was filed by the defendant, and that suit came to be decreed on 26/2000.
RA is decreed.
RA decreed. Against that, the present appellants filed RSA 1851 of 2008. That suit came to be, the appeal came to be allowed on 16/11/2011. And against this, 16/11/2011. Again,
RSA 1851 na?
1851 of 2008.
2008.
2008. Against that, the defendant here in filed SLP. That SLP was allowed on the ground that substantial question was not formulated by the High Court, and it was remanded to reconsider. Thereafter, this honorable court, after considering framing the substantial question, and heard both the sides, and by its judgment and decree dated 12/12/2019, allowed the appeal and set aside the judgment and decree made by the appellate court in favor of first defendant. Now, on the recent information, after a dismissal after allowing of the second appeal, dismissing their suit, they preferred SLP after a period of 4.5 years. Before and a notice has been issued in that case, and it is pending for consideration. And the plaintiffs herein, they filed this suit in 2012 on the basis of a will executed by mother on 24/2/2006, bequeathing properties in the name of each. Apart from these two persons, 3 daughters are also there. And as the will was executed by mother in favor of these two persons, the daughters were not made as parties to the proceedings. And a suit was filed claiming partition, saying that as per the will, they are in joint position prior to this. As per will, both of them are entitled for half share each. And requested the court to decide the same and decree the half share to the in favor of plaintiff and half share to the defendant. But so far as this property is concerned, whether it is the property belonging to Venkata mother, that fact is not even denied by the other side. They also admits that fact. So in the previous suit, they says that it is the mother's property, and the mother executed solely will in her favor. Even in this case, a written statement was filed. There also they admits. And in the pleadings, what that has been drafted by in favor of plaintiff, it is stated that because mother, after death of mother.
Now the issue is with regard to, there are two wills.
Yes.
One with will is concerned, already matter is pending before the Supreme Court.
Supreme Court.
In case if we decide this RSA, in case judgment of the Supreme Court comes otherwise,
that's why
it's very difficult, alva. ಅವಾಗ ಆ SLP ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆನೆ ಮತ್ತೆ
ಹಂಗೆ
ಈ RSA ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು.
ಹೌದು, ಅದಕ್ಕೆ ತಮ್ಮ ಗಮನಕ್ಕೆ ಇಡುತ್ತೆ. ಅದು 4.5 ವರ್ಷ ಡಿಲೇ ಇತ್ತು, ಅದಕ್ಕೋಸ್ಕರ
ನಾವು ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿ ಮಾಡ್ಬೇಕು
ಆಯ್ತು
ಅಲ್ವಾ ಏನ್ರಿ? ಯಾಕೆಂದ್ರೆ ಒಂದ್ ವಿಲ್ ಪ್ರಕಾರ ಒಬ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು, ಇನ್ನೊಂದ್ ವಿಲ್ ಪ್ರಕಾರ ಇಬ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು. ಈಗ ಒಬ್ರಿಗೆ ಕೊಟ್ಟಿರೋ ವಿಲ್ ಅಪೆಲ್ಡ್ ಆಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆದ್ರೆ these appellants are nowhere.
And my lordship, in the status quo also is order passed by the apex court.
Apex court status quo ಮಾಡಿದಾರಾ?
ಮಾಡಿದಾರೆ.
ಮತ್ತೆ ಆಯ್ತು, ಇಬ್ರು ಅಲ್ಲಿ ಇತ್ಯರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ ಫಸ್ಟ್ ಅಲ್ವಾ? ತೋಡಿ the heard the appellant counsel and also the counsel for the respondent, and both not disputes, and both not disputes that SLP is pending before the appellate court in respect of the will dated 14/11/2005, and this RSA arising out of another will dated 24/2/2006, and unless the decision is taken in respect of the earlier will 14/11/25, the question of deciding this RSA doesn't arise, and hence list this matter after the disposal of SLP number ಏನಾದ್ರು ಇದೆಯಾ?
ಎಸ್ ಮಿಲರ್, ಇದರಲ್ಲಿ ಡೈರಿ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡೈರಿ ನಂಬರ್
23211.
ಅಲ್ಲ, ಈಗ ಒಂದ್ಸರಿ ಕೋರ್ಟ್ ಮುಂದ್ ಬಂದು ನೋಟಿಸ್ ಎಲ್ಲ ಆಯ್ತು ಅಂತಂದ್ರೆ ನಂಬರ್ ಆಗಿರುತ್ತಲ್ಲ SLP.
ಅದೇ ಇದರಲ್ಲಿ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ.
ಹೌದಾ, ಆಯ್ತು. ಡೈರಿ ನಂಬರ್
23211.
211 of 2024.
Up 24 up 24 ಅಂತ ಮಾಡಿ.
ಮಚ್
ನೋಟ್ಸ್ ಅಲ್ಲಿ ಇಡಿ, ಮುಂದೆ ನಾನು ನಮ್ಮ ಮುಂದೆ ಬಂದ್ರೆ.
79 ಮಹೇಶ್
ಕಿರಣ್ ಶೆಟ್ಟಿ.
ಫೈಲ್ ಸ್ವಲ್ಪ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ, ಅದು ಬೆಳಿಗ್ಗೆ ಸಿಕ್ತು, ಮಂಗಳವಾರ ಮಾಡ್ತೇನೆ.
ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಅವ್ರು ಸರ್ವ್ ಆಗಿದೆ, ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್.
Appellant counsel seeks time on the ground that file is misplaced. List this matter on 3/7.
May I request for interim order extension?
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order granted earlier is extended till next date of hearing.
Oblige.
ಇಲ್ವಾ? ಏನೋ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತಾರೆ ಹಿಂದೆ.
ಒಂದು ಡೇಟ್ ಅಲ್ಲಿ, ಅಂದ್ರೆ ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಅಲ್ಲಿ
ಒನ್ ಡೇಟ್ ಮಾತ್ರನಾ?
ಒನ್ ಡೇಟ್, ಅದು ರೀಚ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಒನ್ ಡೇಟ್ ಆರು ಓಕೆ. ನೆಕ್ಸ್ಟ್
80
ವರುಣ್ ಪಾಪಿ ರೆಡ್ಡಿ, PK ಚಂದ್ರಶೇಖರ್, MG ರವೀಶಾ for R2 and R4.
I appeal for the
Shekar for R2 and R4. ಹೇಳಿ.
This appeal is by the plaintiffs.
Plaintiffs appeal?
Yes, my lord. Suit is for partition and separate possession of 1/8 share each in all the suit scheduled properties. Suit properties consist of 14 items of landed properties. 14 items. And one house property and a fixed deposit of rupees 10,74,495. These are the subject matter of the suit. 10,74,495.
495
kept in a fixed deposit in the State Bank of Mysore.
FD ಅಲ್ಲಿ.
FD. The suit was dismissed. And appeal also confirmed the judgment and decree of the trial court. Lord, in the contesting defendants, Lord, the propositors had 6 sons and 2 daughters. 4 sons and 2 daughters have filed the suit.
Already there was a oral partition anta.
They plead a oral partition.
The absence of any documentary evidence to prove the factum of oral partition, and the parties have acted upon the same.
If that oral partition is substantiated, I have no case. In this case, the plea was taken that oral partition had taken place 25 years earlier to the filing of the suit. But I have produced the revenue records. All the revenue entries have been changed in respect of the landed properties based on inheritance. That too, a collective statement of 5 sons and the mother was recorded and the imitation was effected. I have produced the
ಅದು ಯಾವ yearly?
Exhibit P8 is the
Exhibit P8
P8 is the mutation extract.
All the sons and mother.
Yes, my lord. 5 sons and mother.
ಯಾರ ಹೆಸರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತಿದ್ದು?
That is Tattappa alias Tattaya.
ಯಾರವರು
That
ದಟ್ಟಪ್ಪ
is
ಅಂದ್ರೆ?
he was the eldest son of Chelvegowda. Chelvegowda was the propositus. He had 6 sons and 2 daughters. 4 sons and 2 daughters have filed the suit. The LRs of Tattappa, the eldest son of Chelvegowda, had contested the suit. They took the plea of prior partition, that to oral partition. But that oral partition was not reflected anywhere in the revenue records at all. No legal and convincing evidence was placed before the trial court, proving that issue number 2. A specific issue was also framed by the trial court on the plea of oral partition. The finding of the trial court on issue number 2 is in favor of the contesting defendants. That finding is perverse. I have also produced the revenue records exhibit P12, P13, P14, P15 and 16 relating to
P12,
P13, P14, P15,
D15,
P15,
P15
and P16 are the RTC extracts in respect of 4 survey numbers 1/3, 1/1, 18/6 and 18/26. But out of the suit properties, survey number 61 and 3/1, totally measuring more than 10 acres, are the ancestral properties. The joint family had also another 17 acres, 34 guntas. That 17 acres, 34 guntas in survey number 21 was acquired for the dam.
Acquired by?
Acquired for the dam, my lord.
Oh,
For
dam.
Now, that was also a part of the giant family. It was ancestral property. Now it is not available. Apart from that, survey number 61, 7 acres, 31 guntas, survey number 3/1, measuring 2 acres, 22 guntas. Exhibit P2 and P3 are the RTC extracts.
Survey number 61, 7 acres,
7 acres, 31 guntas, my lord. Survey number 3/1, 2 acres, 22 guntas. With 200 coconut trees and 200 areca nut trees. These are admittedly ancestral properties. RTC extract exhibit P2 and P3 in respect of these 2 survey numbers I have produced. In the revenue entries, blood has been made in the name of Tattappa based on inheritance. Therefore, in the absence of establishing or proving the earlier partition, the case of the plaintiff should have been accepted. But one more plea, oral plea was raised in the trial court, saying that suit was only for partial partition, and the property which is standing in the name of the first plaintiff, which is in Bangalore, was not included. But admittedly, first plaintiff was in service, government service. He had acquired one house property in Bangalore. That was not included. It was his self-acquired property. So a plea was also not taken in the written statement, saying that it is also a part of the joint estate, and it should have been included, and suit for partial partition is not maintainable. That plea was not taken. Only during the arguments that plea was submitted, and the trial court accepted that and held that suit is not maintainable for partial partition.
Trial court.
Yes, my lord. These two, mainly these two grounds, not the claim of, legitimate claim of the plaintiffs was declined. Material documents have been ignored.
Then according to you, two grounds. One is for not included the property of the plaintiff number one.
Yes. Another is.
Other ground is
This
oral partition.
Oral partition. These two things were not proved or pleaded. This oral partition was pleaded, but no evidence was adduced, and the finding given on issue number 2 is perverse. Suit item number 4 is a fixed deposit amount. Still, it is in the bank. Suit item numbers 3, 5, 6, 7, 13 and 16. These 6 items were acquired in the name of Tattaya. Lord, just the government had acquired 30 acres, 17 acres, 34 guntas. Considering the acquisition of Jain family property, Lord, 2 items of land were granted in favor of Tattaya. That is suit item number 14 and suit item number 15.
Acquisition ಯಾವ year ಅಲ್ಲಿ?
Lord, that year is not mentioned in the. But these.
But that is relevant alva?
Yes, Lord.
Subsequent purchase ಆಗಿದ್ರೆ.
Not purchase. It was granted.
Tattaya ಹೆಸರಲ್ಲಿ ಕೊಂಡ್ಕೊಂಡವ್ರೆ ಅಂದ್ರಲ್ಲ ನೀವೀಗ.
It was the other 4 items were purchased. But family had Lord, nucleus. Ancestral properties were there, and garden lands are there, and giant family had resourceful sources. Therefore, out of the giant family income, those properties were acquired. And agriculture was the only source for the giant family.
No other source.
No other source. But they plead, Lord, in the evidence they have given, that he was doing some business. No material is placed to show that he was doing other business and he had an independent source of income. Admittedly, 12 acres, 19 guntas, Lord, in survey numbers 61 and 60/2, they are ancestral properties. Exhibit P8 is the document. Relationship is admitted, my lord. There is no dispute regarding the relationship. The defendant number 4, 5, 6 had jointly filed the written statement. Defendant 7 filed a separate written statement, but they are the contesting defendants, my lord. They took the plea of earlier partition, but they have not established and substantiated.
Whether the trial court given finding with regard to any issue of property belongs to the family or any self-acquired property, like that, any finding is given?
Lord, saying
because
that,
you are claiming that some of the properties are purchased in the name of the Tappa.
Earlier partition was held against the plaintiff, and their properties which are standing in the name of the Karta were held as self-acquired properties, and
that is the
plaintiffs.
finding.
Yes, my lord. Plaintiffs are not entitled for.
Before purchasing the property, there was a oral partition.
Yes, 25 years earlier to it. The issues are at page number 59.
ಪೇಪರ್ ಬುಕ್ ಇದೆಯಾ ಮೇಡಮ್? ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಾ?
The first issue is ದಾವಾ ಸ್ವತ್ತುಗಳು ಒಟ್ಟು ಕುಟುಂಬದ ಅವಿಭಾಜ್ಯತ ಸ್ವತ್ತುಗಳು ಎಂದು ವಾದ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ವಾದಿಯರು ರುಜುವಾತುಪಡಿಸುವರೆ. Second issue is ಪ್ರತಿವಾದ ಪತ್ರದ ಖಂಡಿಕೆ 12ರಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ
1 and 2.
1 and 2, they are the main things, my lord. Now issue number 2 has been held in against the plaintiffs.
Only finding that there was already a partition, partition and hence not entitled for the share.
Yes, my lord. No evidence, my lord. No evidence. Therefore, that finding is false.
Finding from para number 18 to 23.
18 to?
18 to 23 para number. The finding given by the trial court.
Para 18 is regarding that properties belonging to the family members are not included. That plea itself was not raised in the written state.
Plea ilva?
There is no plea.
You defense ತಗೊಂಡಿದ್ದೀರಾ?
Defense was taken in the form of earlier partition. We are already separated and separated dealing.
Not inclusion of the property in respect of exhibit D1. Was there any pleading?
Only exhibit D1, my lord, more than 12 items. They have sold independently, they have purchased independently, everything is there. So my foundational ground is, there was earlier partition. Subsequent to partition, they have deal the independent affairs and business with respect to their property. That has been.
ನಿಮ್ಮ ಪ್ರಕಾರ oral partition ಪ್ರಕಾರ ಯಾರ್ಯಾರಿಗೆ ಏನೇನ್ ಆಸ್ತಿ ಕೊಟ್ರಿ?
Yes, that as per the oral partition in the two.
ನಿಮ್ದು ಅಷ್ಟೇ ಅಲ್ಲ? ನಿಮ್ದು ಏನಾದ್ರು ಹೇಳೋದಿದ್ರೆ ಇನ್ನು ಕೇಳ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಕಡೆಗೆ ಹೋಗ್ತೀನಿ ಅದಕ್ಕೆ.
Deposition I have to point out. After their submissions I will point out.
ಈಗ ಹೇಳಿದ್ರೆ ನೀವು ಅವ್ರ ಮೀಟ್ ಮಾಡ್ತಾರ ಅವರು.
Yes.
ಆಮೇಲೆ ನೀವು ಉಳಿಸ್ಕೊಂಡಿದ್ದೀನಿ ಅವ್ರು ಮತ್ತೆ ಮೀಟ್ ಮಾಡಕ್ ನಾನು ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು. ಏನ್ ಬಿಡಿ ಹೇಳಿ. ಡಿಪೋಸಿಷನ್ ಏನು?
DW1. DW1, evidence of DW1.
DW1.
Yes. Defendant number 4 was examined himself as DW1.
DW1.
In his cross-examination, recorded on 14/11/2018.
ನಾನು ಹಿಂಗೆ ಸೇರಿಸ್ಕೊಂಡು ಹೋದದ? ಫೋರ್ 5 ಎಲ್ಲ ಹಂಗೆ ಇದೆ. ತೆಗೆದು ಉಲ್ಟಾನೆ ಹಾಕ್ಬಿಡ್ತೀವಿ. ಕಟ್ ಮಾಡಿ ಇದು ಚೀಫ್ ಕ್ರಾಸ್ ಎಲ್ಲ ಉಲ್ಟಾ ಇದೆ. ಯಾರು ಹೊಲದ್ ಕಳ್ಸೋದು ಇದು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರ ಅಥವಾ ನಮ್ಮವ್ರ ಹೊಲೆ ಅದು? ಇಲ್ಲಿ ಪೇಜ್ ಹೆಂಗ್ ಮಾಡ್ತಾರ್ರಿ? ಪೇಜ್ 47 ಅಂತ ಇಲ್ಲಿ ಊಟನ ಹಾಕೋಣ. ಏನ್ ಮೋಸ್ಟ್ಲಿ ತೆಗೆದು ಹೊಲ್ದಾನ ಏನೋ ಮಾಡ್ದಂಗಿದೆ ನೋಡಿ. ತೆಗಿಬೇಕು. ಇಲ್ಲ ಡಿಪೋಸಿಷನ್ ಮಾತ್ರ ತೆಗೀರಿ. ತೆಗೀರಿ ನೋಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ. 14 ಹೆಂಗ್ ಗೊತ್ತದ ಮೇಡಮ್? ಒಂದೊಂದು ಪೇಜ್ ಒಂದೊಂದು ಇರಲ್ಲ ಇದೆ. ಈ ಕೇಸಿನ ಅರ್ಜಿದಾರ ಆಗಿದ್ದು ನಾನು ಮುಖ್ಯ ವಿಚಾರಣೆ ಪ್ರಮಾಣ ಪತ್ರಕ್ಕೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಆಯ್ತು. ಮುಂದುವರೆದ ಕಾಲಾವಕಾಶ 3 ದಿವಸ ಆಯ್ತು. ಹೇಳಿ ಕ್ರಾಸ್ ಅಲ್ಲಿ.
Yes, cross examination recorded on 14/11/2018. ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆದಿರೋ ವಿಚಾರಗಳು ನನಗೆ ಗೊತ್ತು. ನಾನು ಹೇಳಿದಂತೆ ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯನ್ನು ತಯಾರಿಸಿದ್ದರು. ನನ್ನ ಸಾಕ್ಷಿಯನ್ನು ನನ್ನ ಹಾಗೂ 5ನೇ ಪ್ರತಿವಾದಿ ಪರ ನುಡಿಯುತ್ತಿದ್ದೇನೆ. ನನ್ನ ಮತ್ತು ವಾದಿ ಪ್ರತಿವಾದಿಗಳ ಮಧ್ಯೆ ಅನ್ಯೋನ್ಯತೆ ಇದೆ ಅಂದರೆ ಸರಿ. ನನ್ನ ತಾತ ಹೆಸರು ಚೆಲುವೇಗೌಡ. ನನ್ನ ತಾತ ಬದುಕಿದ್ದಾಗ ಅವರೇ ನಮ್ಮ ಕುಟುಂಬದ ಕರ್ತ ಆಗಿದ್ದರು ಅಂದರೆ ಸರಿ. ಫರ್ದರ್ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ನನ್ನ ತಾತ ತೀರಿಕೊಂಡ ನಂತರ ನನ್ನ ತಂದೆ ನಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ಕರ್ತ ಆಗಿ ಯಜಮಾನಿಕೆ ಮಾಡುತ್ತಿದ್ದರು ಅಂದರೆ ಸರಿಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಕೈಂಡ್ಲಿ ಸಿ. ನನ್ನ ತಾತ ತೀರಿಕೊಂಡ ನಂತರ ನನ್ನ ತಂದೆಯವರೇ ಒಟ್ಟು ಕುಟುಂಬದ ಎಲ್ಲಾ ವ್ಯವಹಾರಗಳನ್ನು ನೋಡುತ್ತಿದ್ದರು ಅಂದರೆ ಸರಿ. There was no partition, therefore he was looking after the family. ದಾವಾ ಸತ್ತು ಭಾಗಾಂಶ ಕೋರಿ ಸಲ್ಲಿಸಿದ್ದು ಅದು ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ ಎಂದು ಹೇಳಿದ್ದು ಅದು ಸರಿ ಅಂದರೆ ಸಾಕ್ಷಿ ಅದು ಸರಿಯಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನನ್ನ ತಾತ ತೀರಿಕೊಂಡ ನಂತರ ಅವರ ಹೆಸರಿನಲ್ಲಿರುವ ಎಲ್ಲಾ ಆಸ್ತಿಗಳು ನನ್ನ ತಂದೆಯ ಹೆಸರಿಗೆ ಬಂದಿತ್ತು ಅಂದರೆ ಸರಿ. ದಟ್ ಈಸ್ ಬೈ ಇನ್ಹೆರಿಟೆನ್ಸ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್, ಫಸ್ಟ್ ಲೈನ್. ದಾವಾ ಸೊತ್ತುಗಳು. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ದಾವಾ ಸೊತ್ತುಗಳು ನಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಸೊತ್ತು ಅಂದರೆ ಸಾಕ್ಷಿ ಎಲ್ಲಾ ಆಸ್ತಿ ಪಿತ್ರಾರ್ಜಿತ ಸೊತ್ತು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸರ್ವೆ
ಎಂದು ಹೇಳುತ್ತಾರೆ.
ಸರ್ವೆ ನಂಬರ್ 60, ಸರ್ವೆ ನಂಬರ್ 33/1, ಸರ್ವೆ ನಂಬರ್ 24/6 ಹಾಗೂ ಸೈಟ್ ನಂಬರ್ 8 ನನ್ನ ತಂದೆಯ ಸ್ವಾರ್ಜಿತ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ. ನಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಗಳು ಒಟ್ಟು ಎಷ್ಟು ಎಕರೆ ಇತ್ತು ಎಂದು ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನನ್ನ ತಂದೆಯ ಸ್ವಾರ್ಜಿತ ಆಸ್ತಿಗಳು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ ಮತ್ತು ಚೆಕ್ ಬಂದಿ ಅನ್ನು ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. 1ನೇ ವಾದಿ ಅವರು ಪೊಲೀಸ್ ಕರ್ತವ್ಯದಲ್ಲಿದ್ದರು ಅಂದರೆ ಸರಿ. 1ನೇ ವಾದಿ ಅವರು ನಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ವ್ಯವಹಾರ ನೋಡುತ್ತಿದ್ದರು ಅಂದರೆ ಸರಿಯಲ್ಲ. 4ನೇ ವಾದಿ 30 ವರ್ಷಗಳ ಮುಂದೆಗೆ ಆಗಿದ್ದು ಅವರ ಮದುವೆ ಕಾರ್ಯಕ್ಕೆ ಒಡವೆಗಳನ್ನು ಕೊಟ್ಟಿದ್ದರು ಅಂದರೆ ಸರಿಯಲ್ಲ. 5ನೇ ವಾದಿ ಅವರು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. 5ನೇ ವಾದಿ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕು ಮೆಜೆಸ್ಟಿಕ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಾರೆ. ಅವರು ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲು ಹಾಜರುಪಡಿಸಬಹುದು. ತಾತಯ್ಯನವರು ಕಾಂಟ್ರಾಕ್ಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಹಾಗೂ ಅವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರೆಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ತಾತಯ್ಯರವರು ಕಾಂಟ್ರಾಕ್ಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಅವರು ಯಾವುದೇ ಲೈಸೆನ್ಸ್ ಅನ್ನು ಮಾಡಿಲ್ಲ. ತಾತಯ್ಯರವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಕಚೇರಿಯನ್ನು ಇಟ್ಟುಕೊಂಡಿದ್ದರು. ಸದರಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ನ ಹೆಸರು ಗಣೇಶ್ ಡೆವಲಪರ್ಸ್ ಆಗಿತ್ತು. ಸದರಿ ವ್ಯವಹಾರವನ್ನು ಸುಮಾರು 10 ವರ್ಷಗಳಿಂದ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ತಂದೆಯವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರೆಂದು ತೋರಿಸಲು ಈಗ ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಲು ಆಗುವುದಿಲ್ಲ. ನನ್ನ ತಂದೆಯವರು 3ನೇ ವ್ಯಕ್ತಿಗಳಿಗೆ ಆಸ್ತಿ ಮಾರಾಟ ಮಾಡಿ ಖರೀದಿಸುತ್ತಿರೆಂದು ತೋರಿಸಲು ಈಗ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಲು ಆಗುವುದಿಲ್ಲ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿದಂತೆ ನಮ್ಮ ಕುಟುಂಬದಲ್ಲಿ ವೈಯಕ್ತಿಕವಾಗಿ ಯಾವುದೇ ವಿಭಾಗ ಆಗಿಲ್ಲ. Further, my lord, cross examination recorded on 29/11/2018. ನನ್ನ ತಂದೆಯವರು ವರದೇನಹಳ್ಳಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ವ್ಯವಹಾರವನ್ನು ಮಾಡುತ್ತಿದ್ದರು. ರಿಯಲ್ ಎಸ್ಟೇಟ್ ನಡೆಸುತ್ತಿದ್ದವರ ಕಚೇರಿಯ ಕಟ್ಟಡದ ಮಾಲೀಕರು ಯಾರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ತಂದೆಯವರು ಗಣೇಶ್ ಡೆವಲಪರ್ಸ್ ಅಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವಾಗ ಬೇರೆ ಕಾಂಟ್ರಾಕ್ಟು ಅವರ ಜೊತೆಗೆ ಜಾಯಿಂಟ್ ಖಾತೆ ತಯಾರಿಸಿದ್ದಾರೋ ಇಲ್ಲವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ತಂದೆಯವರು ಅವರು ತೀರಿಕೊಳ್ಳುವ 10 ವರ್ಷಗಳ ಹಿಂದಿನಿಂದ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮಾಡುತ್ತಿದ್ದು ಮತ್ತು ಅದರಲ್ಲಿ ಆದಾಯ ಬರುತ್ತಿತ್ತು ಎಂದು ತೋರಿಸಲು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನನ್ನ ತಂದೆ ಬದುಕಿದ್ದಾಗ ನನ್ನ ಚಿಕ್ಕಪ್ಪಂದಿರು ಅವರ ಆದಾಯಗಳನ್ನು ನನ್ನ ತಂದೆಗೆ ಕೊಡುತ್ತಿದ್ದರು ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಗಳು ವೀರಾಪುರ ಮತ್ತು ಅಡಕಮಾರನಹಳ್ಳಿಯಲ್ಲಿದೆ ಅಂದರೆ ಸರಿ. ದಿ ಸೇಮ್ ಪೇಜ್ ಲಾಸ್ಟ್ 4 lines. I will read the last para. 6ನೇ ವಾದಿ ನಮ್ಮ ಜೊತೆಗೆ ಸುಮಾರು 10 ವರ್ಷಗಳಿಂದ ವಾಸ ಮಾಡುತ್ತಿಲ್ಲ. ಅಂದರೆ ನನ್ನ ತಂದೆ ತೀರಿಕೊಂಡು 2 ವರ್ಷಗಳ ಹಿಂದಿನಿಂದ ಅವರು ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿಲ್ಲ. 6ನೇ ವಾದಿ ಈಗ ಬೆಂಗಳೂರಿನಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಅಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಸ್ವತಃ ಹೇಳುತ್ತಾರೆ ಅವರು ಹಿಂದಿನಿಂದ ಬೆಂಗಳೂರಿನಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದಾರೆ. 6ನೇ ವಾದಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದು ಊರಿನಲ್ಲೂ ಸಹ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿದ್ದಾರೆ ಅಂದರೆ ಸರಿ. 1ನೇ ವಾದಿ ಅವರು ಪೊಲೀಸ್ ಇಲಾಖೆಯಲ್ಲಿದ್ದ ಕಾರಣ ಅವರ ಆದಾಯ ಚೆನ್ನಾಗಿದ್ದು ಅವರ ಒಟ್ಟು ಕುಟುಂಬದ ಸದಸ್ಯರನ್ನು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. Next page, my lord. Second paragraph, third paragraph. Third paragraph. ನನ್ನ ತಂದೆಯವರ ಸ್ನೇಹಿತರ ಜೊತೆಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರೆಂದು ನಾನು ಸುಳ್ಳು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಂದೆಯ ಸ್ನೇಹಿತರ ಹೆಸರು ದೆಬ್ಬಗುಳಿ ಶಿವಣ್ಣ. ನನ್ನ ತಂದೆ ಮತ್ತು ದೆಬ್ಬಗುಳಿ ಶಿವಣ್ಣನವರ ಮಧ್ಯೆ ವ್ಯವಹಾರ ಆಗಿದ್ದ ಬಗ್ಗೆ ತೋರಿಸಲು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಮ್ಮ ತಂದೆಯವರು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಮತ್ತು ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಅಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು ಎಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆ ರೀತಿ ಅವರು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ತೋರಿಸಲು ನನ್ನ ಬಳಿ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ನನ್ನ ತಂದೆಯವರು ಹೈಬ್ರಿಡ್ ಹಸುಗಳನ್ನು ಸಾಕಿದ್ದಾರೆಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಂದೆಯವರು ಸುಮಾರು 10 ರಿಂದ 15 ಹೈಬ್ರಿಡ್ ಹಸುಗಳನ್ನು ಸಾಕಿದ್ದರು. ಸದರಿ ಹೈಬ್ರಿಡ್ ಹಸುಗಳನ್ನು ಎಲ್ಲಿಂದ ಮತ್ತು ಯಾರಿಂದ ಖರೀದಿ ಮಾಡಿದ್ದರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ಹೈಬ್ರಿಡ್ ಹಸುಗಳಿಂದ ಪ್ರತಿದಿನ ಸುಮಾರು 100 ಲೀಟರ್ ಹಾಲು ಕರೆಯುತ್ತಿದ್ದವು. ಸದರಿ ಹಾಲನ್ನು ನಾವು ಡೈರಿಗೆ ಹಾಕುತ್ತಿದ್ದೆವು. ಸದರಿ ಹಸುಗಳು ನನ್ನ ತಂದೆಯವರು ಸುಮಾರು 10 ರಿಂದ 15 ವರ್ಷಗಳು ಸಾಕಿದ್ದರು. ಆದ ಕಾರಣ ಸುಮಾರು 10 ರಿಂದ 15 ವರ್ಷ ಕಾಲ ನಾವು ಡೈರಿಗೆ ಹಾಲು ಹಾಕುತ್ತಿದ್ದೆವು ಅಂದರೆ ಸರಿ. ಡೈರಿಗೆ ನಾವು 10 ರಿಂದ 15 ವರ್ಷ ಹಾಲು ಹಾಕುತ್ತಿದ್ದ ಬಗ್ಗೆ ತೋರಿಸಲು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಯಾವುದೇ ದಾಖಲು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ನನ್ನ ತಂದೆ ತೀರಿಕೊಂಡ ನಂತರ 3 ಮತ್ತು 6ನೇ ವಾದಿಗಳು ಅವರ ಮನೆಯ ವ್ಯವಹಾರಗಳನ್ನು ಅವರವರೇ ನೋಡುತ್ತಿದ್ದರು ಅಂದರೆ ಸಾಕ್ಷಿ ಮೊದಲಿನಿಂದಲೂ ಅವರೇ ನೋಡುತ್ತಿದ್ದರು ಎಂದು ಹೇಳುತ್ತಾರೆ. ನಿಶಾನೆ D1 1ನೇ ವಾದಿಯ ಮನೆಯ ಆಸ್ತಿ ಅಂದರೆ ಸರಿ. ಅವರು ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇರುವಾಗ ಅವರ ಸ್ವಂತ ಸಂಪಾದನೆಯಿಂದ ಸದರಿ ಆಸ್ತಿ ಖರೀದಿಸಿದ್ದರು ಅಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ 3ನೇ ವಾದಿ ಮತ್ತು 6ನೇ ವಾದಿ ಮತ್ತು 5ನೇ ಪ್ರತಿವಾದಿ ಗಂಡ ನಾರಾಯಣಪ್ಪ ಅವರ ಮಧ್ಯೆ ಸಂಬಂಧ ಚೆನ್ನಾಗಿರಲಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. 6ನೇ ವಾದಿ ಅವರು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಅವರ ವ್ಯವಹಾರದಿಂದ ಬಂದಿದ್ದ ಹಣದಿಂದ ನಿಶಾನೆ D2 ಮತ್ತು 3ರಲ್ಲಿ ತೋರಿಸಿದ ಆಸ್ತಿಗಳು ಖರೀದಿಸಿದ್ದರು ಅಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪ್ಯಾರಾಗ್ರಾಫ್ 3 ಮಿಲೋಡ್. ಒಟ್ಟು ಕುಟುಂಬದ ಎಲ್ಲಾ ಆಸ್ತಿಗಳನ್ನು ಒಟ್ಟು ಕುಟುಂಬದ ಸದಸ್ಯರ ಒಪ್ಪಿಗೆ ಮೇರೆಗೆ ನನ್ನ ತಂದೆಯ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಸಬೇಕೆಂದು ಹೇಳಿ ನಿಶಾನೆ P8ರಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ 1ರಲ್ಲಿ ತೋರಿಸಿದ ಆಸ್ತಿಗೆ ನಮಗೆ ಯಾರಿಗೆ ಭಾಗ ಬರಲು ಅರ್ಹರಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ D4 ರಿಂದ 7
ಆಲ್ ಆರ್ ಡಿನೈಲ್. ಏನೇ ಅಡ್ಮಿಷನ್ ಇದ್ರೆ ಹೇಳಿ.
No, defendant 7 was examined herself as DW2.
Right,
She had also contested the suit. DW2 deposition.
Any other witness you are relaying evidence?
Yes, my lord. DW2.
DW2. Continue day after tomorrow.
Please.
Heard in part. Further arguments. Nadiddu. 20th. 81 Chandranath Ariga. Prakash Timmanna Hepar.
appellate.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ?
ನಂದೊಂದು 30 to 35 minutes ಅಷ್ಟೇ.
ನಿಮ್ದು?
Lords, I want to make one submission. Last time we made a submission that we want to file cross objection. Today we have filed a fresh RSA, my lords, for respond number 2, 3, 5, 6 and 7. Lords, may I have this matter after 10 days, my lords? It could be taken along with this RSA, my lords.
ಈಗ ಹಂಗ ಆಗ್ತಿರ್ರಿ 21 ಜೊತೆ.
ಅಲ್ಲ ಉಳಿದಿರೋ plaintiff. So it is this appeal is filed by only one of the plaintiff.
One of the plaintiff.
One of the plaintiff. Rest of the plaintiff.
Others now they have.
Now they have filed. In fact, we wanted to file cross objection, then we thought it's appropriate only to file RSA. Today we have filed it. 10 days plus ಅದರಲ್ಲಿ complaints ಮಾಡ್ಕೊ ಬಂದ್ಬಿಡ್ತೀವಿ.
Counsel for respondent seeks time.
I am appearing for respondent number 1, my lord.
One na?
1, my lord.
1B2.
Contesting respondent.
ನಾನು respond number 2, 2, 3 ಉಳಿದಿರೋರಿಗೆ ನಾನು 2 to 7.
2, 3, 7 ah?
2 to 7.
Counsel for R2, R3, R5, R6 and 7 submits that other plaintiffs have also filed RSA. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿರೋದು?
ಇವತ್ತು ಮಾಡಿದ್ವಿ.
Today in the office. And the same is also arising out of the common judgment.
Same judgment and decree.
And hence registry is direct. Number ಗೊತ್ತಿಲ್ಲ ನಮಗೆ ಪುಟ
FR number ಇದೆ. FR number
ಅಲ್ಲಿ ನೋಡಿ and 6 time ಅಂದ್ಬಿಡಿ ಸಾಕು. And 6 time and hence this matter on 3/7 ಗೆ ಹಾಕಿರಿ. ಅಷ್ಟೊಳಗೆ ನಂಬರ್ ಆದ್ರೆ ಅವತ್ತು ಬಂದು ಹೇಳಿ.
Please, please.
ಕಾಪಿನ ಶುರು ಮಾಡಿ ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರೆ ಅವ್ರಲ್ಲ. ಅವ್ರ ತಕರಾರು ಹಾಕಂಗಿದ್ರೆ ಹಾಕಿ. ಈಗಾಗಲೇ ಬೆಳಗ್ಗೆ 12 ಗಂಟೆವರೆಗೂ ಅದೇ ಆಗ್ತಿದೆ. ಈಗ ಆಗ್ತಾ ಇದ್ದೀರಲ್ಲ ಸುಮಾರು 10-15 ಅಲ್ರಿ 25 ಇರುತ್ತೆ. ಮತ್ ಬೆಳಗ್ಗೆ ಎಲ್ಲ ಮತ್ ಮಧ್ಯಾಹ್ನದವರೆಗೆ ಅದೇ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಗೊತ್ತಾಗ. ಅಷ್ಟೊಂದಿದೆಯಾ ಇವು ಹೊಸ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ 21ರಿಂದ 21ರಿಂದ ಇನ್ನೊಂದು 10 ಹಾಕ್ಸಿ ಜಾಸ್ತಿ ನೋಡೋಣ. ಇನ್ಕ್ರೀಸ್ ಅನದರ್ 10 IAS ಕೊಂಡಿದ್ಯಾ ಅಥವಾ ಏನು? ಫಸ್ಟ್ PF ಹಾಕಿ ಅವು ಸೆಪರೇಟ್ ಮಾಡೋಣ. ಇನ್ನೊಂದು 10 ಎಕ್ಸ್ಟ್ರಾ ಆಡ್ ಮಾಡಿ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ ರೋಸ್ಟರ್ ಎಲ್ಲಾರು ಬಂದೋಗ್ಲಿ ಕೋರ್ಟ್.
ಇವಾಗ ಹೋಗೋಣ ತಿರ್ಕೊಂಬರೋಣ. 3 ದಿನದಿಂದ ಏನು ತಿಂದಿದಂತೆ ಹುಚ್ಚು ಅದೇ ಹೇಳಿದ್ದು ಹಣ್ಣು ಅಥವಾ ನೀರ್ ಕುಡಿ ಚೆನ್ನಾಗಿ. 3 ದಿನದಿಂದ ನೀನ್ ತಿಂದಿದ್ರು ಅಪ್ಪ ನಂಗಂತೂ ಆಗಲ್ಲಪ್ಪ. ಅದ್ ಹೆಂಗಿದ್ಯೋ ಏನೋ ನೀನು.